ಫ್ರೆಶ್ ಅಲ್ಲ ಇವ್ರೆ ಅದು ನೋಟಿಸ್ ಅಂದ್ರೆ ಫ್ರೆಶ್ ಅಂದ್ರೆ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಕಂಪ್ಲೈಂಟ್ ಫಸ್ಟ್ ಟೈಮ್ ಪೋಸ್ಟ್ ಆಗಿದ್ದೀರಾ? ಅಲ್ಲ ಇವ್ರೆ ಅದು ನಾನು ಹೇಳೋದು ಎಂಟ್ರಿ ಮಾಡರ್ ಗ್ರಾಂಟೆಡ್ ಅಲ್ವಾ? ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಕಂಪ್ಲೈಂಟ್ ಮಾಡಿದ್ದೀರಾ? ನೋಟಿಸು ಆಗಿಲ್ವಾ? ಹೇಳಿ ಸರ್. ಸರ್ ಅಡ್ಮಿಷನ್ ಮೆಮೋಸ್ ಎಲ್ಲ ಏನು ತಗೋತಾ ಇಲ್ಲ ಮೇಡಮ್. ಸಬ್ಮಿಷನ್ ನಿಮ್ಗೆ ತುಂಬಾ ಎಕ್ಸ್ಟ್ರೀಮ್ ಅರ್ಜೆನ್ಸಿ ಇದೆ ಸಬ್ಮಿಷನ್. ಅಡ್ಮಿಷನ್ ಅಂದ್ರೆ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಅಲ್ಲಿ ಇದೆಯಾ? ನೀವು ಅದನ್ನ ಹೇಳಿ. ಸೆಟ್ಲ್ಮೆಂಟ್ ಅಂತ ಟೈಮ್ ತಗೊಂಡು ನಾಟ್ ಸೆಟಲ್ಡ್ ಅಂತ. ವೆಕೇಟಿಂಗ್ ಸ್ಟೇಟ್ ತಗೋತಾ ಇಲ್ಲ ಇದ್ರೆ ದೇರ್ ಇಸ್ ನೋ ಡೈರೆಕ್ಷನ್ ಫಾರ್ ಮೀ ಟು ಟೇಕ್ ದ ಮೆಮೋಸ್. ಈ ರೋಸ್ಟರ್ ಫುಲ್ ಫಿಲ್ ಆಗಿ ಹೋಗ್ಬಿಟ್ಟಿದೆ. ಆಸ್ ಪರ್ ಸೀನಿಯಾರಿಟಿ ಬರೀತೀನಿ, ಕೊಡಪ್ಪ ನಿನ್ ಸಮಾಧಾನಕ್ಕೆ, ನನಗೇನು ಕೊಡು. ಲಿಸ್ಟ್ ಆಗಿತ್ತು, ರೀಚ್ ಆಗಿದ್ದಲ್ಲೇ ಇದ್ರೆ ನಾವು ಡೇಟ್ ಕೊಟ್ಟಿರ್ತೀವಲ್ಲ. ಯಾವಾಗ ಲಿಸ್ಟ್ ಆಗಿದೆ ಅದು? ಡೇಟ್ ಹೋಗಿರುತ್ತೆ ನೋಡಿ ಇವ್ರೆ. ಆ ಡೇಟ್ ಬನ್ನಿ, ಇಲ್ಲ ಅಂದ್ರೆ ಲಿಸ್ಟ್ ಆಗಲ್ಲ. ಆ ತರ ಇದ್ರೆ ಒನ್ಸ್ ಡೇಟ್ ಅಸೈನ್ಡ್ ಅಂದ್ರೆ ನಾವು ಮತ್ತೆ ಡೇಟ್ ಆರ್ಡರ್ ಮಾಡ್ತಿಲ್ಲ. ಸರ್ ನೋ ಸಬ್ಮಿಷನ್ಸ್ ಅಂತಾರೆ, ನೀವು ಮಾಡಿಪ್ಪ. ನಿಮ್ಮ ಇದನ್ನ ನಾವೇನಕ್ಕೆ ಹೇಳ್ಬೇಕು? ತೊಳಿ ಸರ್. ಹೇಳಿಲ್ವಾ ಸರ್? ಆಲ್ ಮ್ಯಾಟರ್ಸ್ ವೇರ್ CPC ಮ್ಯಾಟರ್ಸ್ ಆದ್ರೆ ಎಲ್ಲ ಮ್ಯಾಟರ್ಲು ಎಂಟ್ರಿ ಹೋಗಿದೆ. ವೆಕೇಟಿಂಗ್ ಸ್ಟೇಗೆ ನಾನು ಹೌ ಮೆನಿ ಮ್ಯಾಟರ್ಸ್ ಕ್ಯಾನ್ ಐ ಟೇಕ್ ಅಂತ ಮೇಡಮ್ ನೀವು ಹೇಳಿ. $482
All memos to the post officer. The Lordships and one matter 230 Milord, yesterday's matter Milord, yesterday they have disconnected the electricity and Milord, all three matters are the same Milord. Yesterday they have disconnected the electricity to the houses Milord. All three matters are one and the same. Yesterday also I moved. Same, actually they have disconnected yesterday evening and therefore I moved a fresh matter Milord for reconnection. All three Milord.
Except 230, no other mentions. All mentions, all memos to the court officer.
My lord, it is.
230.
My lord, there is a
opposite party took the time in saying that there is a
I
settlement.
said all memos to the court officer except 230 matter. All memos to the court
my lord.
officer.
Matter got settled, my lord. The LR application has to be.
Give it to the court officer. Except 230, no other matters to be mentioned.
My lord, there is a direction from the Supreme Court to dispose the matter within 6 months.
Why that you cannot write on your memo? That
I've
the court
written,
cannot, then I will look at it.
No,
Please
tomorrow,
Please give it to her.
on top of the list, my lord, the matter is not able to reach.
I will not hear any mentionings. Please write your urgency on the paper. Give it to the court officer. I will look into it. Except 230, no other matters to be mentioned. Call the list.
Number 1, for preliminary hearing, CL number 1, Kashyap and Naik for petitioner. Mohammed Shamir for respondent.
Yes.
Sorry, ma'am. In list number 2, my lord. List number 2.
No mentionings, no. Yes.
In serial number
When it
39.
reaches, we will see.
That may be taken up at 2:30 because they are doing much galata. It is the final hearings. It is not reaching for the several.
Final hearing, no urgency for final hearing. Yes, call the.
At least to 2:30 make idea.
No. Yes,
List number
ma'am.
2, serial number 39.
Whenever it comes. Yes.
They were the advocate for the petition. This matter was heard briefly last week,
Yes.
arising out of Order 37 of the CPC, Court of CPC Order 37.
All that 37 rules, sir.
Rule 3.
Yes.
Procedure for appearance of defendant, where initially, my lord, in a suit to which this order applies, the plaintiff shall, together with summons under Rule 2, serve on the defendant a copy of the plaint annexures thereto, etc. Within 10 days of such service, defendant is required to enter appearance. Sub-Rule 2, unless otherwise ordered, all summonses will be left at the address given to him for such service. Sub-Rule 3, on the day of entering the appearance, notice of such appearance shall be given by the defendant to the plaintiff's pleader, or if the plaintiff sues in person, to the plaintiff himself, either by notice delivered or sent by prepaid letter. Where the defendant enters an appearance, plaintiff shall thereafter serve on the defendant a summons for judgment in Form 4A in Appendix B. Sub-Rule 5 is what is relevant for the purpose of this matter. Defendant may, at any time within 10 days from the service of such summons for judgment by affidavit or otherwise, disclosing such facts as may be deemed sufficient to entitle him to defend, apply on such summons for leave to defend such suit, and leave to defend may be granted to him unconditionally or upon such terms as may appear to the court or judge to be just. First proviso, provided that leave to defend shall not be refused unless the court is satisfied that the facts disclosed by the defendant do not indicate that he has a substantial defense to raise, or that the defense intended to be put up by the defendant is frivolous or vexatious. Second proviso, provided further that where a part of the amount claimed by the plaintiff is admitted by the defendant to be due to him, leave to defend the suit shall not be granted unless the amount so admitted to be due is deposited by the defendant in court. So there is no automatic right to file a written statement. I have to make out a case that my defense is substantial. In the facts of this case, I'll take your lordship through the impugned order. The court grants categorical findings, renders categorical findings that the defense raised by me is substantial. Page 29, my lord, is the impugned order.
39 is relevant, I think. The other day you were reading paragraph
Yes.
23.
If I may begin from page 48, para 36.
40?
48. Point for consideration framed by the trial court. Whether the applicant defendant has made out a ground so as to allow I number one in the affirmative. And then at para 39 onwards, 39 to 47 are the reasoning and the findings. 39, keeping in mind the above provision of law, I have bestowed my attention to the admitted facts of this case, wherein admittedly, the defendant held mutual discussion with the plaintiff company's representatives and entered into a term sheet dated so of 2019, under which the plaintiff was to directly purchase lands aggregated by the defendant as well as lands owned by the defendant for a consideration of 450 crores. that the plaintiff and defendant also executed term sheet of 2020 under which plaintiff was to purchase another 100 acres of land in so-and-so village for a consideration amount of 150 crores.
No, I'm saying
It's 3256 is the
5-6.
Para 40, it appears both the parties did not proceed with land transaction and thereby the terms of the term sheet were not fructified. As per the case of the defendant, he has spent rupees 50 crores out of his pocket in procuring the lands. However, the plaintiff did not make any effort either purchasing 100 acres of land which were procured by him or 60 acres of land which were in fact standing in the name of the defendant. Plaintiff, having failed to purchase the said lands, has issued termination notice of 2022 illegally and thereby the defendant has sustained huge loss. Per contra, the plaintiff herein contends that the termination of the term sheet by notice dated 22 is valid in the eyes of law. Here the findings come. Para 44. Having regard to the above rival contentions, I am of the firm view that the defendant has raised a valid defense regarding termination of term sheet, and this court is bound to answer whether the plaintiff's purported termination of the term sheet by issuing notice dated so-and-so is valid or is unlawful. Further, in the present case on hand, it is also essential for this court to know whether both the parties have performed their obligations under the term sheet and whether the plaintiff was ready and willing to perform its obligations, and among the parties, who was at fault and failed to perform their obligations in terms of the term sheet. The other substantial defense which is raised by the defendant herein is that he has got every right to forfeit the amount of 5 crores as the plaintiff has violated the terms of the term sheet and as the plaintiff failed to perform his obligations under the term sheet. Having regard to the submissions made by the defendant, I have bestowed my attention to the term sheet wherein admittedly there is no term which entitles the defendant to forfeit the advance amount of 5 crores. When the defendant contends that he has got a right to forfeit the advance amount of 5 crores and that he has further entitled for damages of 50 crores for the alleged loss caused by the plaintiff, I am of the view that the defendant should be given an opportunity to raise his defense by filing written statement along with counterclaim if any. The case of the defendant that he has invested amount from his own pocket and therefore is entitled to forfeit the advance amount of 5 crores. In my opinion, the said assertion of the defendant needs to be tested during the course of trial. Further, in the present case on hand, as per the case of the plaintiff, the defendant, in order to repay 5 crores, has issued a check and the said check got dishonored. In my opinion, if the defendant had right to forfeit the said amount of 5 crores, then what made him to issue check for 5 crores to the plaintiff is an issue which needs to be thrashed during the course of trial. Keeping in view the documents produced by the plaintiff and the averments made by the defendant in application, in my opinion, the defendant has got substantial defense regarding the termination of the term sheet, forfeiture of 5 crores, and the failure on the part of the plaintiff to comply with the terms of the term sheet. Hence, in this case, the defendant should be given an opportunity to file written statement and to lead evidence. The trial court relies on the decision of the Honorable Supreme Court in 2022 BL Kashyap, where on page 5317.1, the court has laid down the principles also. I'll just read that one paragraph, 17.1. As noticed, if the defendant the Supreme Court places all the defenses in 4 buckets. So we're looking at each of the buckets. As noticed, if the defendant satisfies the court that he has a substantial defense, that is a defense which is likely to succeed, he is entitled to unconditional leave to defend. In the second eventuality, where the defendant raises triable issues indicating a fair or bona fide or reasonable defense, albeit not a positively good defense, he would ordinarily be entitled to unconditional leave to defend. In the third eventuality, where the defendant raises triable issues, but it remains doubtful if the defendant is raising the same in good faith or about genuineness of the issues, the trial court is expected to balance the requirements of expeditious disposal of commercial causes on the one hand, and of not shutting out tribal issues by unduly severe orders on the other. Therefore, the trial court may impose conditions both as to time or mode of trial as well as payment into court or furnishing security. In the fourth eventuality, where the proposed defense appears to be plausible but improbable, heightened conditions may be imposed as to the time or mode of trial, as also of payment into court or furnishing security or both, which may extend to the entire principal sum together with just and requisite interest. This is the manner in which 4 buckets are created. First 2 buckets where there is a substantial defense or a reasonable or plausible defense, unconditional leave. Only where the defense appears to be not bona fide or shaky, then conditional. That is what the Supreme Court says. Having considered the law, my lord, at para 51, page 55, in view of para 51, page 55.
Yes.
In view of the ratio of the precedent cited above, it is clear that the court has to consider an application filed by the defendant seeking leave to defend with open mind and shall not prevent the door to the defendant from contesting the case unless the defendant shows that he has substantial defense or raises tribal issues or shows bona fide or reasonable defense. The court has to balance the rights of both the parties evenly and if necessary by imposing conditions regarding time or mode of trial or security. In my opinion, this court, being the court of first instance, has to accord equal opportunity to both the parties to present the case effectively. In this case, now my lords will see the conflict between para 53 and para 54. And that is where I respectfully submit the trial court fell into error. Para 53. In this case, as the defendant has raised substantial defense, the citations relied upon by the plaintiff are not at all applicable to the facts of this case. However, taking note of the decision relied upon by the defendant in IDBI trusteeship services, I am of the opinion that the plaintiff can insist upon the court to direct the defendant to conclude his evidence as early as possible. Para 54. The circumstances of the case show that the defendants raised by the defendant is a possible defense and is not vexatious or frivolous, the adjudication of which requires a trial. If the leave to defend is granted to the defendant with a condition to deposit furnished bank guarantee in respect of the admitted amount of security deposit, no prejudice would be caused to the plaintiff. Hence, the defendant has made out a ground to allow. If I am asked to deposit, no prejudice will be caused to the plaintiff. That I think is a statement in error that seems to have been made by the trial court. Therefore, the order that comes to be passed, my lord, in spite of the finding consistently throughout the order that I have a substantial defense, the court requires me to furnish the entire principal amount of 5 crores by way of deposit as a precondition to filing of written statement. This goes against the law that has been.
Why was the check issued?
We will look at the plaint itself, my lord. The plaint, it is not towards an admitted liability. It was offered as a security check, which is what the plaintiff's case itself is at page 65. And I have two more submissions before my learned film begins on this issue.
65.
65, para 10.
Yes.
Further, as stipulated under the term sheet, the defendant issued an undated check number so-and-so drawn on so-and-so branch for an amount of 5 crores in favor of the plaintiff to secure the refundable deposit security check, a certified copy of the security check. This was not a check offered towards payment of an admitted liability. It was offered as a security check. I am disputing this security was invocable upon termination. I am disputing the termination itself. Therefore, this is not an admission of liability. This was offered as security. That is one. Secondly, the trial court itself has come to a conclusion that the check is offered as security. The check is not offered towards admitted liability, and therefore there is a substantial difference. It will be my learned friend's contention that the check amounts to an admitted liability. If that were to be so, the plaintiff also could have challenged the findings of the trial court. The plaintiff has chosen not to challenge the findings of the trial court. These findings of the trial court have attained finality. So what I would beseech this court to do is examine the findings rendered by the trial court and thereafter if the conclusions are justifiable or not. Grateful.
Lord, I think there are two parts to the order. While the trial judge, Lord, has, or the commercial court judge has said substantial defense, I do not think he meant substantial defense in the manner in which the Supreme Court understood it, because his conclusion is in the final paragraph, where he says he balances both scenarios. If your lordship sees the order, Lord, while he says substantial defense on one occasion, he actually is referring to the contention that it is a substantial defense. If your lordships may kindly see the paragraphs, Lord, in the petition, in the order, please see, my lord, how the learned trial judge proceeds. He first, my lord, at page 48, your lordship will kindly see para 38, extracts order 38, rule 3.5. Now, the payment of 5 crores is an admitted fact. That is not disputed fact. The
5 crores?
The payment of 5 crores is an admitted fact. And that it was paid as a security deposit also is an admitted fact. They don't dispute that fact. That is very critical, because under order 38 rule 5, Lord, there is one exception, and that is where you admit the money and you say, I have received it, now I want to adjust it towards damages. That is his claim. His claim is I want to adjust it towards damages, not that it is not payable, because the term sheet itself is there which says upon termination you are bound to pay the entire amount of money. Therefore, the trial court says you accept the fact that 5 crores you received. Therefore, if it is a case now where they say I have never received the 5 crores, it is different. Which is why the second proviso of order 38 rule 5.3, if your lordships kindly see the proviso, Lord, the second proviso, order 38 rule 3.5, I'm sorry, not 5, order 38 rule, I'm sorry, order 37 rule 3.5, second proviso. Provided further where a part of the amount claimed by the defendant is admitted by the defendant to be due from him, leave to defend the suit shall not be granted unless the amount so admitted to be due is deposited by the defendant in court. Therefore, in this case, the fact that there is a liability to repay the money is only overcome by saying, I want to adjust it towards the losses that are caused to me. Now, my Lord knows that damages cannot be set off against debt. And that I think is an accepted position in law today, that you cannot set off against damages a debt that is due and payable. Now, if your lordships kindly see the document for a minute, I'll just show your lordships the document, which is the term sheet at page 86. At page 89, my lord.
Yes.
Then can I humbly request my lord to kindly come to page 90, the deposit. On execution of this term sheet, my lord got that. On execution of this term sheet, 5 crores shall be paid by GPL to the promoter's refundable deposit, subject to the promoter providing a PDC of equivalent amount simultaneously, which will not be adjusted against outright consideration. Promoter shall refund this refundable deposit at the time of execution of the first transaction documents on said land 2, said land 3, or said land 4, whichever is the earliest. Then please see termination, Lord, at page 89. GPL shall be entitled to terminate the term sheet on occurrence of any of the following events. I won't trouble your lordships on the events, my lord, because we're not on that. Last paragraph, in that itself. In the event of termination, promoter shall within 30 days of such termination refund to GPL term sheet tranche of the outright consideration paid by GPL to owner. In the event of delay in refunding the term sheet tranche of the outright consideration, same shall become bear interest bearing at 24% per annum. Therefore, the fact that it is paid is admitted. The fact that it has to be refunded upon termination also is accepted. The argument is I can adjust it against damages. Therefore, the court, if your lordship sees the order now, why the learned judge, my lord, says, though the word substantial is used in 2 occasions as part of the order, finally at para 54, the court, my lord, answers it in my respectful submission correctly. He says, I have not challenged it, my lord, I understand, I have not challenged it, I am not challenging the findings, but I am always entitled, even if I succeed, to my lord, in a proceeding, say that some finding is incorrect. I'm always under order, even under order 41, my lord, I'm entitled to always, as a losing defendant or a losing party, come back and tell your lordship that a particular finding is incorrect. That I'm entitled to, because it does not upset the final order. Para 54. The circumstances of the case show that the defense raised by the defendant is a possible defense and is not vexatious or frivolous, adjudication of which requires a trial. If leave to defend the suit is granted to defend with a condition to deposit or furnish bank guarantee in respect to the admitted amount of security deposit, which is why the second proviso to Rule 5 comes into play. Therefore, the court says you deposit it. It is not as if, my lord, the money is going anywhere else, not being paid to me. You deposit it in court. I'm granting you leave to defend. If you succeed, my lord, that money will go to him. That is all the court is saying. Therefore, my lord, it is a complete case of exercise of discretion by the learned judge, where the learned judge has seen, of course, the word substantial defense in the order as well, but ultimately says these defenses are a possible defense, and that is all. A possible defense, in my respectful submission, invites the third condition. If your lordship sees that, I won't trouble my lord by reading the judgment, but please see the extract itself, which is there, because both parties relied on the same judgment on BL Kashyap. If my lord sees page 50,
Somehow that's the beauty of some judgments.
it applies to both.
Respondent can rely on.
It applies to both.
Yes.
I'll come to that.
Page number?
Page number 53.
Yes.
And if my lord sees bottom 5 lines, therefore the trial court. There, my lord got that? Therefore, the trial court may impose conditions both as to time and mode of trial, as well as payment into the court of furnishing security. In the fourth eventuality, where the proposed defense appears to be plausible but improbable, heightened conditions may be imposed. Then your lordship may kindly come to 17.2, my lord, on the next page.
Yes.
Thus, it could be seen that in the case of substantial defense, defendant is entitled to unconditional leave. Even in the case of a tribal issue or a fair and reasonable defense, defendant is ordinarily entitled to unconditional leave to defend. In case of doubt about the intent of defendant or genuineness of the tribal issue, as also the probability, leave could not be granted, but while imposing conditions, could yet be granted, but while imposing conditions to time or mode of trial or payment of furnishing security. Thus, even in such cases of doubts or reservations, denial of leave to defend is not the rule, but appropriate conditions may be imposed while granting the leave. It is only in the case where the defendant is found to having a substantial defense and or raising no genuine tribal issues coupled with the court's view, defendant is frivolous or vexatious, leave to defend is to be refused, and the plaintiff is entitled to judgment forthwith. Of course, in the case where any part of the amount claimed by the plaintiff is admitted by the defendant, leave to defend is not to be granted unless the amount so admitted is deposited by the defendant in the court. Now, my lord, what also has happened is they filed a written statement along with an application to condone the delay. There's no counterclaim.
No, I think the court has given them liberty to file the counterclaim.
They didn't claim. They don't make a claim for counter. There's no counterclaim made in the statement of objections or the written statement.
No, in the order somewhere I read it. The court says they are at liberty to come
They
up
are
with
at liberty
their
to raise it. But after this, my lord, since this matter was challenged before your lordships, they filed the written statement. Now, of course, whether it's within time or not is a different issue. But they filed the written statement. In the written statement, they should raise the counterclaim if they had suffered loss. No counterclaim.
After this order, they
After this order, no counterclaim, which shows not that this defense itself was an improbable defense. They raised it only for the purpose of trying to get leave to defend. Now it's only a simple. And oh, my lord,
Is it correct, Mr. Counsel?
I have the written
That
statement.
no
I would not
counterclaim.
know that, but my lord, but what was asked of me at that point in time was, during those days, that 120 rule, even in regular suits, the amended CPC was prevailing. It has now been stayed, and therefore that rigor is not there. Therefore, I had advised them, at least for whatever it is worth, place.
There's a commercial suit that 120 is there.
It is a
for,
commercial. So anyway, that 120 days was there. So they filed the written statement for whatever it is worth.
No, not whatever it's worth. It's a written. If you succeed, it's
My defenses need not be prejudged at this stage.
No,
And-
just as a.
As
Because
a
the
matter
court-
I am under instructions that there is no counterclaim raised as of now.
Therefore, my lord, I asked me what else is left.
Therefore, no need for a trial, no need for anything. Let us just give him a decree and he can walk out of the
That
court
is
today
exactly
itself.
what we are saying. This is an admitted fact.
I have only, if
How?
the learned friend finishes,
No, I'm
one
not
more
finished.
submission.
I'm not finished. I'm only saying this whole argument, oh, I suffered 100 crores loss, 50 crores loss, all that is all that in your application you leave to defend. But where is your counterclaim? There's not even a single word in your statement in your written statement. Please see, my lord, the written statement starts at page number 7. Simpliciter, a written statement. And if they don't file a written statement along with the counterclaim along with the written statement, then that's the end of it. They don't have a right to make a claim later on, unless. And there is no counterclaim. Lordship will say there's absolutely no counterclaim.
Yes.
My instructions now, my lord, I just got. There is no counterclaim because what my learned friend has omitted to mention is that along with the written statement, we have also filed an application under section 8, contending that in the contract between the parties, there is an arbitration clause. Suit itself is not maintainable. So that section 8 is pending adjudication. They will move the counterclaim before they learn an arbitrator as and when the section 8 is allowed.
That is on an
Those are
assumption.
my
You'll say,
instructions.
everything is on an assumption you'll succeed.
Exactly.
According to me, there's no agreement. The
Therefore,
term sheet is
should we also assume that the plaintiff will succeed? With respect, that cannot be the
No,
case.
the point is, if you succeed, it's a different
Everything
thing.
is assumption at the time of filing pleadings. It is only at the time of trial that will get tested. Only one submission, my lord, further.
Sorry, I'm so sorry. As a matter of fact, my lord, in the leave to defend, then that should have been a ground.
No,
Right,
of course, not necessary. That's a different ground by itself. I mean, it is not that it ought to have been done, this ought to have been. I have done what I have done. I have filed my leave to defense. The trial court has come to a conclusion that I do have a substantial defense. I have also filed a section 8 saying that your suit itself is not maintainable because of the arbitration clause. That is
you've not
subject to
said.
adjudication. Just one. Not in its extract of B.L. Kashyap, the Supreme Court judgment, the trial court has extracted para 17. The next para 17 in 32. If my lord will come to page 15, page 15 of B.L. Kashyap, where those 4 buckets are extracted in para 32.
Yes.
At para 32, the 4 buckets are extracted. Lord, para 33 is the actual finding of law, which the trial court inadvertently probably omitted to set out. I'll just read out para 33. It is at once clear that even though in IDBI trusteeship, this court has observed that the principles stated in para 8 of McCulloch Engineers case shall stand superseded in the wake of amendment of Rule 3 of Order 37. But on the core theme, the principles remain the same, that grant of leave to defend with or without conditions is the ordinary rule and denial of leave to defend is an exception. Putting it in other words, generally, the prayer for leave to defend is to be denied in such cases where the defendant has practically no defense and is unable to give out even a semblance of tribal issues before the court. Therefore, to say that I have a substantial defense, but I'm still trying to balance. My learned friend sought to put me into the third bucket. The third bucket, we will just see, my lord, what is a third bucket where some conditions could be imposed? Because the first and second bucket entitle me to unconditional leave. It is a third bucket where the trial court can impose certain conditions. Third bucket, in the same paragraph above, is at para 17.4. 17.4. If the defendant raises a defense which is plausible but improbable, the trial court may impose conditions as to time and mode of trial as well as payment into court or furnishing security. As such a defense does not raise tribal issues, conditions as to deposit or security or both can extend to the entire principal sum together with such interest as the court feels the justice of the case requires. The trial court gives categorical findings that there are tribal issues raised. Nowhere the trial court says that there are no tribal issues or that the defense is vexatious or frivolous. In those circumstances, my lord, when those are the findings, the conclusion is improbable, the conclusion is conflicting. Great.
I think, Lord, insofar as my learned friend submission of reading that para 33 says you can grant leave to defend. On what conditions it must be granted is not stated in para 33. That is what is contained in para 7 or 32.2, where they refer to IDBI. And my lord, this amount is admitted. And now today you don't have a counterclaim. And you can't then refer saying, I have filed an application under section 8.
I can. I can't.
1 minute.
I can.
I mean, why are you interrupting, Mr. Joshi? You can't file an application under section 8 and say, that is the reason why I have not raised a counterclaim. You should. Oh, come on. Why are you?
I'm not.
You are constantly talking.
He's distracted because he's not sure of his own submissions. I am not saying anything. In good spirit. We don't intend to.
No. My respectful submission is only this. Today, the court has used the word substantial, but obviously understands not substantial in a very narrow way, as we understand, saying he has raised a substantial defense. Not in the legal way, because final finding is, your lordship must contrast it with the earlier conclusion here the learned judge has drawn. Why did you issue a check? There is a reason why you have issued the check. That has to be explained. I therefore believe it must be explained in trial. But the fact is, check is issued. And the fact that a check is issued, whether a security or otherwise, now if it is not payable or not refundable, there's no question of issuing a security check. A security check is to secure, my lord, what you ought to have done of refunding. If you don't refund, I'm entitled to present this security check. That is ultimately the objective. And therefore, when I present the security check, I'm entitled to the money. And I'm therefore filing my suit also on the basis of that document. In my respectful submission, therefore, when those two facts are looked at, and the fact that there was a security given, there is an admission insofar as that amount is concerned. And if that amount is admitted, then in terms of the proviso, you are liable to make payment to that amount of money. And in my humble submission, therefore, the order is absolutely right in saying that you must deposit the principal in court. If you succeed, the money will go to him. If you fail, it will come to me.
Great.
Cell number 2.
There are two matters, both are connected.
Both
are almost
What
identical.
about the other one?
Both identical.
Identical.
Cell number 2. Santosh PM for petitioner. Rupesh B.
I pay some time. I got to produce a few documents.
What documents?
A week's time, my lord. Next week, your lordship, I kindly have to.
I've already said yesterday I have given enough
No,
time to.
a week's time, my lord. I'll.
Either today I dismiss or I dismiss it in the month. I'll post it in the month of September. No via media.
September.
At the request of land counsel for the petition.
Cell number 3.
Memo for withdrawal. Trial court suit is in practice. Suit is in practice.
Suit is disposed of.
Make one submission. In your pendency of this petition, they say the petition is pending, therefore that
List this
application.
matter in the month of, earlier matter, list in the month of September. The pendency of as there is no stay granted by this court, this trial court is at liberty to proceed with the matter.
Lord, I withdraw.
Give a memo, not a case, Mr. Counsel. Yes, take the memo. Memo is filed, not about your case.
Sorry.
Earlier case.
Sorry.
Memo is filed seeking to withdraw the writ petition, dismissed as withdrawn. Yes, in this, give this one, third. Where is that memo? It is, memo is filed. That is. And
Cell
four,
number 4.
the writ petition matter, the writ petition, the memo is filed seeking to withdraw the writ petition. Accordingly, the writ petition is dismissed as all the contentions are left open to the parties to agitate before the trial.
Cell number 4.
Petitioner, madam, the matter has been settled before the trial court, madam. The writ petition will be in practice.
That the matter has been the petition has been-
Great.
It's fine.
Mariere, Vinay N for petitioner.
Coming up for the first time.
Kindly pass over. This is coming for the first time, Your Lordship. Kindly
But you
pass
have
over.
to, in the meantime, where is that list? Vinay, V.S. Karthikeyan, serve papers on him.
We have served BBMP, Your Lordship. We went to the BBMP
Huh?
office. We went to BBMP office. We served them 2 copies of the.
No, this is matter pertains to BESCOM.
Yes, Your Lordship. Sir, BESCOM office, we went there, we served them a copy, Your Lordship.
You know, if you want an order, you better serve on the council so that he'll get instructions. Tell him that I'll take it up at 2:30. Let him get instructions, or else I'll take it up as first matter tomorrow.
Much
That's
obliged, Your
better.
Lordship.
Print the name of Mr. B.S. Karthikeyan is directed to take notice on behalf of the respondents. Respondent 1 and 2.
Yes, sir.
Respondent 1 and 2.
1 and 2, Your Lordship.
Print the registry is directed to print his name and counsel. The petition is directed to serve the copy of the writ petition on the council. The council shall get specific instructions. This matter as first matter tomorrow. Yes, next.
Still number 6, Prakash K. RB for petitioner.
Yes, madam, appearing petitioner, my lord. This is with regard to court fee, my lord. With regard to court fee, my lord. My lord, the
Court fee.
court fee, my lord. Court fee. The plaintiff has paid the court fee under section 24D and section 26 of the Karnataka Court Fees and Suits Valuation Act. I would like to take lots
So
of
this we can decide. This we can decide after notice to the respondent.
till then.
No,
still-
why should it be? Court fees is not your problem. That will be paid to that is issued, your court is also concerned. This is matter, notice to the respondent. Petition is permitted to take out and summons on the council, appearing for the
My
respondent.
lord, no defendant are appeared before the court. When the matter was posted, first day this order was came to be passed, my lord.
Give that. Yes. Where is the order?
My lord, Annexure A, that is page 23, my lord.
Hmm.
Will take lordship's attention to the page 27, my lord. At para number
What is
5.
the suit for?
Suit for, my lord, seeking permanent injunction in respect of A scheduled property which is purchased under the registered sale date dated 28/3/2007.
Hmm.
I am seeking as a C relief, seeking only permanent injunction. I will take lordship's attention to the plaint which is filed by me before the trial court. I will take lordship's attention to the relief which is sought before the trial court, my lord.
What is this? However, the plaintiff cleverly did not sought for the relief of declaration of his title to the property in order to avoid payment of court fee.
My lord, may I take lordship's attention to the para 3 of my plaint, my lord. The plaintiff submits that she is the plaint, my lord. Page
Para?
36, para 3, my lord. Para 3 of my plaint, that is
Page number?
36, my lord.
30?
6,
Hmm.
36.
Hmm.
The plaintiff submits that she is the absolute owner of the property bearing site number 15, situated at Apna Ashiana Layout, Timmasandra Village, Kasba Hobli, Hanekal Taluk, Bangalore, district, measuring east to west 60 feet, north to south 40 feet, totally measuring 2,400 square feet, which is purchased under the registered sale date dated 28/3/2007. So and so. Well, this is the pleadings which are mentioned in the plaint. May I take lordship's attention to the order passed by the trial court para impugned order, my lord.
You are
In
the
the
owner of the property or purchased the property in the year 2007.
Yes, my lord. My lord,
What is this 2023
subsequently,
sale
my lord,
deed?
subsequently, who are executed the sale deed in favor of Apna Sapna way back in the year 2005. Then layout has been approved by BMRDA. After approval, I purchased this property Again, once again, the earlier owners has executed and sale deed in favor of defendant number 28 for an entire extent, and then fencing has been.
So according to you, mere injunction is maintainable.
My lord, I am seeking, my relief is with regard to my property's injunction because I am in possession, my lord. I am in lawful possession.
You're seeking cancellation of the sale deed.
My lord, I am seeking, as a null and void, I am not party to the sale deed which are executed by the earlier owners in favor of defendant number 28, my lord. So that I am seeking as a null and void. That is, there is no issue with regard to subsequent sale deeds are concerned, my lord. The trial court raised the objection saying that so far as your sale deed, you have to pay the court fee as contemplated under section 26B of the Karnataka Court Fees and Suits Violation Act. 26B.
Heard reserved. Yes, next.
So, 35.
For petitioner, my lord, matter is already settled in local authorities 11/7.
Calling it no. You will see when the matter reaches. Yes.
Serial number 7, Ramesh Chandra.
I am appearing for the petitioner challenging the constitutional validity.
The mic.
Challenging the constitutional validity of section 4 for the amendment of the CPC, my lord. For the filing of the return statement, my lord. Order 7 rule 1. My lord.
What is the delay?
Delay is 144 days. My lord.
Above 120 days.
Above 120 days, my lord.
No. After 120, another 140.
No. Totally around 135 to 140.
Another 20 days. Still.
Yes.
The petition is before this court, questioning the constitutional validity of the amended proviso, and also the amendment to section 4 of the CPC, and also an order dated 7/2/2026 passed with the principal civil judge CJM Davangere, whereby the court has refused to take the written statement on record as it is filed beyond 120 days. Then counsel submits that the petition has stated the reasons for the said delay, and further a coordinate bench of this court has already stated the operation of the amended act. In that view of the matter, there shall be stay of all further proceedings pursuant to the
Coordinate bench.
I'll take notice for respondent number 5, my lord.
order dated so and so. AGA takes notice on behalf of fifth respondent. Accepts notice.
Coordinate judgment order, my lord.
The petition is permitted to take out notice on respondents 1 to 4. How many are there?
4.
1 to 4. On the council appearing before the trial court and shall file a memo. Shall file a memo in that regard. By 28th of July, orders to stay granted by this court stands vacated in all the matters. Notice in addition the hand summons. Yes,
5 is the state, my lord. 5 is the state, my lord. Respondent 5 is the state, my lord.
He has taken notice. Sir.
What's up?
Yes.
Number 8, VP Shivakumar for petitioner.
Can be taken up tomorrow. Senior held up in other court.
Huh?
Senior held up in other court. Maybe taken up tomorrow only, my lordship. There is some.
Tomorrow it's not possible.
There is some
This
emergency.
matter next Tuesday. Yes. 9.
Cell number 9, Maya Holla for petitioner.
My lords, I request for a short adjournment. Seniors, my lords, the day after tomorrow, if it may
Why?
be taken. My lord, seniors are not available, my lord.
This is matter on 23rd of July.
Cell number
Please then.
10. Cell number 10.
For the petitioners, my lords. Petitioners are the plaintiff before the trial court. Suit is for declaration and injunction, my lords. My lords, defendant is the association. My lords has conducted a general body meeting without complying the quorum as required in the bylaws, and passed certain restrictions on the tenants of the petitioner along with other residents, my lords, wherein entry and exit of the tenants were restricted after 10:30.
What is the suit for?
Suit is for declaration, wherein my lords, general body meeting conducted on 3/5/2026 was challenged and sought for declare it as null and void. And also filed application to stay the impugned general body meeting, implementation of the general body meeting notes, wherein certain restrictions as against the tenants.
The order.
Notes wherein since the trial court has issued a notice, observe.
Where is that page number?
Order is at page 39 minutes. Page 38. Wherein trial court was of the impression that bylaws were challenged and issued a notice. Wherein what has challenged before the trial court is only the general body meeting, not the bylaws.
No, it has come up on 26/2026. What happened?
On that day, my lords, notice was not received by the respondent. Once again, steps were taken, and now it is posted for September in the month of September 29th, my lords.
Please come. The petition is agreed with the order dated 29/5/2026 passed by the Principal City Civil and Session Judge Bangalore, whereby the court has issued suit summons without passing any orders on the IA number 1, seeking injunction. What is IA number 1?
IA number 1 is at page 35 minutes, page 55, wherein we have sought for restraining or temporary injunction restraining the defendants, its office bearers, agents,
Sought for injunction.
implementing.
It is submitted that an application is filed seeking ad interim injunction. Court has to pass orders on the merits of it, but it cannot issue notice to the. But it cannot. But the court has issued suit summons. He has relied on the judgment of a coordinate bench of this court in so and so. Till you will get that judgment as in so and so so and so. In the light of the above judgment, this court deems it appropriate to pass following order. The order dated so the trial court is directed to consider I number 1, notwithstanding the fact that the notice is not served on the defendants. The same shall be considered within 1 week from the date of receipt of the copy of the order. Yes.
Notice.
Great.
Yes.
Raven, Santosh, Sanat, Kumar SP.
For the petition in this matter, please, Lord. Writ petition is filed seeking a mandamus directing to trial court to consider the application filed by me
When did you file?
in December 2025, please, Lord.
What is this IA?
One is recall, reopen. Another one is production of discovery of the documents.
IA number?
IA number 19, 20, and 21, please, which has not been considered.
The present petition is filed saying the following prayer. Then counsel petition submits that he has filed IA 19, 20, 21 in the month of December 2025. So far, the court has not considered the same, hence is constrained to approach this court considering the submission of the done counsel. This court has passed the following order. The writ petition is disposed of, requesting the trial court to dispose of I number 19, 20, and 21 as expeditiously as possible. In accordance with law, no notice is issued to the respondent as disposal of the matter is in the interest of both the parties. Yes.
Number 12.
So the next date is on 21st this month. So
Is it as expeditiously as possible?
please.
Yes.
Number 12.
Yes.
My lords, against impugned order, again on application for appointment of commissioner, my lords.
What is the
Not
suit for?
Suit for earlier for injunction, my lords, later converted for possession also.
What is the present stage?
Present is status is, my lords, argument is concluded now.
Documents are concluded.
Evidence is concluded, my lords, it's for arguments. My lords. Now what has happened, my lords? Rejection ground, my lords, is an impugned order at page 90. Relevant para at
Not
page
the
90.
defendant, not the plaintiff.
I'm the plaintiff, my lords. Page 99, my lords. Where my lord rejects on that, this application amounts to an res judicata. Earlier application was filed.
Where is that?
That my lord, page 99, could my lords would find. Starts at 90, my lords, at annexure K. But my lords, page 99 would my lords is para 10. In fact, on earlier occasion, my lords, a liberty was resolved. After leading evidence of both sides, it can be considered.
What is order?
That my lords, kindly my lords, annexure it's page 70, annexure F.
Why the court is not able to read its own order? 70?
Page number 70 my lords. Annexure F my lords is the earlier order where my lords suit for injunction. Para 12 my lords could find at page number 75 my lords.
Please come. Then counsel to the petitioner submits that when an application is filed for appointment of an advocate commissioner, after the evidence is concluded, the same is dismissed. Observing that the application is hit by section 11 of the CPC as the earlier application is dismissed. Then counsel for the petitioner submits that when the earlier application is filed, by the time the evidence has not commenced, hence that application was dismissed, and the court has the finding of the court that is hit by res judicata is bad. It is submitted that this is an appropriate time to appoint the advocate commissioner, and the court has failed to consider why the appointment of commissioner otherwise is not required in the facts and circumstances, and more on the fact that the earlier application is dismissed, has dismissed present IA. Considering the submission, there shall be stay of. You want stay of your own?
Stay my lords, stay of the process.
Stay of all further proceedings pursuant to the order date so and so. Notice to the respondents. In addition, same hand summons memo shall be filed by 29th of July, or else a stay granted by this court. Stands
Number
again.
13, Raghavendra V.
For the petitioner, my lord, in a suit for partition, the trial court, after framing of issues, my lord, the issue pertaining to the limitation and court fee has been tried as preliminary issue, my lord, which is against to the dictum full bench decision of this honorable court and the three-judge bench of the honorable apex court, my lord, but has been challenged before this honorable court.
Where is that?
Annexure A, my lord, impugned order. Annexure A, page 14, my lord.
What was the reasoning given by the court? Let's see.
But issue number 4 and 5, my lord, it has been narrated in the impugned order itself. I have also produced the issues, my lord. In all 9 issues have been framed by the trial.
No, there is a reasoning. What is the reasoning given by the court?
My lord, page 16.
Yes.
The instant suit is a suit for partition of the suit property brought about by the children of first defendant, seeking partition of property in their favor, with the plaintiff claim that the defendant number 1 has alienated suit property without their knowledge or consent. In response to the suit, the defendant number 2 has filed a written statement containing this court does not have the pecuniary jurisdiction to try the instant suit, and this instant suit is hopelessly barred by limitation. And accordingly, issue number 4 and 5 were framed as to set as preliminary issue. However, a total volte-face to the written state contention, defendant number 2 submitted that he has no evidence to lay upon the matter which evident by order dated 28/11/2024. Accordingly, matter was proceeded with. The share of the plaintiff in the suit property is valued by her at rupees 3 lakhs as per the valuation slip dated 12/4/2022. The burden to prove the plaintiff share in suit property exceeds the pecuniary jurisdiction of the court is upon defendant number 2, who has failed to discharge the same. Therefore, it is held that this court has the pecuniary jurisdiction to try the subject matter of the instant suit. Accordingly, issue number 5 is answered in the negative.
No. Earlier, there must have been an order that these issues will be decided as the preliminary issues.
Yes, my lord. While framing issue itself, my lord, the court has, I have produced the issues, madam. You may kindly peruse the issues at page 28, annexure D. In all 9 issues of framed, in the next page, page 29, my lord, last page, there is a note, my lord. Issue number 4 and 5 are hereby ordered to be tried as preliminary issues as the same.
Have you questioned it?
No, my lord, that they have not questioned, madam. But they,
Without questioning it, you were no. How
No, my
can you
lord.
question this?
trying these issues, my lord, is bad under law, my lord. That is what against the dictum of this honorable court, my lord.
That is dictum. When was this order passed? On 27/4?
2024, my lord.
And then
27.
what were you doing from then?
The parties were not aware of this, my lord.
And you let the court to do all exercise.
My lord, there was no evidence at all. Plaintiff has not led any evidence. Defendant has not led evidence. Even plaintiff has not led any evidence. Without there being any evidence, issues have been answered by the trial court, my lord.
No, after pronouncement of the judgment, you should have questioned all this.
May I furnish the decisions of this honorable court, my lord, full bench decision of this honorable court?
Decisions are not required for every case.
Please, my lord. And even my limitation issue has been tried as preliminary issue, my lord, which is a mixed question of law and fact, my lord, without there being any evidence by both the parties. And moreover, my lord, plaintiff as the defendant has not challenged the jurisdiction of the court. What he has stated is plaintiff is not in possession of, because sale is of the year 1999. Suit is filed in 2022. The contents of the defendant is, my lord,
Pecuniary jurisdiction that cannot be tried.
pecuniary limit, my lord, the limits of the trial court, my lord, which is civil judge. By that time, the 5 lakhs rupees was the under the Karnataka Civil Courts
But
Act.
few of these two issues are decided. Pecuniary jurisdiction, why it
Pecuniary
cannot,
jurisdiction
why
pertain
it
to
cannot
the-
be decided?
No, that was not the contention by the defendant at all. What defendant has contended it, plaintiff has not paid the correct court fee. That was the contention. But the trial court has framed an issue saying that whether this court has pecuniary jurisdiction. We have not, the plaintiff defendants have never challenged the pecuniary jurisdiction of the court. Well, under 35(1), section 35(2) of the Court Fee Act says that if the plaintiff is in possession of the suit scheduled property, court fee is rupees 200. If she is not in possession, under section 35(1), court fee has to be paid under market value.
This issue was framed long back. Have you asked for recasting of the issues? Everything you keep quiet, and now suddenly you wake up and come to the
My
court and
grievance
say
is
that
that
everything-
without there being evidence, these issues have been answered, my lord.
Let notice go. Notice to the respondent.
May I request for the stay of the trial court order?
Cell number 40.
Notice to the respondent. Petition is permitted to take for handsome. In addition.
Number 14.
My lords, I appear for the petitioner in this matter,
11.
my lords. This serial number along with serial number 26 may kindly be done. Serial number 26 is also arising out of the same order. Common order passed by the lower appellate court in RA number 5 of 2026.
What are
My
these
lords-
two IAs?
My lords?
What are the two IAs?
Two IAs, my lords. This IA, this serial number 14 is IA for seeking leave of the seeking leave to file RA by the respondent. It is filed by the all IAs by the respondent only.
Then what is other IA?
Other two IAs, serial number 26, my lords, it is for the stay. He asked for stay. Court has granted stay.
What is the suit for?
Suit, my suit it is. My suit for partition. I filed suit OS number 2014 of 2000 in 2011 for partition and separate possession of my share against my father and my stepbrothers. That was decreed in 2020. My lords, the respondent herein, he is neither the purchaser through my father nor brothers or anybody. He is totally a stranger to my property. He was never ever in the picture. And he says he purchased it to purchased from his vendor Krishnappa, who is also not my family member, nor purchased through me, and there is no connection at all. And that Krishnappa, through whom he is claiming title, he created a fraudulent revenue record. Based on that, he sold it to the respondent herein. And now he is filing in my partition suit. I got a decree in 2020. After a lapse of 2000 days, he filed application for condonation of delay and he filed RA against decree. I got it in partition suit. He is no way
When he
concerned.
purchased the property?
My lords?
When he purchased the property?
He purchased, my lords, in 17. Kindly, my lords, I am passing on these two documents, sale deeds. The first one is, my lords, I have also given, kindly see the cost title, my lords, because these names of the parties is very important. This is first sale deed in 2017 by Krishnappa. Krishnappa gives GPA to Krishnamurthy and Krishnamurthy in turn sells it to Krishnappa. And Krishnappa in 2024 sells it to the respondent herein. Both of them are strangers to my family.
Now the party who has filed the implead or a leave to appeal.
Leave to appeal.
Leave to appeal.
Yes.
Has purchased a property in the year?
In 24. My decree is in 2020. My suit is 2011. And none of them are...
and after 2020, what happened? After your suit is decreed.
I filed... after the suit is decreed, I filed execution petition.
What is the stage of the execution?
FDP, sorry.
FDP, what happened?
It is pending. That is, my lords, when this is going on, he files against my partition decree, RA, seeking leave. My lords, the legal question is this. The suit, he has to file a separate suit if at all he is aggrieved because he has to seek declaration.
What is this case? What is his case? According to him, what is the relationship between this joint
No,
family?
no, he says he himself admits he is no way concerned to my family. My lords may kindly see the paragraphs in the order, common order passed with the.
Come to the order.
Yes, my lords. Kindly see, my lords, page number.
Court grants leave.
Page number 280, annexure AA is the impugned order, common order on IA, all three IAs. Kindly, my lords, I come to the relevant paragraph, page 290, para 20. My lords, his claim, it is contention of the respondent herein is called out, and his claim came to the his claim of the title. Appellant submit that originally item number 1 of suit scheduled property belonged to Nanjappa Kempanna. Since the land revenue was not paid, the property was declared as Sarkari Pada. Krishnappa, son of later Giriyappa, late Giriyappa, who is the grandson of Nanjappa, filed application on 18/3/2006 to cancel Sarkari Pada and to restore Khata in his name so and so. This is what is his claim, my lords. That is Krishnappa. He says it is my grandfather's land. There is a dispute regarding.
So he can even in FDB proceedings also he can file a petition as an, if it is his case that he is in possession of any property as an obstructor, he can file an application before the FDB court.
FD, my lords, what happens is here. Now he is not claiming through me nor my father. He is totally a stranger here. He says it is my grandfather's property. In the event, what happens, my lords? It is only unsettling my partition decree. That's all. Can he claim a title, my lords, on the basis of?
Agreed with the, so these two petitions here, this one, 14 and 26. Then counsel for the petition submits that the respondent herein has filed I number 2 to 4 before the in RA number 10001 of 2026 before the 4th additional district and session judge at Dodvalapur. He has filed the application to leave to appeal with a condemnation delay and seeking stay of further proceedings. Then counsel submits that the petitioner herein has filed a suit for partition in the year 2011 and that came to be decreed in 2020 and the final decree proceedings are pending, stating that he has purchased a property from a person unconnected with the family. He has filed the present RA along with the 3 applications. He submitted that the court without considering the aspect that he is unconnected with the joint family and his remedy is to file an independent suit, but he cannot seek stay of the, he cannot unsettle the judgment and decree that is passed in favor of the petitioner family. This, considering the submission of the land council and the petitioner, there shall be stay of all further proceedings pursuant to the order in I number 2 to 4. Notice to the respondents. Notice to all the respondents.
And to the council, my lords.
All the respondents.
Yes, my lords, and also to the council.
On council only, I'm saying to all notice,
Yes,
all
yes.
petitions permitted take out hand summons on the council appearing with respond and file a memo to that effect by 29th of July or else a stay granted with this court's transfer.
My lords, there is one more on delay, which was we moved actually, my lords, but before it came to the board branch, it was late. That number is there and 21268 of 2026, my lord. It will
List
come up
along
tomorrow.
with, list along with
21268
21268.
of 2026.
Tag these 2 matters and list along with that. Yes.
Obliged.
And that was, yes.
Till number 15, Mahesh Arupin.
For the petitioners, my lord. My lord, herein a suit was filed against me and my son, my lord, by my daughter-in-law, my lord. The trial
The
court.
suit for partition.
Yes, my lord. Suit for partition.
What is IA?
My lord, seeking stay, my lord. My lord, in the FTP, my lord, my son had passed
Asking what is the present impugned order?
My lord, in the petitioner's son has passed away during the proceedings, my lords. The Honorable Court, Trial Court has, in the FTP proceedings, has ordered for second preliminary decree, my lord. Instead of giving the share of my unmarried son to me, my lord, they have divided it between the sister-in-law and the mother, my lord.
Who has filed the suit?
Suit was filed by the daughter-in-law, my lord. The son,
The unmarried, who is
there were two sons, my lord. One was married to the petitioner, my lord. Petitioner, plaintiff in the suit, my lord. So the plaintiff has filed for partition, my lord. 2/3 share was granted, 2/9 share was granted to her. 4/9 share was granted to the second son.
plaintiff is, you're the plaintiff.
No, my lord. I am the defendant number one.
Who is the plaintiff?
Plaintiff is my daughter-in-law.
2/9 share. Defendant number one is?
Defendant number one is myself, my lord. I'm the mother.
Share.
Yes.
Defendant number two?
Is the other son, my lord, who was awarded 4/9 share.
Hmm.
So the defendant number two passed away, my lord, during the proceedings, when the proceedings were.
Where is the order impugned?
Order 31, my lord. Order dated 29/8/2025, my lord. The trial court has rejected the commissioner report, my lord.
Hmm.
It was noted that the defendant number two has passed away. Noting that the trial court has passed an order to draw a second decree, my lord, second preliminary decree, dividing the share of both mother-in-law and
Where do you get that? Notice to the respondents. Petition is permitted to take court handsome. The memo is filed by 11th of August. This is matter on 12th August. Yes.
My lord, the FTP proceedings are going on, my lord.
Let it go on, nothing will happen. We'll see.
16 Shashikumar.
For the petitioner, my lord, the suit for recovery of money, my lord. I'm the defendant in the suit, my lord. My return statement has been rejected. I filed
What is the delay?
18 days behind 120 days, madam, my lord.
Same, in the like
Even after
other
considering
other matter with regard to the amendment. Same order. Yes, notice to the respondent, same hand summons, and memo shall be filed by 29th. Yes, next.
My lord, the
17.
proceedings are going on, my
I granted stay.
lord. Grateful.
Yes.
Ask Shashidhara.
Application seeking permission to file return statement came to be rejected, my lord. New of the amendment to the CPC.
How much delay?
Plus, the 28/11 is 25, the last date, my lord. I filed on 6/1/2026, my lord. 3 months.
Is it a commercial suit or regular suit?
Regular suit, civil suit.
Same order in this also.
Till number 18. Party in person, Shankar Nasimha Bhatt.
Yes.
ಪಾರ್ಟಿ ಪರ್ಸನ್ ಶಂಕರ್ ಭಟ್ ಅಂತ ಮೇಡಮ್, ಒಂದು ನಮ್ಮ ವಿರುದ್ಧವಾಗಿ ಒಂದು 2020
Sir, English ಅಲ್ಲಿ ಹೇಳಿ.
ಇಂಗ್ಲಿಷಲ್ಲಿ ಹೇಳ್ಬೇಕು. ಓಕೆ ಮೇಡಮ್, ದಿಸ್ ಈಸ್ ರಿಗಾರ್ಡಿಂಗ್ impelled order issued by the Honorable Trial Court CCH-43.
What is the suit?
Suit is for by the plaintiff on 20 OS at CCH-43 on refraining the permanent injection on writing emails and LinkedIn
I list this
platform.
matter before the other court.
It is there. It is there in the earlier.
No, I listed before the other judge so that you will be able to argue because I am not able to understand Kannada.
No problem.
The party in person.
Well, I can also argue in English also.
With Kannada.
No problem.
The registry is directed to list this matter before another bench after obtaining necessary orders from the Honorable Chief Justice.
Till number 19. Sarvana S.
So respond number 1 filed suit for partition, claiming the suit scheduled property is the ancestral property, and defend number 1 to 10 they constitute a joint family property. I was a defend number 11, not I.
Tell him what it is. What else?
Not I was defend number 11. I had purchased the item number 1 property in the year 2005. Not the suit proceeded ex parte. None of the defendants were served. The respond number 1 obtained the ex parte judgment. On the basis of the ex parte judgment, she also filed a final decree proceedings. Final decree proceedings also proceeded ex parte. Notes by order dated 1/6/2024, the respond number 1 secured an order
Date, day after tomorrow.
The day after tomorrow. Okay.
Day after tomorrow.
16.
List it day after tomorrow.
Notice the final decree proceedings also proceeded expiry. 1/6/2024, respond number 1 secured an order for appointment of a court commissioner. Thereafter, notice the petitioner appeared in the final decree proceedings. He filed 3 applications. One to set aside the expiry proceedings against him, that was set aside. And another application seeking permission to file objection, that was also allowed. We filed one more application seeking notice the court to relax that application, the order dated 1/6/2024, to keep that order in abeyance so far as appointing the court commissioner and proceeding with demarcating of the property. Court is
Why all this exercise is done by the executing court? There is an ex parte judgment.
ex parte judgment.
You have to question it by filing an appropriate.
No, that miscellaneous proceedings also filed. We only requested the court till such
Miscellaneous petition, you will ask all these reliefs, seeking stay of the other proceeding.
But now what has happened? This order is dated 1/6/24. 1/6/24 is the order, original order directing the final decree proceedings, directing for an appointment of court commissioner. It had not yet proceeded till that date. Once I filed an application telling that please keep it in abeyance, I'm taking my necessary steps to see that ex parte judgment is set aside. Court says no, by 31/7 the court commissioner should file the report.
Correct.
After I file an application, let's court's passing.
Because you're asking something the executing court which it is not concerned with.
Not, I understood not that miscellaneous proceedings we are taking step. We are taking step.
What was the reason for you not to appear before the court? Why was
Not summons was not served.
ex parte?
Not summons was not served. Summons was not served. Otherwise, the notes, I am a purchaser. Why will I keep white notes? I would have definitely notes. Not only me, the other.
As per the court proceedings, how the summons are served on you?
Not that we have taken all the order sheet and we are filing a business petition that.
What it says?
Not it says.
The order sheet says that how the notices are served.
Not in others. That information is not clear with me.
Will please take notice to the respondents. We'll see.
May I request any short date before 31st of July?
Yes.
I will serve the advocate notes.
And counsel for the petty notice, in addition, petitions permitted to take out handsome. And the counsel appearing for the respondent shall file a memo to that effect by 30th. If the memo is filed by 30th, this is a matter on 31st.
31st, before the 31st, 28th.
If the memo is filed by 29th, this is the matter on 30th.
Please.
Cell number 20, Abhinay YT for petitioner.
No representation in the month of September.
Cell number 21, K. Krappa.
Same order.
Cell number 22.
Passwords will not be called. I'll pass over. Password.
Cell number 23, Somshekar KM.
I am seeking directions to dispose of the suit as earliest.
Suit is of which year?
22, my lord.
Which court?
My lord, the senior civil judge and JMFC Anekal, my lord.
The memo is filed seeking mandamus to dispose of the suit of the year 2022 on the file of pending on the file of
Senior civil judge and JMFC Anekal.
Senior civil judge and JMFC Anekal. The registrar judiciary is directed to call for a report from the concerned judge with regard to the statistics pending cases before the court. Yes, this is matter in the first list on Friday. Yes.
Cell number 24. All done.
Against the ex parte order.
Yes.
We have come before your lordships.
Ex parte?
Ex parte order temporary injunction. We have come before your lordships. Only thing is, we, my lord, also, my lord, I must also bring this to your lordship's notice. They filed an application for vacation. Please come to, my lord, page 28 for a minute. Objections to that IA, my lord.
When were they filed?
My lord, it was filed on 9/7/2026.
We'll ask the court to decide it within a week.
Please.
Where is that order?
My lord, please come to page 28. At 29, my lords get the impugned order. And that we filed objections, my lord, to that IA is at page 32.
Please come. The petitioner is agreed with the order. The petition defendant is before this court agreed with the order dated 4/7/2026. Passed in I number 1 by the principal city civil and session judge in OS number 4736 of 2026. Then the senior counsel representing the counsel for the petitioner submits that the court had granted an ex parte injunction on ex parte injunction 4/7/2026 immediately after service of notice on the respondent defendants. They have filed their objections and it's a grievance of the petitioner that the court has failed to consider the same. Even 30 days is not yet completed.
30 days is not complete, but then, my lord, there is urgency because of this. The injunction order virtually says you shall not, my lord, terminate. CEO, my lord, getting, my lord, 4 crores of rupees. She has been, my lord, harassing the life out of these young, my lord, young.
No, but why should this court interfere?
My lord, I'll tell you, lordships. Can I, my lord, seek one indulgence?
Yes.
The interim order, my lord, that was passed, they must not dispensing with 39 rule 3. They must give reasons. My lord, can I just pass on one judgment of Justice Nagaratna?
No, where but in every case, that's what happens in every ad interim injunction.
Only thing is, they must give reasons. And that's what, my lord, laconic reasons, my lord, mere, my lord, verbatim reproduction of order 39 rule 3, my lord, is not sufficient, is what this honorable court has said. At any rate, my lord.
No, we will not interfere because this, if you make this a practice, then there is no end to this kind of litigation.
Because, see, what has happened is,
This is a matter coming up.
25th, my lord.
We'll say expeditiously to be decided. The, what did you do?
Huh?
The court has failed to consider same and so far.
My lord, can I seek one indulgence? We filed a caveat. Despite it, my lord, she, my lord, without notice to us, my lord, is passed the order. If I can give you, lords, one judgment of this honorable court, when a caveat is filed, you can't pass an ex parte order.
It is submitted that.
That's why, my lord, when your lordship said, my lord,
Spite of a
for within a week, I didn't want to, my lord.
caveat. No, if it is caveat or not, so it's a different, not this case is different. That is submitted, they've already filed a caveat and the court, without there being a notice to the petitioner, an ex parte injunction is granted. Then senior counsel submits that. Even seeking dispensation of notice to respondent, the proper reasons have to be given. Whereas in this case, even that and even there is no compliance of the same. Next paragraph. Considering the fact that a caveat, in spite of a caveat being filed, no notice is served, and already the objections are filed by the respondent defendant. The trial court is directed to consider the objections to I number 1 within a period of 1 week from the date of from the receipt of copy of the order. Give this by tomorrow. Give this order by tomorrow.
Great.
Within a period of 1 week from the date of receipt of the copy of the order. Yes. No
Please.
notice is issued to the respondents as no adverse orders are passed against the
Number
respondents.
5, yes, Kalyan Basavaraj.
Electricity connection was disconnected. Electricity was disconnected. I was before this court on the previous occasion. Kindly go to page number 35, my lord.
Please serve the notice on them.
There is a threat. Kindly see the order passed.
Take it up at 2:30 so that they'll get some instruction. That's the
Bescom,
way
Bescom.
Bescom. Mr. Devaraj is directed to take notice. No order is required. Please serve the papers on him.
Please.
Tell him that I'm taking up at 2:30.
Please.
By that time, you should get instruction.
Please.
Yes.
26 order, 27. Tell number 27, Narendra Babu BK.
Petition in this matter,
Ishan
please.
Praketa.
I appear for the Please. caveat, I respond.
Yes.
The petitioner has filed an application order 6 rule 17 for amending the plaintiff, please, my lord.
You're the plaintiff. What is the suit for?
Suit for mandatory injunction
When was the suit filed?
towards the is in the 2019, please, my lord. Towards the western side of the property
What is
belongs to the
present
defendant,
stage?
my lord.
What is the present stage?
Now it is posted for evidence.
Evidence.
Evidence is not yet started.
Please come to the IA application.
Please.
Page number?
18 minutes. Page number 18 is the IA, please, my lord. The facts are like this, please, my lord.
Not required. Please come to the application. I'll read from the application.
Please.
Where is that affidavit that's filed in support of the application? Please come to page 21.
Please. Para 3, I submitted at the time of filing this case, I was not aware of the sale deed dated 5/9/2019-07. I came to know about it only when the defendant produced it before this honorable court. After verifying the said sale deed, I came to know that about the correct measurement of the defendant's property is 23 feet in width. His vendor sells him 25.5 feet is highly illegal. It needs to be annulled. This fact is very important, which needs to be brought on record. I further submit that the sale deed of the defendant clearly shows that only the land and the house of the vendors are sold to him. Western wall of the suit schedule property is not conveyed to him. I further submit that the defendant has himself admitted in his written statement, para 20, para D, that the building in the SSP is constructed by by my father about 25 years ago. After demolishing the old house building, this by itself is an admission that the western wall of the suit schedule property exclusively belongs to me and my family and not to the defendant. I further submit that after demolishing his portion of the house, the defendant has no right to touch my western wall or damage it. He is also bound to follow the municipal setbacks rules by leaving 3.5 feet space between my wall and his building. And he starts the construction at this stage. I submit that I have a very good case on
I've
this.
seen. Please come to the order.
Oh, yeah.
Para 8.
I have gone through the records on the case and the same discloses that the present suit is filed by the plaintiff for mandatory injunction seeking directions to the defendant to restore the construction structure common wall measuring 24 inches width, 85 feet in length and 30 feet in height for damages, seeking directions to the defendant to pay compensation of rupees 10 lakhs for illegal demolition of the portion of the suit common wall, etc. The defendant has filed his written statement to the plaintiff hereby denying his claim. The court has framed necessary issues on the pleadings and now the case is posted for plaintiff's evidence. Such being the case, now the plaintiff has come up with the present application seeking amendment of his claim as per the proposed amendment. Perusal of the proposed amendment revealed that the plaintiff intends to add some paragraphs in the plaint to the effect that the purpose of purchase of the property by his
The amendment, what he is seeking is basing on the written statement and the documents filed by you.
Please, my lords. My lords, in the plaint, he has taken up a contention that it's a common wall. My lords may kindly see the pleadings in the plaint.
No, you do not deny what has been stated by him now because your own document speaks about it.
There are three things here, my lords. One, he says he came to know about these facts after I filed my written
Document of 1906.
Please, my lords.
Which is filed by you.
Please.
Which
I
is
have
not
filed
in
it
his
on
person.
2/1/2021. This application, my lords, is filed on 19/11/25 after a delay of 4 years.
No, that is, but what is the prejudice that will be caused to you? Because that is based on your document. Now, the trial, though the issues are framed, no doubt, but the actual trial has not begun.
He has taken about 13 dates, my lords, to lead evidence, but he has not led evidence.
No, we will say, we'll allow this application and we'll say that the
Speedy
any delay
disposal.
on his part, then
We are
the
ready.
court shall not grant unnecessary adjournments to him.
I may be permitted to file additional.
You can.
Please.
Please come. Agreed with the order dated 25/3/2026 in I number 8 and OS number 180, 133 of 2019 by the senior civil judge and principal JMFC KJF Kolar. The petitioner plaintiff is before this court. The plaintiff herein has filed a suit for mandatory injunction in the year 2019. When the matter is set down for the evidence at that point of time, the present application came to be filed under Order 6, Rule 17, seeking amendment of the plaintiff. It is a case of the plaintiff that At the time of filing of the case, he was not aware of the sale deed dated 5/9/1907. He came to know about it only when the defendant produced it before the court. After verifying the said sale deed, he came to know about the correct measurement of the defendant's property as for 23 feet in width. His vendor selling him 25.5 feet is highly illegal, and he wanted to amend the written statement basing on the subsequent aspects that came to his notice after the written statement is filed along with the documents that came to be rejected by the trial court by order impugned. While dismissing the application, the court has observed that a perusal of the proposed amendment reveals that the plaintiff intends to add some paragraphs in the plaint to the effect that after purchase of the property by his great grandfather in the year 1907, there was a partition in the year 1993, and after the partition, Raja Adinarayana Setti erected a lengthy wall separating his property. The plaintiff also intends to seek additional relief, seeking declaration that the western wall of the suit exclusively belongs to the plaintiff, in addition to seeking prohibitory injunction to restrain the defendant from touching or using the said wall as common wall. Thus, from this, it is clear that the plaintiff intends to take inconsistent plea in his plaint, inasmuch as he has already he has a pleading in the plaint. The suit wall is common wall between him and the defendant, but now by way of amendment, he intends to plead that the suit wall exclusively belongs to him. However, such inconsistent pleas are not permissible in the plaint, and accordingly dismiss the IA. When counsel appearing for the petitioner submits that, basing on the documents that are filed by the defendant, the plaintiff has come up with this with the present amendment, and no prejudice would be caused to the defendant, only on the ground that, as it is specifically pleaded that, as that document is not in possession of the plaintiff, he has taken the earlier plea. Now the very document relied on by the defendant makes it clear about the measurements and all. It is submitted that the court has to, while allowing the application for amendment of plaint, court has to look at the substantial interest of the parties and should not dismiss the same on technicalities. When counsel appearing for the respondent submits that the suit is of the year 2019. He has filed a written statement in the year 1920
2121.
on 20 in the year 2021. From 2021 till 2026, when this
19/11/25 is the date of the application.
Till 19/11/2025, the plaintiff has kept quiet. In fact, it is submitted that he has been dragging on the matters, and he has taken 19 adjournments.
13 adjournments, madam.
What?
13
For?
for leading evidence.
13 adjournments for leading the evidence. It is submitted that this clearly shows that only with an intention to protract the proceedings, the petition is coming up with these kind of, the petitioner plaintiff is coming up with these kind of applications. The court has rightly dismissed the application. Next part. Having heard the counsels bring the side, peruse the material on record. The whole basis for this amendment sought by the plaintiff is the written statement and the documents that are filed by the plaintiff, filed by the defendant. Basing on this additional pleadings are sought. It is also an aspect that it is also a fact that these documents are placed on record in the year 2021 until 2025. The petitioner plaintiff has kept quiet. It is also from the submission of the learned counsel for the defendant, it appears that he has taken 13 adjournments to lead the evidence, which prima facie shows that the petitioner plaintiff is trying to protract the proceedings. But at the same time, the court cannot lose sight of the fact that these amendments are very much necessary in the light of the documents that are placed by the defendant before the court. And no doubt, no prejudice would be caused to the defendant if this amendment is allowed. However, for the delay and laches on the part of the plaintiff if the, on,
Let it not relate back to the filing of the suit, my lords. Let it be allowed from the date of the application, the amendments. The amendment, my lords, if my lords, let it not relate back to the date of the filing
how
of the
does it matter?
My lords, he was aware of it for 3 years, 11 months, my lords. I have that defense to take regarding the
It's
delay.
on a document of 1907.
I understand, my lords, but he has slept over the matter.
Not the case for that. I can understand the case of some limitation, say leaves and all, then it's a different aspect. The on costs, the delay, the same can be balanced. In that view of the matter, this court is passing the following order. The order dated so and so, passed and so, dated so and so is set aside. And consequently, I number 8 is allowed. The defendant is at liberty to file the additional written statement. Number 3, for the delay on the part of the plaintiff in filing this application, the plaintiff shall pay an amount of 10,000 cost the respondent, defendant. Petitioner or plaintiff shall not take unnecessary adjournments.
28.
Much.
There are DS for petitioner, B Lokesh for Kevita.
You for the petitioner, my lord.
Yes.
Petitioners are the
There is
defendants.
a caveator, is this served?
We have served 2 weeks ago, my lord. My lord, the plaintiff, the respondent, was the plaintiff in the trial court, had sought for bare injunction against me. The plaintiff in her plaint has said as follows, my lord. Please see page number 1.
What is the suit for?
Suit is a bare injunction.
And what is the IA, present IA?
What?
What is the IA?
The IA was for injunction in the trial court. Trial court granted injunction. First appellate court granted injunction. Though much before the appeal was filed, she herself files a police complaint that they have sold the property to me. We have formed a layout. We have sold it to various other people. One of the purchasers has filed a suit against the present respondent and obtained an order of injunction. The learned trial judge holds that as a circumstance against me. That suit, which is in fact clearly shows that they are.
Both the courts have granted injunction in favor.
Yes.
Let's see the appellate court's order.
Yes. Page number 68.
Yes.
According to the plaintiff, he is in possession of the suit scheduled property. According to the defendant, entire property measuring 2 acres 24 guntas in survey number 144 was sold in its favor by family members of the plaintiff. That is, the mother-in-law and husband of the plaintiff sold it to me. Sale deed executed in favor of the defendant is placed before the court, wherein it clearly stated that 2 acres of land in 144 Coppa Valley is sold in favor of the defendant.
It is of the year.
Pardon?
Your sale deed is of the year
2005.
2005.
Sale deed includes entire 2 acres 24 guntas. In the sale deed, schedule given is in common boundaries to all properties in survey number 142, 43, 44, 152/5. In the sale deed, it's clearly stated only 2 acres in survey number 144 was sold. The defendant contended that in the advance sale receipt, it's clearly stated that 2 acres 24 guntas was sold, but because of technicality, it was not stated in the sale deed. No doubt in sale advance receipt, it is stated that the vendors agreed to sell 2 acres, but 2 acres was sold. It admitted that survey number 144 was converted for non-agricultural purpose by the husband of the plaintiff and mother-in-law. During conversion was made only for 2 acres. Sketch attached to conversion order established as 2 acres of land was converted to non-agricultural purposes. As admitted by the defendant, they never made conversion. Conversion made only 2 acres. According to the defendant, he formed residential layout in 24 guntas and sold the property. Documents placed by the plaintiff show that 24 guntas was not converted to agricultural property. When property was not converted, how is it possible to form a residential layout in agricultural property? According to the defendant, he is in possession of 2 acres, 24 guntas. RTC produced 24 guntas standing in the name of the plaintiff. Sale deed executed in favor of the defendant shows that 2 acres was sold in favor of the defendant. Conversion order sketch shows that in 2 acres, 24 guntas, 2 acres was converted. On the basis of the documents produced, it is not possible to conclude that the entire property was sold in survey number 144. Survey sketch and revenue entry discloses possession of the plaintiff was scheduled property, and 24 guntas were retained by the husband of the plaintiff. Now, my lord, please see the plaint, page 173.
So on all the documents, it's only 2 acres.
Pardon?
On all the documents, it's only 2 acres. But only on the sale agreement,
There are
it is
two-
2 acres, 24 guntas.
But there were one small portion of 24 guntas, then 2 acres. Boundary difficulty, they said 2 acres. But problem point remains is that the whole thing was sold, sites were formed. There was,
That's sold.
no, I'll show what happened was subsequently, I sold it also. Subsequently, one of my purchasers, please see page 156.
My question is, you can say that you're owner of the 2 acres, 24 guntas basing on a sale deed.
Yes.
Your sale deed is.
So let's say, let me take it as 2 acres. I've sold 2 acres. Now, where is the, then what happens is I form the layout.
So the suit is for what extent?
I'll show you.
Plaintiff's injunction is in respect of?
Where is the suit is now for 170, page number 175. Please read in this plaint, please read page 8, para 8, my lord, at 175. They admit that I own 2 acres.
No, there is no dispute on that. No, it's about, that's why I'm asking. Injunction is in respect of 24 or?
My lord, there's one more submission. This is the problem, my lord. Please see 2 acres, 24 guntas. Schedule says 0.24 guntas. My lord, there's worst of difference between 24 guntas is half an acre, my lord. 0.24 gunta is 1/4 of 1,890 square feet. Because the whole the area has been sold. Now what happens is, this is what they do. Then they go after somebody, disturb somebody's possession. Some buyer goes and files a suit. He gets an injunction. They keep on going like this. My lord, the position is today the caveator is not there, though we served. But let the parties maintain status quo. Your lordship may call. See because what happens is, my lord, I am not.
I have to be convinced.
Yes, please come to. I'll show your lordship. Please come to page number 265. There's a Kannada complaint given by them in Tagoli. Son of the plaintiff was given. I got the English translation also here. Page 265, 260, 265, 266, 267. Lordship has that, my lord, 7 to 25. Please come to the second page. This relates to encroaching upon 24 guntas of our ancestral land in survey number 144. Now please come to the second page. The survey officials issued 2 notices on 2 occasions directing the company to produce the relevant title documents. Company's advocate failed to produce. Taking advantage of the situation without our knowledge, the company has unlawfully encroached upon our ancestral property, formed a layout, constructed houses, thereby causing interference. Well, this is clearly, they themselves admit much earlier in point of time that houses also have been constructed on the 24 guntas. Today, making use of some technicality, they are saying 24 guntas, which is about 30,000 square feet.
Unfortunately, it's not a technicality. It is when you are.
But when when their own admission that they should have taken a declaration.
It will not give you 2 acre 24 guntas when you purchase 2 acres.
Pardon, Mala?
You purchase 2 acres by way of a sale deed. You have converted 2 acres into non-agriculture land.
Yes.
So you have 2 acres. If you do something about 24, whatever their complaint and all, it will not come to your.
Well, one submission is, if that be the case, if that be the case, a bare suit of injunction was not maintainable. But a bare suit for injunction, and when you yourself admit that you are not in possession, injunction is that I should be in possession for me to get injunction, irrespective of title. I'm entitled to injunction if I'm in possession. Here, you yourself admit in February of 25 that I have entered, formed a layout, put up construction. But once you admit that much, but title is now becomes one issue. Tomorrow, if you are entitled to title, you take back title. But my possession is to be protected. Even if I don't have titles, I would go to that extent. Even if I don't have title, my title is to be protected because settled possession, I have made layout, I have done it. They have not chosen, they have admitted that yes, he has made a layout, he's constructed houses. Yet they choose pay 25 rupees court fee and file a suit for injunction. This is the position, Mala. It's not that we are shying away from proving anything.
The caveator, please inform him. I'll take it up at 2:30 so that I'll dispose of the writ petition. Will not keep it pending.
Very well. My lord, there is an injunction order as against the respondent by one of the purchasers. Please see one, just for my sake, my lord. Please see 175. Please see 175, 171. One of the people who purchased from me had filed a suit against the respondent in respect of the same survey number 144/1, restraining till next date of hearing. He is also granted an injunction. I produced the plaint also.
Let him be there, I'll dispose of.
Yes.
Yes, next.
Cell number 29.
Call this matter at 2:30,
PM Sidmalappa, petitioner.
along with the other 2:30 matter.
This
Ramesh.
case, appear for petitioner, please. The plaintiff writ petition, please, Lordship. The plaintiff filed the suit for permanent injunction against the respondent. The trial court, considering the order 39 rule 1 and 2, granted the interim order. The respondents filed the appeal before the first appellate court in MA number 29/2025. The first appellate court reversed the order of.
Let's see the order of the appellate court.
I request this honorable court, please, Lordship.
Page
In
number?
page number 146, it is comments reason. The admitted facts, please, Lordship. Site number 75 as the.
We'll read the order, then you can make your submission.
Please, Lordship. It is a 146, running page.
Please come to 148.
148.
Reasoning part.
I request para 14, please, Lordship. In 147.
The facts are there in 13.
I can read the facts, please. The one Sri Krishnappa was the owner of the suit schedule property. He sold the suit schedule property to one B.S. Srinivasa. The plaintiff has purchased the suit schedule property from one B.S. Srinivasa through a registered sale deed dated 21/9/1999. From the sale deed, the plaintiff has been in peaceful possession and enjoyment of the suit schedule property. When such being the case, having no manner of rights, the defendants interfere with the peaceful possession and enjoyment of the plain scheduled property. Through the plaintiff has lodged the complaint before the police. The police has not taken any action. Hence, the plaintiff has filed the present suit. Along with the suit, the plaintiff has filed an application under section 39 rule 1 and 2 of praying to restrain the defendant from putting up construction in the plain scheduled property till the disposal of the suit. The defendant, after appearing, they filed the written statement contending that the plaintiff has not approached with the clean hand. The plaintiff has not described the suit scheduled property by giving a proper boundaries. The defendant are the owner of their own property. There is a dispute with the respect to the identity of the suit property. The defendant, after obtaining the sanction plan from the competent authority, they have been constructed a house in their property. Hence, the defendant prayed for to dismiss the application as well as this suit. The reasoning, please, Lordship, in page number 146, para 13. Before saying anything on the controversial facts between the parties, it is just and necessary to narrate the admitted facts by the parties. It is an admitted fact that the plaintiff is the owner of site number 75 and the defendant are the owners of site number 77. It is also an admitted fact that once Sri Krishnappa was the owner of the suit schedule property and Srimati Ramaka is the owner of site number 77. Sri Krishnappa died intestate, leaving behind Sri Jairama and Gopala. They sold the suit schedule property to one B.S. Srinivasa through a registered sale deed dated 13/3/1995. In turn, B.S. Srinivasa has sold the suit schedule property to the plaintiff through a registered sale deed dated 21/9/1999. It is also an admitted that the defendant one is a legal heir of Srimati Ramakka, who was the owner of site number 77. It is also an admitted fact that in between the site number 75 and 77, there is
I have read the order. You can make your submission.
Yeah, I request this honorable court, in page number 77, please, Lordship. I have produced the layout plans. Layout plan. It is a site in page number 77, annexure G, please, Lordship.
Yes.
I request this Lordship, third roll, the 77, 76 and 75 sites was.
77 is your.
Not 77 is not mine.
Which page?
77, page number 77.
Page number
Annexure G, please, Lordship.
Page number 77 is your application before the appellate court.
78.
79 is some plot numbers are there.
Sir, it is a 79. I'm sorry, Lordship.
Yes, yes. Which plot, which number?
It is a serial number, third line, please, Lordship.
Hmm.
That's 77, 76 and 75 is shown. 75 is mine.
77
76,
and 75.
75.
Yours?
In between 75 and 77 is in between 76 site is there. My humble submission, please, Lordship. The first appellate court,
Defendant is owner of 75.
77. I am the owner of 75.
Hmm. And what is your case?
My case is, I am in the owner of the site number 75. He is trying to put up a construction in my property. I am nowhere concerned with respect to site number 77 is concerned.
What is happening in 70, in that 76?
76, one Ali Saab is there, please, Lordship. He is already in physical position of the property. He has constructed the house and he is
He
staying.
construct in your house, leaving away in between the, I can understand yours is his property is an adjacent property.
No, it is not adjacent property.
How can
One
it-
property is in between me and the defendant property.
In your property, already the building exists is what is.
That is a version the first appellate court wrongly come to the conclusion. I have not constructed any building in my property. The trial court rightly appreciated with regard to my position is concerned, please, Lordship. I request, please, Lordship, para 40.
You're ready? Then what are you doing?
Senior counsel is 2-3 days urgent.
No, 2-3 days. Caveator is not entitled. You want to argue, argue. Otherwise, I'll grant interim order and then whenever it's convenient to you, you can argue.
Senior counsel not for your.
Caveat is not for adjournment.
I request order for para 14 of the first appellate court order, please. It is a totally contrary to the sketch what I have produced. The first appellate court wrongly come to the conclusion that there is a adjacent property of plaintiff and defendant property.
Please come. Then comes with the petitioner submits that the trial court has granted injunction and the appellate court, contrary to the material on record, has set aside the order of injunction. It is submitted that the findings of the court are contrary to the evidence on record and the pleadings of the parties. Then counsel appearing for the caveator defendant has sought for time. Next, considering the fact that already an injunction is granted by the trial court and considering the submission of the learned counsel with regard to on the findings of the appellate court, the party shall maintain status quo. This is matter on 12th of August. Yes, next.
Grateful.
Cell number 30 for admission matter 30. R.S. Rajesh.
Yes, I appear for the petitions.
Yes.
Here, the suit was filed for partition, challenging the alienation done by the father in the year 2005. One of the daughters claims to challenge the suit claiming for partition.
What is her age? What is her age? Age of the
Age,
daughter.
she was 15. In 2005, she was 15.
Hmm.
And she should have challenged if any, it's an undivided right so of the property moreover. The father himself was one of the joint owners who purchased the property. And the daughter claims it was sold in favor of 85 persons having formed the sites. In the year 2021, when she was aged about 15 years,
Come to the order, we'll see.
page number 26 to 155.
Where is the discussion about all this?
Mala.
Where is the discussion about all this? Court officer.
Discussion.
Huh?
Discussion about the.
Discussion, the 26 to page number 26 to 155. The discussion is about.
Yes.
Yeah. Says rejection of the plaintiff.
Please come.
Reasons.
Learned counsel for the petitioner submits that the suit is filed for partition and also seeking the cancellation of the sale deeds which were executed in the year 2005. It is a case of the plaintiff that she was 15 years old when the document executed in the year 2005, and the suit is filed in the year 2021, which is miserably barred by limitation. And these aspects were when the petitioners filed an application under Orders 7 to 11, the court has failed to appreciate the same. And court, just by the discussing that how when a plaint can be rejected, without going into the merits of the matter, had dismissed the application, considering the submission of the learned counsel for the petitioner. There shall be stay of all further proceedings. Pursuant to the order dated, memo to the notice. In addition, hand summons of the counsel appearing for the respondent. Memo shall be filed in that regard by 28th, or else the stay granted by this court stands vacated.
Cell number 31. Girish, yeah.
Petitioner.
Yes.
Defendant's petition, my lords, revision petition. The my lords, the petition is, my lords, challenging, my lords, order passed by the trial court, my lords, under order 7 rule 11 of CPC.
What is the suit for?
Suit fees for, my lords, declaration, my lords, to declare that, my lords, the plaintiff is the legally wedded wife of one deceased Vinay AR, my lords. The facts of the case is that, my lords, my lords, the petitioner, my lords, is the first wife of, my lords, the said Vinay AR, my lords. In the year 2020, my lords, the said Vinay AR, my lords, has filed a divorce petition, my lords, and the petitioner has appeared, my lords, did not file any objection. Accordingly, my lords, the trial court, my lords, has passed the decree of divorce in favor of, my lords, the husband. My lords, in meantime, my lords, within appeal period, my lords, the petitioner has appeared before this honorable court and filed a MFA, my lords, and got the interim order of stay of the decree of divorce. My lords, in meantime, my lords, on my lords, in the year 2024, my lords, the said Vinay AR, my lords, got died due to health issues, my lords. In the year 2025, the plaintiff, the present plaintiff, my lords, came before the trial court and filed, my lords, suit for declaration, saying that, my lords, she is the second wife of said Vinay AR, and also sought for, my lords, declaration saying that, my lords, she is the legally wedded wife of the said Vinay AR, my lords. Kindly see, my lords, the plaint, my lords. In the plaint, my lords, she has admitted that, my lords, the petitioner is the first wife and got decree of divorce. In meantime, my lords, she has also mentioned about the MFA and interim order passed in the MFA, my lords. Kindly see, my lords, plaint, my lords, page number 17.
To that MFA.
My lords, MFA is still pending, my lords. The, my lords, interim order in the MFA, my lords, kindly see page number 50, my lords. Sorry. 40, my lords, Annexure B.
Why she cannot maintain the suit?
Please, my lords.
Why she cannot maintain the suit?
Because, my lords, there is no cause of action, my lords. As, my lords, she admitted that, my lords, I am the first wife of the said Vinay AR, my lords. During pendency of appeal, my lords, she got married, my lords, the said Vinay AR. As per section 15 of Hindu Marriage Act, my lords, during pendency of appeal, my lords, if the marriage happened, my lords, that came to be, my lords, the void marriage. It has to be considered as a void marriage. My lords. Kindly see, my lords, section 15 of Hindu Marriage.
Not necessary. Yes.
Please, my lords. One more thing is that, my lords, under section 7 of Family Courts Act, my lords, declaration in a suit for declaration in respect of any marital status, my lords, is has to be before family court, my lords. She has filed, my lords, the suit before, my lords, civil court, my lords. Under two circumstances, my lords, I have filed the present application of 7 rule 11, my lords.
Come to the order.
Order. Kindly see, my lords, page number 50, my lords, Annexure D.
Yes.
Reasoning, my lords, at page number 58, my lords. May I kindly read?
When was the judgment and decree?
Family courts. Kindly see, my lords, the
You can give the date.
date I will. 7th March 2022, my lords.
When did you file the appeal?
Appeal, my lords, on 4th, I have filed, my lords, 4/4/2022, my lords, MFA before this honorable court. Within appeal period only, my lords, I filed the appeal and got interim order within appeal period only. Lord, section 15 specifies that, my lords, even though there is no interim order, if the appeal is pending, the marriage is, my lords, considered to be a void marriage.
For that, the court has to pass an order.
For that, my lords, kindly see, my lords, plaintiff, my lords. She herself has admitted the, my lords, facts about the
Come to your affidavit.
application.
Yes, application, affidavit in support of the application.
Please, ma'am. Page number 42, my lords, is the affidavit supporting the application. Para number 2, 42. I mentioned about the section 15, my lords, and also about the section 7 of the Family Courts Act. In para number 4 and para number 6.
Whether when was the stay granted and all, were there in the plaint? Did she mention about the stay granted in MFA?
Please, my lords. In the plaint itself, she has mentioned about the stay granted by this honorable court. Plaint, my lords, page number 17, para 5 of the plaint, my lords, page number 18, my lords. 18 and 19. It is submitted. May I kindly?
Please come. The petitioner has filed an application order 7 to 11 on 2 grounds. As per the averments made in the plaint, the marriage is a void marriage, and further the court has no jurisdiction to entertain the suit. And the suit has to be entertained only by the family court. It is submitted. It is a contention of the counsel for the petitioner that all these aspects were not considered by the court. And the court had, without giving proper reasons, had dismissed the same. Considering the same, they shall be stay of all for their proceeding. Invoice number so and so, same notice. In addition, and summons memo shall be filed by 29th July, or is a stay granted with this court's transvocate.
Number 32. For petitioner.
No representation in the month of September.
Till number 33. PP Rajendra Kumar Sungay for petitioner.
Suit for partition, my lords.
Ashok Kumar M.
For short accommodation.
There is an interim order.
There is no interim order. I have no objection for it to be decided finally, but there's some urgency because evidence is on 1st of August. So before that, if my lordship
What is the ground?
No cause of action, suit of partition filed by them, admitted documents of title produced along with the plaint clearly shows that I am the absolute owner. There's already a partition entered into in 2011. One is no cause of action. Second ground is barred by limitation because from 2011.
Come again. What is the suit for?
Suit is for partition, claiming that my property she's entitled to half share. 2 grounds. One is that is my sole property. Already registered documents of title, including partition deed, have already been executed, and that property is mine. Second ground is it is barred by limitation because all of these registered documents of title was in 2011. Now they have filed the suit in 2024. So those are the 2 grounds, my lords. Because along with the plaint itself, they have produced all of these documents: partition deed, sale deeds, all of them show the property in my name.
We'll hear it finally.
It can be heard.
Counsel for the petitioner submits that the order 7 to 11 application is filed on the ground of limitation.
Cause of action.
And there is no cause of action. It is submitted that all the sale deeds are of the year 2011. And the
Partition deed.
Suit is filed.
Suit is filed in 24. Partition deed is 2011. Already partition.
Deed is of the year 2011. Sale deeds are of the year.
Sale deeds, my lords, from 2000 and there are multiple sale deeds from 2012 onwards till 2019.
12 to 19. And the suit is filed in the year 2020?
24.
2024. And all these aspects were not considered by the court. Considering the submission, they shall be stay of all further proceedings. This is matter on 19th of August. Yes, 34.
34.
Great.
Giving Verma B for petitioner.
And for the petitioner, Your Lordship, being agreed by the order of the trial court with respect to order
Why
7
the memo is given for the case?
Lordship.
Oh. No, but the memo is given. What is the urgency that is put forth?
Today it is posted for evidence, Your Lordship. Yesterday I
When
had
was this
moved-
order passed?
Your Lordship,
When was this order passed?
in the sense,
Impugned order is passed when?
impugned order was passed. Kindly look into the order sheet, Your Lordship.
You can tell the date. I don't have to look at the order sheet to tell the date.
Was 15/11/25, Your Lordship. 15th November of
15th
2020.
11/2025.
The
And
suit-
for that urgency yesterday to list this matter
No,
today.
Your Lordship. Already this matter was heard before the coordinate bench. Then the matter was posted for, and notice was issued to the opposite party. We have served the notice as well. After that, even last week, I had moved a memo. This honorable court told me that your
But
matter is
for
on 14.
6 months you were waiting. And now then you will say like the matter is posted for evidence. If
No,
6
Your
months you keep quiet, the matter will be
Already-
posted for evidence.
Already this was posted before the coordinate bench and the matter was pleased to
Yes,
issue
come
the
to the
notice.
application and order
Yes.
7 rule 11. Where is it?
Yes. Your Lordship, Annex G may be looked into, Your Lordship.
Page 62, come to page 62.
Page 60.
62 is the affidavit.
Yes. Yes, Your Lordship. Here, Your Lordship, before going into the application, the facts may be looked into, Your Lordship. Because,
Let me read this.
yes. Yes. Now, looking into the facts of the
Oh,
case.
you are raising two grounds. One, you say that she is not the legally wedded wife. First defendant is a legally wedded wife. It's a question of fact which has to be decided during the course of the trial.
Indeed.
Then what are the other two grounds?
The other ground being during the lifetime of late Sanjeeva Rai, who is the owner of the property, he transferred these properties in the year 2005 in favor of the defendants.
Who said this fact?
So I stated the fact.
Your fact you stated
Yes.
can
Along
be a
with-
basis for the court to consider the application under order 7 rule 11?
Your Lordship, after I filed the written statement, an additional written statement was filed by the plaintiff in the form of replication, where he has disputed those documents, saying that it is insufficiently stamped.
But while considering an application under order 7, court will consider the plaint and the documents filed. No other documents will be looked into.
Even the replication file has to be looked into, Your Lordship. That
Then where are the documents?
documents I had filed it, and he has.
Again, you're going to the same point.
Yes.
You have filed. Why will the court look into your documents?
Yes, but the same document is disputed by the plaintiff.
So mere denial is sufficient without even looking at the document. The document is not filed along with the plaint.
No, it was not filed. But later on in the replication, kindly look into the replication that has been.
Replication, by replication, that means that the document is part of the plaint? Plain document?
No, but
Come to the order. I understood your argument. Please come to the order.
Your Lordship, page
Very
number
sorry.
70 may be looked into, the reasons. The suit is for partition. In an application under Order 7, Rule 11, it is held in Ketanov decision by the Honorable Supreme Court that only the plaint has to be looked at. On perusing the plaint, it clearly discloses cause of action, and also a prima facie does not appear to be barred by law. The defendants have claimed the suit is barred by law, but they have stated that any provision under law which the suit is barred, and they have included this under Section 9 of CPC. The presumption is in favor of jurisdiction. This is not pleaded over there. From the affidavit annexed to the IA, it becomes clear that the contention of the defendants is because the plaintiff has not sought the declaration relating to the settlement deed. The suit is barred by law. In a suit for partition, the relief of declaration that settlement deed or sale deed is not binding is not necessary relief to be sought by the plaintiff. The reason being that the validity of this said deed is dependent on the outcome of this suit. Your Lordship, kindly look into along with that replication, he has also filed a settlement deed that was filed by the plaintiff, where it clearly shows that he is only the adopted son of Vedavati, not the adopted son of late Sanjeeva Rai. So this material fact was suppressed.
According to them, Sanjeev Roy has, she's a wife of Sanjeev Roy. That property is devolved upon her after his death. And he being the son of, adopted son of that Vedavati, he is entitled for the properties.
But kindly look into that document. I've produced the document along with that. The document states that even in that document, this Vedavati Rai does not claim that she is the wife of Sanjeev Rai.
These are all disputed questions of fact. How do you expect the court to look at it in order 7 to 11?
And Your Lordship, this being the absolute property of Sanjeev Rai, during his lifetime, he had every right to transfer the property.
He has transferred it to you.
Yes.
It is a matter of written statement and the documents filed along with the written statement.
Yes, but this is cunningly, they have not looked into that.
That is what it is. Why the plaintiff will,
Because it will
plaintiff will
attract the
say something
declaration.
which is convenient to you.
Your Lordship,
Please come. Yes.
Your Lordship,
pass on.
I may be permitted to produce a citation with respect to this,
I'll record, take that.
where a registered document becomes a constructive notice.
Yes. All that will not be decided under order 7 to 11. The present, pass on the paragraphs you mark, I'll record. The present petition is filed.
Para 13 may be looked into.
Yes, the present petition is
Already
filed.
stated in that.
Agreed with the order.
Even in this same suit, Your Lordship, the matter in contention, the property was partitioned before filing the suit. There also the same contention was taken, and the court said that
Please
once it is
understand. You have
partitioned,
to understand the legal position, isn't it?
yes, kindly look into the.
What is it? What judge? Any judgment with the no judgment will lay that kind of a proposition. Don't have to look at it, but I'll still record it.
Okay.
You say something you have filed along with the written statement. According to you, that Sanjay Roy has bequeathed the properties in favor of the defendants.
By virtue of
That
the
is your
settlement.
case.
Yes.
That is not the plaintiff's case. And the documents are your documents. How will they be looked into under order 7 to 11?
No, it forms a constructive notice, Your Lordship, to the defendant also, to the plaintiff also. That is what is stated in the judgment as well.
If I have to tell you what is law on order 7 to 11, then
Yes.
then it is difficult for the court.
Yes, once it is
I
bequeathed.
will record your reason. I understood.
Yes.
I will record your contentions
Yes.
and I will record the judgment and then I'll pass order.
Because it is an absolute property, then it does not take the form of a partible property.
That is under order 7 to 11, Mr. Counsel.
No, Your
Be
Lordship,
considered.
in a partition suit, in a Hindu family, it has to be a joint family property. So once there is no joint family property.
Ultimately,
where is
your
the
submissions all revolved around the same fact. That I will record, I'm saying.
Yes.
Repetition is not required. An application is filed. The petition is agreed by an order passed in I number 7 in OS number 8 of 2020, dated 9/10/2025, whereby the court had dismissed the application filed under order 7, rule 11 AB of CPC. This is on the file of the senior civil judge ACGM Puttur. The respondent herein has filed a suit for partition. In that, the present IA came to be filed by the defendant under Order 7 to 11. In the affidavit that is filed along with the IA, it is stated that where is that affidavit?
Page number 61, I believe.
In the affidavit, it is
Page number
stated that
62.
the plaintiff has filed the suit for partition of the properties of Sanjeev Roy. The contention of the plaintiff is that he is a son of Vedavati Roy, who is a wife of Sanjeev Roy, and as such, Vedavati Roy, as wife, inherited the properties of the husband, and he, being the son of Vedavati Roy, has got 1/5 right, along with defendant number 1 to 4. According to the plaintiff, the first defendant is not the legally wedded wife of Sanjeev Roy. Instead, she lived like a kept mistress, due to which defendant number 2 to 4 were born to them. Hence, the plaintiff also sought a 1/5 share. It is a case of the defendant that the plaintiff is not the son of either Vedavati Roy or Sanjeev Roy, and as such, he has no right in the properties of Sanjeev Roy. Apart from the same, during his lifetime, Sanjeev Roy, during his lifetime, has transferred the properties to the defendant by executing a registered settlement deed dated 19/2/2000, registered at the SRO of Puttur, and same is produced along with the written statement, and accordingly RTC is also entered in their names. Therefore, question of inheriting the same by Vedavati Roy does not arise. Therefore, the suit is barred by limitation. It is a case that the first defendant is a legally wedded wife of Sanjeev Roy, and defendants number 2 to 4 are their children. That is, I said 27/1/2010. Settlement date is what is the date that 19 to settlement date dated?
19 to 2005.
2005.
Since 20 years, they've been enjoying
He
the
has transferred the properties to the defendant by executing a registered settlement deed dated 27/1/2010, and the same was registered before the SRO. Basing on these grounds, they've sought for rejection of the plaint. The trial court, by order impugned, had dismissed the application. While dismissing the application, the court has observed that no under which provision of law the suit is barred by the court observes that on a perusal of the plaint, it clearly disclosed the cause of action, and also prima facie does not appear to be barred by any law. They have stated that the suit is barred by law, but they have not stated any provision or law under which the suit is barred. In a suit for partition, the relief of declaration that settlement deed or sale deed is not binding is not a necessary relief to be sought by the plaintiff. The reason being that the validity of the sale deed is dependent on the outcome of the suit. Hence, the court has held that there are no grounds to reject the plaint and accordingly dismissed. Next parallel, counsel appearing for the petitioner submits that has submitted in line with the state amendments made in the affidavit, and further it is submitted that the defendants are the sons of Sanjeev Roy, and even it is stated that the plaintiff is not the adopted, is not the son of Sanjay Roy. In fact, he is an adopted son of Vedavati Roy. When all the properties belonging to Sanjay Roy are settled in favor of the defendants who are the children of Sanjeev Roy, question of partitioning those properties should not arise. It is submitted that along with the written statement, they have filed all these documents to show that the document to show that the property is settled upon the defendants. Further, it is submitted that this is a registered document, and section 3 of the TP Act says that there is a constructive notice to the parties hence the same is barred by, hence the suit is barred by limitation. He relied on a judgment of the apex court in case of Uma Devi and others versus Anand Kumar and others, reported in 2025 SCC 198. He relied on paragraph number
13.
He relied on paragraph number 38. Extract that. Relying on this, it is submitted that on these counts, there's no cause of action. The suit is barred by limitation, and the plaint has to be rejected. Next part. Having got the land counts for the petitioner, peruse the material on record. The suit is for partition. The plaintiff claims that he is entitled for partition as he is the adopted son of Vedvati Roy, who is the wife of Sanjeev Roy. And after his death, the property devolved upon Vedvati Roy, and he being the adopted son, he is entitled for the property. According to the defendants, Vedvati Roy is not the wife. In fact, first defendant is a wife of Sanjay Roy. And during his lifetime, by way of documents dated 2005 and 10, he has settled these properties in favor of the defendants who are his children and wife. And according to the petitioner, as this is a registered document, which is in the name, which is, as it is a registered document, it is in the constructive notice of the public, and a suit is filed in the year
2020, Your Lordship.
20, and the same is barred by limitation. All these contentions that are raised by the petitioner cannot be appreciated for the following reasons. When the application is filed under orders 7 to 11, seeking rejection of the plaint, the court has to consider the averments of the plaint and also the documents that are filed along with the plaint. The court has rightly held that there is a cause of action. The plaintiff has come before the court stating that how he is entitled for the partition, being the adopted son of Vedavati Roy. Whether Vedavati Roy is the wife of the plaintiff, the wife of Sanjeev Roy or not, has to be decided by way of a full-fledged trial. Then next, coming to the settlement deeds of the year 2010 and also 2005 are concerned, those are the documents that are relied upon by the defendants. And it is settled law that while considering the application for rejection, court would not look at either the written statement or the documents that are filed along with the written statement. In those circumstances, considering the plaint averments, the court has rightly held that there is a cause of action, and the question of and they have not questioned that the documents are not binding on them, and the court gives a finding that that is not necessary, and accordingly rejected the plaint in the considered opinion of this court. There are no grounds to interfere, accordingly dismissed. In the contentions, after the plaintiff's contentions, respondents are served, but no wakalat is filed. Yes, next.
Ratified. A.R. Desai for petitioner.
Petition.
Do that.
Rashek Napa.
Non-taking of steps in respect of deceased R2.
Suit against R2, my lord, has been withdrawn now.
It's withdrawn.
Has been withdrawn. I will file a memo in that writ petition.
Yes.
So far as this petition is concerned, my lord, respondent had earlier filed a suit.
What is this CRP is under order 7 to 11?
This CRP.
Yes, we'll see.
Earlier, they had filed a suit, my lord, against defendants 1 and 2. And delay.
Why this matter is tagged on with this?
What, ma'am?
Why this matter is tagged along with 35.1?
No, after hearing argument for some time during admission stage, my lord, your lordship, when I submitted that writ also has been filed and the same is pending, your lordship had directed to post that writ also along with this petition.
Where is the counsel for the respondent? You have an interim order in 35.1.
What?
In 35.1, you have an interim order.
In there, no interim order was passed because of some delay.
No representation on behalf of the respondent. Lists matter on 28th of July.
The trial court, interim stay may be granted, my lord, because trial court
Then you
matter
argue
is
on the matter.
posted for evidence.
Argue on the merits of the matter. Yes.
When, madam, date?
You argue on the merits of the matter if you want an interim order, or else it will come
Yes,
up
yes,
on
ma-
29th.
yes, my lord.
Yes, argue.
See, the respondent had initially filed a suit against defendants 1 and 2.
Maybe you can come to your application filed in support of the IA, so that the court will understand why you have filed this application.
Order 7, Rule 11 application, my lord. Order passed on that.
Where is that application? Page number 66.
Yes, ma'am. The plaintiff has filed the suit against defendants 1 and 2 for relief of permanent injunction, restraining the defendants or anybody under them from interfering with peaceful possession and enjoyment of digging pits or putting any sort of construction in the suit property of the plaintiff by way of granting permanent injunction. Later, plaintiff implicated me as defendant number 3, as I am the adjacent owner of the suit A schedule property towards west. There was no relief sought as against D3 at the time of filing this suit. Now the plaintiff deleted defendants 1 and 2 and continued the suit against defendant number 3 only. The plaintiff has specifically stated in the plaint paragraph 7 that the cause of action arose to file this suit on 11/6/2017 when defendant number 2 started to dig the pits in the suit property with help of laborers. So the suits filed today is in time. Now the plaintiff has deleted defendants 1 and 2 and the alleged cause of action arose only against defendant 2. After deletion of defendants 1 and 2, there was no cause of action as against defendant number 3. Moreover, the plaintiff has not amended the cause of action and not specifically stated that when the cause of action arose as against D3, when the cause of action arose. Hence, the suit is liable to be dismissed against me as there was no cause of action as against me. It is respectfully submitted that the plaintiff has not pleaded in the plaint that when I was constructed this house or when I encroached Schedule B property.
In the plaint, he has stated about you.
What?
In the plaint, he has stated about interference by you.
Plaint was initially filed against other defendants, my lord, 1 and 2, adjacent site owners. Subsequently, he has deleted them and sought to continue the suit against defendant 3 only.
Para 10 of the order at page 21
Para 10
of the order, impugned order,
impugned order.
at page 21.
In this regard, at the time of considering application under 7 Rule 11, the court has to look into averments of plaint alone. Hence, on perusal of averments of plaint, it is important to note that at para 4 from 6A and 6F, the plaintiff herein has made a specific allegation against D3 herein, and further it is settled position of law that the cause of action are the bundle of facts. In the present case on hand, the plaintiff herein at 6C of the plaint has averred about the cause of action, cause for impleadment of defendant number 3 in the present case on hand. Subsequently has been impleaded, my lord, and he constructed the suit.
According to him, even in the plaint, that you are interfering with his peaceful possession and enjoyment of the property. More or less on a technical.
More than 37 years have passed, my lord, since he constructed that
When you
house.
were pleaded to the suit, you have not questioned it.
Impleading application, that is the subject matter of challenge also in that writ petition.
Then we will, if you want, I'll hear both and I'll pass out final orders.
Yes.
Yes. Please inform the council. I will take it up, this matter. Pass over.
Today, my lord, today I may not be able to contact him.
Then Liz's matter on 28th, no interim order,
28th, ma'am.
Cell number 36.
no representation on behalf of the respondents. Yes.
36, J. Sangvi for petitioner.
I appeal for petition, my lord.
I appear for the respondent in this matter.
Your lordship. I am the statutory tenant. I get protection under the Karnataka Rent Act 1999. The monthly rent is rupees 900 only. And scheduled premises is 135 feet only. When they issued the legal notice, they did not mention anything regarding the measurement. Even at the time of filing of the suit, they did not mention the measurement. Only after the lapse of several years, they filed an amendment application stating that it is 170 square feet, which is against to their own statement of accounts. They produce exhibit P4, there they show exhibit, it is 156 square feet. Your lordship will see 1 square meter is equal to 10.7684 square feet. And no document has been produced. Sanction plan, no.
No, the
Nothing has
suit
been produced.
Order is dated 19 January 2026. The defendant is directed to quit, vacate and hand over the vacant portion within 3 months from the date of this order.
True. We are, what I'm saying is,
File.
My lords,
Execution is filed.
execution is not filed by us.
Oh.
If I may submit, I may submit, my lords. Now, the plaintiff, the appellant over herein was a tenant under me, my lords. Pursuant to that, he was paying a monthly rent to me for rupees 900. Pursuant to that, there was an enhancement of an 18%, which he didn't comply.
So anyhow, I have to finally dispose this matter.
Please, my lords.
You have not filed the EP.
Execution has not been filed by
Then
us.
don't do it and don't file it. I'll give a date. That day we'll hear
Please, my lords.
Yes.
This is matter on 4th of August.
Please, my lords.
This is
One more-
matter on 4th of August.
one more connected 38 matter, serial number between the same parties.
Might be clubbed together.
It is also. Let
Where
it
is the
comes
other one?
together. Yes.
38.
38 serial number between the
36
same.
connect with 38.
Yes.
38
The first matters with respect to shop number 7
and 9.
and
and 38.
the other is-
Lend
Same.
counsel for the respondent on a query from the court
Your
submits
lordship may
that.
call for the trial court record.
Submits that. They have not yet filed the EP due to
Let
paucity
them
of
undertake,
time.
your lordship.
This is matter on 4th of August.
Obliged.
Registry is directed to call for the trial court records. Till such time.
I'll not do it, my lords. For, with a
if
fair
you
submission,
submitted
I'm not doing it.
I'll-
Until now, I have waited it. I will not do within a period of month. The date is given, I'll not undertake it.
Let him undertake.
No, there is no question of undertaking. On the
Again,
prima
they-
facie, let him argue. I'm ready with it.
Fourth.
Your lordship, trial court records.
Huh?
Trial court
Call for
records.
media.
Trial court?
Trial court records will be.
I said,
Ah.
yes.
Carry on.
Cell number 37,
For the respondent.
Sidramaya VB.
Suit for eviction, my lord. Suit for eviction. The petitioner.
suit for eviction.
Yes, my lord. Very cantankerous person has left no stone untouched. Repeated applications for rejection of the plaint in this suit. She has filed a parallel.
What is of which year?
2019, my lord.
19.
My lord. There was a direction for speedy disposal. She doesn't turn up. In spite of that, she files repeated
No,
applications.
2019 means only 7 years.
No, my lord. My client is.
No, the other day I've seen one case of eviction.
Yes.
It is like you're saying that he is cantankerous, that
No,
suit
my
is-
lord. Why? Yes.
The
Why?
suit is
Because-
filed in the year 2009.
No, correct.
Trial is not yet concluded.
No, he
till now.
doesn't. She doesn't respect the court direction. That is what I'm telling you.
I'll hear it.
There is a direction
Today,
for.
the Passover will not reach today. I'll take the Passover will come tomorrow in the first list.
Yes.
Tomorrow.
Tomorrow, my lord.
Tomorrow in the first list. Yes, next.
Cell
Interim
number,
order
And one
ordered
more
and
thing, my
granted.
lord, they are not paying the.
Tomorrow I'll decide.
They're not paying the rent while they're not showing.
Tomorrow in the first list. Yes, next.
cell number 38, urgent. Cell number 39,
My lord, may I make a submission on Thursday, my lord? Wednesday?
Thursday.
I have family court matters.
Thursday. Yes, 39.
cell number 39.
Brought the
Chandan
petitioner is
K
a
for
defendant number
petitioner.
3 before the trial court.
39.
Respond number 1 herein is the plaintiff.
Hmm.
The
No, why I'm
respondent-
asking is, after the petitioner completely, when he completes his argument, then the respondent counsel will say, I want time.
Yeah, I understand.
Yes.
The suit is filed by the plaintiff for declaration of various sale deeds executed in the year 1991, March 1991, in fact, 6 sale deeds, to be declared as null and void and to declare him as a owner of the property with respect to 50
The
portion.
declaration of title and cancellation of the sale deeds.
Yes, declare it as null and void, not binding on him, and declare he is the owner of 50% share of the property and for injunction and possession. Lord, the brief fact of the case is that plaintiff's father and mother, who were defendant number 5 and 6 in the suit, they had created a trust by name Masood and Masoom Benefit Trust. And one of the beneficiary of the trust was the plaintiff. And as per the trust, under various clauses, the trustees, that is the settlers of the trust, were entitled to sell, buy property and everything. With that power, they had sold certain properties in the year 1991 to the plaintiff herein, and it was subsequently sold to defendant number 7 as well.
Plaintiff when it was sold? When it was sold to you?
Not the plaintiff, not his parents, who were the settlers in 1991. It was in the year 1991. Now, my lord, I would like to take your lordship to paragraph page 43, which is a plaint. I'm solely relying on the plaint governments. At page 45, paragraph 5, my lord. From 43, the plaint starts. Page 5, my lord. Paragraph 5 at page 45. During the year 1987, the trustees, defendant number 5 and 6, started conducting themselves in the manner detrimental to the interest of the trust. They were attempting to alienate the trust property. It is submitted that plaintiff, on learning the intention of defendants to alienate the trust property, plaintiff filed OS 6105 of 1990. These are the same properties, my lord. Before the court and the Honorable City Civil Court, Bangalore, so and so, it is submitted that during the pendency of the said original suit, defendants approached plaintiff saying that the said sale deeds are already executed by the trustee, who is none other than the plaintiff's father, and it would take several years for the conclusion of the case, and indicated that in case plaintiff were to agree for a compromise and withdraw the suit, defendants would safeguard the interest of the plaintiff in such a way that no nuisance would be caused to the plaintiff. Defendant number 1 and 2 had put a precondition that plaintiff has to withdraw OS 6105 of 1990 at first instance. Thereafter, they would take positive steps in safeguarding the interest of the plaintiff. At the time, they did not disclose as to the manner in which they proposed to safeguard the plaintiff's interest.
To OS number 90.
90,
This
my lord.
fact is known to him in the year 90.
He was aware that the sale deeds were executed in the year 9 during the course of the proceedings itself. He withdraws the suit on 1/10/1993. Now, my lord, I would like to take your lordship to paragraph 9 of the suit.
Yes.
It is submitted that after withdrawal of the suit, that is the first suit which I said, by putting plaintiff in fear, defendants, he alleges throughout the suit that I was put under coercion, I was put under fear, but no action has been taken either to revive that suit, saying that I was made to withdraw, nor any other action. Defendants have taken the signatures of the plaintiff on several documents without disclosing their contents. They, means the defendants, had also filed original suit 338 of 93 against the plaintiff and his 2 brothers in respect of lands in survey number 23 and 30. Plaintiff has no manner of interest over the said properties. The defendants compelled the plaintiff to sign the compromise petition dated 18/11/93. That suit also resulted in a compromise. So that was ended. Now, my lord, paragraph 12 at page 51, my lord. In this, it is submitted that as the sale deeds in favor of defendant number 2 and 7 are executed by defendants in violation of the specific clauses of the trust deed, hence the same are liable to be declared as null and void and not binding on the plaintiff. Defendants had no title or suit property. As they were only trustees, they could not have conveyed the property to defendants. The plaintiff had also filed WP 27225 of 1993 before the Honorable High Court, praying for issue of writ of certiorari and quash the order passed by the ULC authority granting permission to defendants to alienate the scheduled property. The defendants herein were added as respondents. The said writ petition, in the said writ petition, there was also defendants threatened the plaintiff and compelled the same thing he says, and even that was withdrawn. Now, after doing all this, my lord, withdrawing all the 3 cases, compromise in one case, and there are several other cases, my lord, which were also compromised and settled, which the plaintiff has not disclosed in the plaint. Whatever he has disclosed, I am relying upon. After all this, in the year 2000, to this particular trust deed was in the year 1969. 29th October 1969, date of the trust deed, and for a period of 30 years. And after 30 years, that is in the year 1969 was a trust deed. After 30 years was the date for distribution of whatever is available in the trust. His contention is after 99, because there I had a right for distribution, so I could file this suit. The fact here is you are also aware of the sale deeds.
No, the suit is of year?
2002, my lord. After that, the suit was dismissed. He files a miscellaneous petition. The suit gets restored and then gets renumbered in 2013. So there is a long story for that. So then this application is filed. Now, my lord, the question
So
here.
according to you, when the cause of action arose for him?
Cause of action arose in 1987 itself when he says in paragraph 5 that I came to know that my parents are selling the property. I filed the first suit and during the suit I had the property was sold, which I was aware.
That's 1990.
90. No, my lord, 1990.
Suit is 1990.
Yes, 1990. That is the day of cause of action when he first came to know about the sale deeds. Section Article 58 is very clear on that.
And he filed the suit after 12 years from
Yes.
1990.
1990, after 12 years. Article 58 is very clear on that. It says to obtain any declaration, 3 years when the right to sue first accrues. His right to sue first accrued on the date of knowledge that there is a sale deed executed. He knew all the way. Thereafter, he files another suit. In that, it gets compromised. He files a writ petition that he withdraws. Now, one more suit.
No, how the court has dealt with this?
The court, my lord, I would like to take your lordship to relevant portion at page 32, my lord, of the impugned order reasons. My lord.
Yes.
Since these points are interconnected, here the 2 points are raised, my lord. One is whether the plaintiff does not disclose the cause of action, suit is barred by law of limitation. I filed this under Order 7, Rule 11, A and D both. Whether the plaintiff is required to be rejected as contended, and reasons point 1 and 2. Since these points are interconnected, the same are taken together for the common discussion. It is a contention of defendant number 3 that the plaintiff has filed the suit for declaration, permanent injunction, damages, and other reliefs. Defendant number 7 is absolute on suitable properties, having purchased the same from deceased defendant number 5 and 6 under the various sale deeds, and some lands are purchased from Masood and Masoom Benefit Trust and Mrs. Latif Unisa and Mansoor Benefit Trust. Both are represented by late Mahmood Ali
I
Mumtaz.
think
And
all these are reiterated, what you have
all
said
these are
is
reiterated. Now, my lord, I will take your lordship to the contentions at page 35, para 8, my lord. The reasoning. The basic principles in order to consider the application filed in 7 Rule 11 of CPC, the only averments of plaint shall be looked into. It is pertinent to note that Honorable Supreme Court has issued the guidelines as to how the application. Now, my lord, the guidelines is reiterated, and I would like to take your lordship to page 38, para 9.
Yes.
It is a specific contention defendant number 3. The suit of the plaintiff is not maintainable. The plaintiff has no cause of action to file the suit. The suit of the plaintiff is barred by law of limitation. The contention of the defendant that plaintiff has filed this suit for declaration, permanent injunction, and damages. The plaintiff has sought for declaratory relief in respect of sale deeds. The plaintiff has contended in his plaint that the suit is suit in OS number 610 of 1990 has been got withdrawn as a matter settled out of court. It is also contended that in the plaint, the plaintiff has filed a writ petition which was also came to be withdrawn. It is therefore, since the plaintiff has withdrawn the earlier suit, he cannot maintain the present suit. It is also further contended that the plaintiff has challenged the sale deeds executed in the 1991. It is therefore the plaintiff has no cause of action. He again reiterates the same contentions once again, my lord. And finally, my lord,
I've seen nothing much.
Nothing much. And finally, he comes in the present case on hand at the last portion of this page, my lord. In the present case on hand, the contention of the defendant number 3, plaintiff has no cause of action to file the present suit. It is further pertinent to note that settled proposition of law, cause of action is a bundle of facts, and in order to ascertain the same, plaint has to be read in a whole. This is what he says. In fact, the plaintiff read in a whole and the contentions of the plaintiff himself, he admits that the suits were filed on the same cause of action with respect to the same sale deeds. Those were withdrawn.
We'll ask it.
Grateful.
Admittedly, the trust deed was executed in 1969. There is a specific clause that the trust property should not be sold for 30 years. So the sale deeds were executed from 1987. There were basically 4 trusts.
This is one of the trusts. There are other cases also which are pending with respect to same people. Then what happened, my lords? 1987 to 1990, there were several sale deeds. Admittedly, the injunction suit which was filed in 1990, it was not a declaration suit. That came to be withdrawn, and the writ petition also came to be withdrawn based on a settlement. But that settlement never went through. Until 1999, October 29th, the trust properties were intact. Presently also, I am in the possession. 2002, I file a suit for declaring myself as pauper, not to be able to pay the court fees with respect to these properties. 2008, the matter gets allowed. 2008, a fresh suit comes to be filed with respect to no court fees. The court fees are.
No, not going into all those facts.
Yes, ma'am.
You are saying that there are sale deeds that have come into existence between
Yes.
87 and 90.
Yes, ma'am.
Your knowledge is, as per the plaint, you have the knowledge
My
about
right
this.
to sue started from 1999, October 29th. Manoj.
Why?
Because the properties gets devolved to me after 29th October to 1999 as per the trustee itself. And the one more.
Why did you then, if there is no right to you, why did you file the earlier suits?
Because of that only we had to withdraw the suit, Manoj. That also, the contention also came up during that time that I
Where
did
did
not
you
have
say
the
in the
right.
plaint about this?
What, Manoj?
Where did you say about, in the plaint about this?
In the plaint.
Plaint.
In the plaint, I have not specifically pleaded about this, Manoj, but there was one more thing which has happened. The one suit which was withdrawn, that was because of coercion, what my learned friend said. A complaint was also came to be filed with respect to that, Manoj. All that I need to prove in the evidences itself, Manoj. I cannot just show it in the plaint and I cannot get concluded with this. Whatever
On the face of
settlement,
it, the suit is clearly barred by limitation.
whatever settlement they talk about, Manoj,
If
nothing
this
has,
is a manner in
nothing
which
has been.
in which the cause of action and the law of limitation has to be understood, then anybody can file the
Manoj,
suit any point
Manoj,
of time.
trust properties, they had to take permission from the principal court of the district. No permission has been taken for selling the trust properties, first of all. And if in case the sale deed is looked into, one unknown individual named Raghunath executes a sale deed, not my father, not my mother. They were the trustees. The trustees did
That
not
is
sell
all
the
on the merits
properties.
of the matter, which are in your knowledge.
Manoj,
These are all on the merits of the matter.
Manoj, my
All these
right,
aspects are in your knowledge.
my right accrued on me since 1999.
Your
Manoj.
right
Within
earlier
3 years
also
of time,
accrued.
within 3 years of time, I filed my suit, Manoj.
Where did you say in the cause of action?
Where, Manoj? In the plaint.
Yes, let's see, what did you say?
Yes.
How the cause of action accrued to you?
That's the plaint is at 43 to 58, Manoj. Page
Let's
number
see.
43.
Cause of action is at page 52, para 14.
Unless I don't have the plaint.
It's all in the bundle. Page 52, no?
ಇಲ್ಲ 45 ಆದ್ಮೇಲೆ ಡೈರೆಕ್ಟ್ ಆಗಿದೆ
Copy.
He says the cause of action for the suit arose on 29/10/1999.
Yes.
The date of maturity of the period of 3 years.
30 years.
30 years mentioned in the trust deed and also on so and so.
That is what, Manoj. My right to sue
And
started
also,
from
no,
19.
you say subsequent dates on which plaintiff learnt about execution of the sale deeds by defendants.
Yes.
But ultimately, without having the right over the property, I could not have even challenged, Manoj. How could I have challenged without having the right on the property?
How you got the right over the property?
Until 30 years, as per the trustee itself, I did not have the right over the property. Nobody had the property's rights apart from the trust. Even the trustees, even the beneficiaries could not have dealt with the properties. That is what the trust deed says. Whatever
That I
transaction my learned
respectfully
friend
disagree.
says.
That I respectfully disagree, my lord.
Whatever transaction my learned friend says with respect to my father executed or my mother executed, that is not my father or my mother who executed. It is some GPA holder, unknown individual to the family. Mr. Mahmood Ali, Ms. Tahira Ali never executed any document. And the GPA which they have said, there is one FIR which is pending with respect to CBI economic wings.
That's what I'm saying. This is all on the merits of the matter, whether
Yes,
you,
Manoj.
you can
My
succeed.
right to sue started in the year 1999.
What do you say on that?
My lord, with respect to that, my lord, I would like to take your lordship to the trustee that page, my lord, 60. And the relevant paragraph is at page 64, my lord. 6A, clause 6A of the trust deed, my lord. The trustee shall hold any movable or immovable property or properties comprised in the trust fund upon trust, and shall have power to sell the same at the sole discretion from time to time, with power to postpone the sale thereof or any part thereof. The trust deed is very clear on this, not only in this paragraph, every paragraph, my lord. Again, my lord, at clause 7E, the next page, my lord, page 66. 7E, to sell all or any portion of the trust fund, whether consisting of immovable property or otherwise, either by public auction or by private contract, or such terms and conditions relating to title or otherwise. This trust deed, not only in two places, my lord, even many places it says that the trustees have the right to sell. Now, my lord, again at paragraph 10A.
What do you say about his submission? That he cannot, till 1999, no rights have accrued to him to question it.
No, my lord, I don't agree with that. Why? Because he is a beneficiary of the trust. If at all the trustees did not have any right to sell the property and they have sold prior to the 30 years, he always had a right to question that. He being the beneficiary of the
submissions, I have the original trust with me. I am finding some pages different, my lords. I need to produce that original trust deed before this court just to look at the documents. I have the original trust deed with me. There are four similar trusts, same trust executed, my lords, on the same
The subject
day.
matter is pertaining to this trust, my lord, the whole property.
Then a senior counsel appearing for the petitioner submits that. An application that's filed in order 7 to 11 on the ground of limitation and cause of action. The court has failed to consider the same. It is submitted that the transactions which have happened between 87 and 90, which are in the knowledge of the plaintiff, had filed the suit in the year
1990,
99.
90.
So filed the suit in 2002, not 99.
No, my lord, 1990 was the first suit which was withdrawn.
6105 of
present suit.
1990.
Present suit in 2002, my lord.
A present suit is filed in the year 2002, and this clearly barred by some limitation. This fact was not considered by the court. Considering the submission of the senior counsel, there shall be stay of all for the proceedings and so and so. Let's just matter on 10th of September.
My lord, any shorter date, my lord. Grateful if your lordship can give a shorter date, my lord.
There are so many matters you have stay.
I'm definitely agree with that, my lord. But the problem is I have been put into this so many number of suits throughout, my lord, from 1990.
The matter on 12th of August.
Grateful, my lord.
Yes, next. It's after lunch. Which one? 20? Oh. Then why are they doing this? And why it is registered for admission? This is matter tomorrow, 30 as it is. No order. Tomorrow we'll see.
Sir, 46 date ಕೊಡಕ್ಕಾಗತ್ತಾ?
ಮೇಡಮ್ ಮಧ್ಯಾಹ್ನ ಲೀಡ್ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ 2:30 ಮ್ಯಾಟರ್ ಆಗುತ್ತೆ
2:30 matter.
My senior argued for serial number 30. He could not hear, madam.
ಅದು
230 matter, you please call.
May I
make one submission, madam.
230
No submission.
230 matter. Cell number 60.
We are filing the memo, my lord. Lok Adalat, my lord, and the petition has become infectious.
30?
35 list 2. Vinita PC. Suresh V.
Memo is filed stating that the execution petition is closed on 11/7/2026 in Lok Adalats on payment of the requital amount. And where is, you say that in the light of the settlement, it has to be recorded. I'll just say, in the light of the settlement for the Lok Adalat, this petition is disposed of, is dismissed. I mean, disposed of, recording the submission.
Yes.
It is, considering the fact that the matter is settled before the Lok Adalat, the petition is disposed of.
Wait for my.
List number 1. 230 matter. Cell number 61.
Just kindly pass over the matter.
Hmm?
Senior counsel is engaged in portal number 1. Kindly pass over.
Man, it's a 230 matter, is a question of,
But it's a matter at the portal 1, my lords.
you have an interim order.
Not to precipitate.
I'll grant, it is there.
Is that, when one of the matters connected, 216 it is there, 214 also.
This is, where is this?
Two portions of the same building.
Which is the case, item number? I was asking you not to these matters. I said specifically 230 certain matters to be called. That I said 230, that's what I wanted you to call. The 61, it is arising out of the same suit. So if one,
Two companions with same evidence was recorded.
yes, the land counsel for the respondent seeks a passover due to paucity of time. This court cannot take up this matter today. The interim order earlier granted is extended. This matter on 19th of August. Yes.
Passover 230. Cell number 25. Yes, Kalyan Basavaraj.
Yes.
Devaraj is
P. Devaraj.
230 matter, madam. 230 matter, one more matter.
I'll take up.
Please.
Yes.
This matter, Lord,
When I was saying 230, I'm referring to this. Yes, 25.
kindly go to,
Yes, Mr. Devraj, what are your instructions?
Disconnection based on the communication. Disconnection based on the communication. I'm not get the instructions, copy served to me now. That may call it and tomorrow itself I'll get the instructions. That what is the reason for that, sent a mail for.
When was it disconnected?
That I am not aware that.
When was it disconnected?
it is yet to be disconnected. They should notice that they will disconnect.
What is the submission every day? They say that it is not disconnected. You're like,
I'm not aware that fact. Now copy is now served that I'll get.
then what is the threat now?
Like, kindly see the notice issued, Mala, Annexure A.
That not
Immediately we will
disconnect.
disconnect.
Disconnection.
They say that immediately we will disconnect.
What is the notice?
Annexure A, Milad.
What the notice says?
Annexure says that immediately we will disconnect the electricity connection.
No, it says so many other things. Apart from
Says
saying
that-
immediately we disconnect. There are 5 lines.
We have obtained legal opinion from our department
Yes.
on the basis of which we will disconnect. That is the sum and substance of.
What is that?
That they have received a communication from the corporate office mail. Based on that, they have issued a notice for disconnection. Stay of disconnection, call it and day after tomorrow, that I'll get instruction.
Forget about stay of disconnection. What is this notice?
There's a
What notice means?
That it is received from the corporate office as to the disconnection of power supply through mail. That is the mail correspondence which has been mentioned in the notice. Based on that notice has been issued to immediately disconnection of power supply. That is.
May I make a
What is, 1 minute,
I'm sorry.
what is the purpose of giving this notice? That I want to know.
That I have to get the instruction. The notice is not specifies that what is the reason for disconnection is.
Then why did you, then I'll pass orders, I'll pass strictures on this.
That I'll get the instruction. What is the reason as it is concerned.
No, they should be, why are you issuing notice? This is not called notice. You're passing an order saying that you're doing it. The land counsel for the petitioner submits that. The respondents have issued the notice, styled as proceedings dated 9 July 2026, stating it as a notice, wherein it is stated that they're going to disconnect the power supply forthwith. It is submitted that this proceedings of the respondent are contrary to the principles of natural justice, and in such a high-handed manner, the respondents cannot disconnect the power supply. The land counsel, Mr. Devraju, is directed to take notice on behalf of respondent 1 and 2. He submits that he'll get instructions and will also file their objections. On the face of it, this notice refers to disconnection without giving an opportunity to the petitioner to submit his explanation. In that view of the matter, the respondents are restrained from disconnecting power supply, and at the same time, the petitioner shall continue to subject to petitioner continuing to pay the usual consumption charges. List this matter in the month of September.
Cell number 28. Jayad DS, B. Lokesh.
We informed the other side also. We informed the other side also. The Lordships had directed the case on caveator.
What is this?
There is no, the senior counsel argued in the morning. The matter can be disposed of is what your Lordship said. Therefore, I also intimated the counsel appearing on behalf of the respondent. Caveator.
He's the only response.
He's the only respondent, plaintiff. We also
in the forenoon as well as in the afternoon, there is no representation on behalf of the respondents. Heard the counsel for the petitioner, then the senior counsel appearing for the petitioner in part. Let's this matter tomorrow. Tomorrow, if he's not there, I'll pass.
Take 5 minutes. 5 minutes.
No, tomorrow I'll pass it because he's not there now also. Whether he's there or not, tomorrow I'll pass orders. You can argue tomorrow. Tomorrow you can argue. Yes, next.
Cell number.
Yes, where is that?
230 mood matter. Srinivas V. Mood at 230 Srinivas V for petitioner.
Yes, that one more 230 matter also you call. Anyway, you called one.
230 matter, cell number 62. Cell number 62.
So this is the matter where the status quo order was set aside.
Yes.
Yesterday we
Respect to a
observed this
site.
matter. Now, what I observed is, there is utter confusion. Survey number 48 is the one which is claimed by his vendor, is the owner, to an extent of 2 acres, 22.5 acres. Whereas the second respondent is the owner in survey number 47. Larger extent is 9 acres. 16.
No, you're owner of 47 and
only.
48.
No, I am not.
Already you are submitting.
Yes, that
No,
is
no,
the wrong
no.
submission. They are only 47.
We have clarified. We have nothing to do with survey number 48. We are only concerned with 47. According to the petitioner's own plaint governments, he claims that his vendor has formed the layout, which yesterday Lordship has seen the map. That is only a proposed map. These are all 2 agricultural lands. Land has not been converted. No approval has been obtained by the competent authorities. So the matter requires deeper examination. I am not claiming anything in survey number 48.
That I will
may be
clarify.
recorded. And whatever construction I am going to make, I am not going to claim any equity, and it will be subject to the outcome of the writ petition. And what if my learner find that succeeds, if the petitioner succeeds in the court, I will leave the place as it is.
The interim order granted by the trial court may be restored, Your Lordship.
That's it.
Wherein site.
Clarifying that that's only in respect of survey number, your land plot number 67.
68, Your Lordship.
68
Yes.
is in survey number 48. He is a owner in respect of survey number 47.
47.
47.
So in that case, there is no dispute at all.
Certainly. The only clarification there would be, Your Lordship, my schedule in my plane is, like I read yesterday, site number 67 formed in Maple Meadows layout, which is a lot you had seen the layout plan, 199 sites with only one site number 67, which sale deed I hold. My learned friend, learned senior, produced two sale deeds of 68 and 69.
Yes.
67 is only mine. When your lordship passes an order, it may be with respect to site number 67 in Maple Meadows layout formed in as per the schedule, your lordship. That is all. Otherwise, they will come. Otherwise, what they already did, they will do again. And lordship, one more submission I have, your lordship. This is not one matter. There are multiple cases. I have the copies with me. There are multiple cases which have been filed by site owners against the same respondents which are pending for the trial court, because these are all sale deeds executed 2013, 2010, your lordship. 10 years later, they have all walked in and said, this is mine only for extortion. I humbly pray that the schedule may be retained, your lordship. Otherwise, they will come.
Filed by his vendor at page number.
This is any oath that is not relevant. Please come.
I am not a party to that suit also, your lordship.
Agreed with the orders passed in MA number 71 of 2024 dated 15/11/2025 by the 5th Additional Principal Senior Civil Judge, Bangalore, whereby the court has reversed the order passed by the trial court in I numbers 1 and 2 dated 26/7/2024. The petitioner plaintiff is before this court.
1, 2, and 3, your lordship. Huh? 1, 2, and 3.
Huh.
3 IAs they have. IA 3 was filed by them for vacating this case.
1, 2, and 3.
Great.
The petitioner herein was a plaintiff in the suit, has filed the suit seeking. Where is your plaint?
It was about page number 84. The prayer is at page number 89. Your lordship.
Has filed the suit stating that is absolute owner of the immobile property bearing site number 67 in Maple Meadows layout formed in property number 47 and property in survey number 47 and 48. Nada Gowda, Gollahalli village, Kanur Gram Panchayat limits, Bigarhalli Hobli, Bangalore East Taluk. Admissioning 2,400 square feet. It is also stated that the suit scheduled property is represented to be formed in survey number 48 by 1 by defendant number 1. The plaintiff have purchased the property from one Sri Sabu T. Verghese, who is also the developer of the Maple Meadows layout in survey number 47 and 48/1. The defendant number 1, who had represented the suit scheduled property, has formed the property bearing number 48/1, has executed the sale deed in favor of the plaintiff, while sale deed dated 24/10/2013. It is the case that on 1/9/2023, the defendant number 3 to 5, along with the henchman, trespassed into the site in the layout, including the suit scheduled property, with a JCB and demolished the front wall and trespassed into the suit scheduled property. That made the petitioner to go before the court by filing the instant suit. In the suit, he has filed the I number 1, 2, seeking injunction. That came to be the court. Where is that order?
At page number 140, your lordship.
Status. The court has initially granted adjournment from injunction. The respondents have filed I number 3. Both I number 1, 2, and 3 were considered, and an order was passed dated 26 July 2024. Whereby the parties were directed to maintain status quo in respect of the nature of the suit scheduled property till the disposal of the suit. The court, while passing the order, has observed that to meet the situation, the court is of the view that directing both the parties to maintain status quo is a solution for the present dispute between the parties. The court observed that the word status quo means the situation that currently exists or exhibiting state of things at any point of time. If court passes an order of status quo, the justice will be done to both the parties and no irreparable loss or damage will be caused to either of the parties. Agreed thereby, the defendants have carried this by filing MA number 71 of 2024. The appellate court, by judgment dated 15th November 2025,
Page 13.
had dismissed appeal filed with the had dismissed the IA number, had set aside the order passed in on IA number 1 and 2 in the suit by had set aside the orders on IA number 1, 2 and 3 and dismissed and consequently dismissed the IAs. And IA number 3 filed with the defendant is allowed. The court, while passing the order, has observed that the plaintiff claiming as owner in possession of site number 67, card out in survey number 48, has filed the above suit alleging that his site number 67 formed in both survey number 47 and 48. But the plaintiff has not produced any document to show that a common layout is formed in both survey number 47 and 48. Admittedly, the vendor of plaintiff is the owner of land in survey number 48, but not survey number 47. When such being the case, the plaintiff cannot claim over the site number 67, which is formed in survey number 7. Moreover, the sale deed dated 24/10/2013 reflects survey number 48 of Nada Gowda Gollahalli village, but plaintiff is claiming his site is property to that of site number 67, carved out in survey number 47 of the same village. Further, the court observed that to prima facie convince the court with regard to claim of possession of the suit property the plaintiff respondent number 1 has to prove his possession based on the flow of title of the suit property. The appellant defendant number 2 to 5 have denied the claim of the plaintiff. And the court has come to the conclusion that the plaintiff has failed to make out a prima facie case. And the trial court, while considering the material placed before the court, has wrongly opined that it is necessary to order to maintain status quo in respect of nature and possession of the property. The trial appellate court has come to the conclusion that the trial judge has committed error and irregularities in passing the impugned order and accordingly set aside. Next para. When counsel appearing for the petitioner submits that the case of the plaintiff is very specific that he has purchased plot number 67 in survey number 48. What is that, Meadows?
Maple Meadows layout.
Maple Meadows is developed by the developer in survey number 47 and survey number 48. However, his property is in survey number 48. It is submitted that the trial court, considering these facts and to preserve and in the interest as an interim measure, the court has rightly granted an order of status quo, balancing the interests of both the parties, as whether the property to appreciate the respective contentions of the parties. It has passed through the full-fledged trial. But the appellate court, without considering all this, has set aside the order. He has drawn the attention of the court to paragraph number 15, where the court gives findings that the property of the plaintiff is carved out. Site number 67 is carved out in survey number 47. And also the observation that the plaintiff cannot claim over site number 67, which is formed in survey number 47, or the findings which are contrary to the material on record. It is submitted that it is a specific case of the plaintiff that the property is in survey number 48. And even the defendants also not claiming the property, even according to them, they're the owners of survey number 47. In those circumstances, the appellate court has gone beyond the jurisdiction vested with the court and had interfered with the order of status quo this passed by the trial court. Next panel, and counsel appearing for the respondents submits that already I passed the order yesterday that the other defendant is not necessary.
Yes. We filed a memo to that.
The then counsel appearing for respondent
1 to 4.
1 to 4.
1 to 4. Then appearing for respondent number 1 to 4 submits that the respondents or the owners in respect of survey number 47, survey number 47. When the plaintiff is specifically claiming as a plot in survey number 48, plot number 67, but when it comes to the schedule of the suit, it is mentioned that Maple Meadows in 47 and 48 survey numbers, that is causing the confusion. As far as the defendant number 1 to 4 are concerned, they have nothing to do with survey number 48, and they are the absolute owners of survey number 47, and they have not sold any property to the plaintiff. It is submitted that the appellate court has rightly considered all these aspects and I had rightly set aside the order passed by the trial court. Anything else to be recorded?
I have produced the two state deeds to show that site number 68 and site number 66 I have sold, and what he is claiming is the middle portion in survey number 43. I have produced
It is the claim of the defendant is the defendant has sold site number 68, 6 and 8.
66 and 68.
66 and 68. Now the plaintiff is claiming.
I have retained 67 for my own.
The plaintiff, the defendant has retained 67, and what is claimed by the defendant, the plaintiff, is that plot number 67. That's it. And it is it is submitted that there are no grounds to interfere with the well-considered order passed by the appellate court.
My submission regarding equity that I will not claim even in the event of any construction that we can be.
It is submitted that they may be permitted to proceed with the construction, and they, in case if they fail to succeed, if they succeed in the suit, still they will not claim any equities. Next, having heard the counsels on either side, per some material on record, the suit is filed for a bare injunction. This court has perused the plaint. In the plaint of it is a specific case of the plaintiff that he has purchased a property in the year 2010. 2013, that is plot number 67, that is Maple so and so. It is submitted. It is a case that when there was an interference by the defendants, the petitioner has filed the instant suit. In the light of the submissions made on behalf of both the parties, there is a dispute. According to the plaintiff, his property is in survey number 48. According to the defendant, his property is survey number 47. When it comes to the plot numbers, according to the defendant, he has retained plot number 67 and he sold 66 and 68. And the plaintiff has purchased a property by way of a registered sale deed in the year 2013 in respect of plot number 67. Considering these facts, and to decide whether the property as claimed by both the parties is one and the same or two distinct properties, or whether there is any interference by the plaintiff, the court has to, there has to be, there has to be the, after completion of the full-fledged trial, then only the said facts can be, the court will be able to find out. At this juncture, the trial court has rightly held that as the plaintiff property is purchased in the year 2013, and according to him, is the owner of the property. And he could prima facie prove his case in those circumstances, and also balancing the interest of the defendants. The court has granted an order of status quo. In the considered opinion of the court, the order passed by the trial court is a well-considered order. And the appellate court, as rightly submitted with the learned counsel for the petitioner, has passed an order where the findings of the court are contrary to the pleadings of the parties and the material on record. In that view of the matter, this court is passing the following order. The order passed in MA number 71 of 2024, dated so-and-so by so-and-so, is set aside, and the order of the trial court is restored. Passed in I number 1 and 2 is restored.
1, 2, and 3.
1, 2,
And 3. 3 is the vacating application.
is restored.
Grateful.
Cell number.
We were permitted to, we were permitted to put up construction. We were permitted to put up construction because the cost of construction is.
Because, no, it is where we will, these equities and all will apply in a different case, not in a case of,
I request your lordship to, for a speedy disposal.
which year is the suit?
2023.
23.
At least 1 year. This is a simple suit that what they have filed. I mean,
No, that cannot be, we can, the court shouldn't do it, the High Court shouldn't pass such orders. Yes,
Grateful.
yes. Call that.
30 moved matter.
Sorry, but one more 230 moved matter was there.
We should move only 1 230 matter a day.
Unfortunately, that got passed over in the morning session, my lord, and it was the first matter. I'm sorry, my lord.
Yes, yes.
My lord, I'm sorry, my lord. The case I have filed 3 petitions today. Which one has come? I don't know the number.
21370.
21370.
Petitioner TV Vaishali.
Yes, my lord. In this case, my lord, it is exactly the same situation as was yesterday, my lord. Yesterday only they have disconnected. This is not a same case.
Have you served the papers on them?
My lord.
You should have served it on the same council so that you would have, unnecessarily it has to go tomorrow again.
My lord, I have my lord, annexed the notification translated version also. My lord, in this case, my lord, though that notification does not apply, my lord, I was putting up construction.
When was it disconnected?
Yesterday, my lord.
Tomorrow
Both the
morning I'll
properties
take.
Yesterday only disconnected.
Who has taken notice on the last occasion?
Mr. Vinayak has taken notice. my lord.
Mr. Vinayak so-and-so is directed to take notice on behalf of the petitioner, and then counsel the petitioner is directed to serve the writ copy of the writ petition on
We
the
are
council.
deciding there, my lord.
Tomorrow in the first case.
We are deciding there, my lord. Yesterday they have disconnected. Today also we don't have power. Tomorrow also, my lord.
You know that what is the procedure I follow? You should have done it by this time. Because without notice and without understanding the facts, just like that, the
But I
court
put a
shouldn't pass
translated
orders.
version of the notice also, my lord. I put a translated version of the notice also, but translated version is at page number 30, my lord.
That's what I request all the advocates in all these KEB matters. Without notice to them, I will not pass any orders. So it is in your interest, you have to
But
issue
the
show the
allegations,
papers
my lord,
on the
is that
councils.
it's an illegal building and BBMP have directed them to take action for
What is,
disconnection.
where is the
Translated version is at page number 30, my lord.
page number?
30, my lord. Lord, page number 30. May I read last paragraph, my lord? Accordingly, upon receipt of a complaint at the office regarding the construction of an unauthorized building by Srimati Vaishali so-and-so, is the spot inspection was
Page
carried
number
out-
20.
30, 30. 30, my lord.
Yes.
Lord, mainly, my lord, they say that as informed at reference one, notice under section 248(1)(2) of the BBMP Act have been issued to the property owner directing production of the sanctioned plan and other related so-and-so. Since the owner there has not produced documents such as approved plan pertaining to said property, the building have been treated as unauthorized building. Notices under so-and-so have been issued. My lord, I will stop here, my lord. Now, till date, my lord, your lordship may record my finding, my submission. Till date, BBMP have not issued any notice to me, my lord. Till date.
No, wait,
Still
that
they write
yesterday's
and make.
matter, where is it? Yesterday one matter has come of this nature where I have,
My lord,
What's the serial number?
yesterday it was 4, my lord.
Serial number?
not your matter, some other matter has come yesterday. Where I said, I think that is there today also.
The only reasons for that is that, my lord, that is why they have gone on for
So that's why I've
disconnection.
asked the council yesterday, what is this connection between the unauthorized constructions and that is the duty of the local authority.
Yes, my lord. They say that they have written letter and they have taken action, but till date, my lord, I'm making with all consciousness that they have not served any notice upon us. BBMP have not served any notice. Even if they serve, my lord, I've got a remedy of appeal. Till the subjective, till the application, till the appeal is exhausted, they could not have directed, my lord. So therefore, my lord, I'm seeking restoration of the connection, my lord.
Mr. Devraj is directed to take notice on behalf of the respondents. When it comes to the petition, so the copy of the writ petition. Is this matter as a first case tomorrow? Tomorrow we'll do it. We'll dispose of the matter itself.
My lord, may I appear through VC tomorrow? my lord?
Yes.
Because I have a matter in Supreme Court.
Yes, yes. First matter tomorrow. In the neighbor, and please serve the papers on it.
Yes,
And
ma'am.
by
I'll serve
tomorrow,
it
the
today
then
itself.
council shall get the instructions. Yes.
My lord, another 2 matters are also same. One is yesterday's matter, my lord.
It has not come up. The other 2 matters are there. All the matters, in all the matters tomorrow. Yes.
All the matters. Two more matters.
Yes, tomorrow.
Same as we, another 2 matters.
That's what I'm saying. All the 3 matters tomorrow.
Much only. In all the matters, I'll serve Devraj. Much.
No, no. Oh, you said some other council has taken in other.
Vinayak in one matter, my lord.
No,
I'll
on
serve
all the
Vinayak.
3 matters, Mr. Vinayak so and so. Registry is directed to print his name. Yes.
I'll serve Vinayak in all 3 matters. Much.
Serial number, list number 1, list continuation, serial number 40. Pradeep Pages for petitioner.
I'm for petitioner. Last occasion, your lordship directed me to file a memo of calculation regarding the arrears of.
That's the only dispute.
That is only dispute.
According to you, have you looked at his memo?
I have looked into it.
Take that.
I said the copy on the Senate Council. The difference is, he says it's 1,12,000. As per my calculation is 1,20,400.
As per his calculation, it is
1,12,000.
1,12,000.
Yes, Lord.
Not
Your calculation
1,20,400.
1,20,400 after deducting the security deposit and also the payments that has been made. That is the amount due as per the order of as per the impugned order.
Your lordship, we are.
So now the only difference is about 8,000.
And one is
8,000 is the difference amount.
8,000 difference amount, your lordship, that the trial court has fixed the damages at the rate of 9,500. It is exaggerated. I am.
Yes.
Step
by step, one step that's over. Now you're coming to the next relief.
No, your lordship. In last occasion, as I have
You said
pleaded,
only about this one last time. You're asking about this money.
Yes, 9,500 rupees. That has been fixed by the trial court.
How much it is coming to now?
It is coming to know, it is 2,19,000, your lordship. I have paid the 1,12,000. According to me, I have to liable to pay 1,07,000. According to him, 1,20,000. There is a difference of 13,000 difference
I'll
between.
mention one thing. I'll just make limited points with respect to the memo of calculation itself. Throughout the trial, the petitioners canvassed that they are not paying any rent since 1998. It is mentioned in the written statement itself. In IA number 1 of 2026, it has been clearly mentioned that they are producing receipts which are stating that rent has been paid. Throughout the trial, they have maintained they are not paying any rent, but only the maintenance charges. Now they are saying 2,600 rupees was paid towards rent. That being one. Now, the trial commenced on 19/3/2025. The documents that they have produced.
See, we don't have to go into all that.
My lord,
These documents were never
Your
produced
Lordship,
before
I
the
am not
trial court,
disputing
nor they
that
were
difference
canvassed.
That's
amount.
what,
What I
no.
am fixing by the trial court, that is 9,500.
And
I
they have
seeking
been
some
paying the
concession
same
on
rent
that
of
9,000.
What do you
2,600.
say about that 9,500?
My lord, they have been paying the rent of 2,600 from 1994 for a property which demands which merits the rent of around 50,000 upwards, which is in a prime area of Padmanabh Nagar in Bangalore. It is a 2,400 plot. The rented house is around 1,400 square feet, my lord. They are
Now
in
you are going to,
1994.
you are going to get rid of all the litigation, so.
My lord, I would be
But
very happy
1994, I have
to
paid
give
60,000.
Huh? Let him say.
Please.
Huh?
The trial court has given them time of 2 months to vacate the premises from 28/4. Now it's close to 3 months. In the next 3 months, if they vacate the premises, whatever they have given the calculation, I'm willing to take that amount, provided they vacate the premises within the next 3 months, starting today. I can concede to that effect. The respondent is here before the court. He's an aged person, 74 years age. He has not stepped into his property for past 32 years. He has purchased that property. The petitioner is in occupation of the property for 32 years. He's paying the same rent he paid in year 1994. What else does he expect us to write out the property to him? Let him vacate the premises within next 3 months. Whatever memo of calculation he has filed, we are ready to take.
What is the extent of the home property? It might measuring
1,400 square feet.
Your Lordship,
1,400 square feet, 9,000 is the rent.
Your Lordship, kindly say.
9,500 is the damages that the court has awarded, my lord, since filing of the suit. It's not the rent, because the agreement is an unregistered agreement. It is month on month rent basis. Since I terminated the tenancy, the trial court deemed it fit against my claim of 10,500 rupees to award 9,500 as the damages, not as the rent.
Your Lordship, kindly say, I have paid the 60,000 rupees advance at the time of the 1994.
60,000.
60,000 in the 1994.
1994,
By considering all
16,000.
this,
Where are you now?
now we are in,
And you are spatting on the property from 94 to 2026.
there is no demand at all. He has agreed for continuing till
Can
issuing
you,
the
you
note.
pay that 1,20,000 and 3 months time? Please come.
Your Lordship, at least 6 months, I will.
My lord.
Huh?
6 months.
No. The petitioner is before this court. Agreed with the orders passed in SC number 825/2020.
Your Lordship,
Agree-
considering that what I have paid, the amount, which is 60,000, and it will come to the 1,20,000 according to him. Your Lordship.
Hmm.
According to me, it will come to 1,12,000. I'm ready to pay.
Take 1,12,000.
I'm okay with it.
Yes. The agreed with the order date.
He has to pay the damages till he vacates at the rate of 9,500.
Hmm?
At the rate of 9,500.
He is leaving all this.
Till he vacates the premises. That is what the trial court order is. That's it.
So another 3 months, that amount has to be calculated.
Yes, madam.
Please.
So how much it come?
It comes to
According to you, it is 1,12,000.
12,000. Another 20,500 rupees. 1,32,500 rupees would be the final.
1,12,000 and another?
20,000. 29 and a half, madam. 29,000.
For 3 months,
Yes, 9,500.
it will be 24,000.
27.
No, 27,000.
27 and 29,000. 28,500.
20?
8,500.
Hmm.
It will 1,40,500 rupees.
1 lakh?
40,500.
The petitioner.
4 months.
My lord, he is drawing at
He
straws.
is searching for.
You can't. Petitioner is agreed. Petitioner tenant is before this court. Agreed with a judgment and decree in SC number 825/2024, dated 28th April 2026, for the second edition of Small Causes Judge, Bangalore. The respondent herein has filed a suit for eviction, recovery of arrears of rent and damages. It is the case of the plaintiff that is the absolute owner of the property, and defendant was a tenant of the plaintiff on a monthly rent of rupees 2,600. The with an advance of rupees 60,000 under lease deed dated 1/7/1994. The tenancy was subsequently extended for a period of 2 years under lease deed dated 12/1/1998. Is a case that the defendant, the plaintiff had paid the rent. The defendant has paid the rent up to March 2024, but from April 2024, he has defaulted in payment of the rent. And he has not paid the enhanced rent for the last 10 years and is in arrears of rent amounting to 10,400 up to July 2024. Further, he requires the suit scheduled property for his bona fide personal use and occupation and requested the defendant to vacate the premises. And he has also issued a legal notice terminating the tenancy. And there was no response from the defendant. He has come before the court by filing the instant suit. The defendant filed his.
I filed my objections.
Huh?
I filed my objections.
Huh?
Filed my objections to petition also.
Filed a written statement and denying the ownership of the plaintiff. It's a case that he paid 60,000 as refundable security and subsequently paid additional sum of rupees 1 lakh in cash towards deposit. It is a case that the plaintiff, with an intention to sell the property and make unlawful gain, has falsely instituted the suit. And it's a case of defendant that he has already instituted OS number 2020 of 2024 before the City Civil Court, Bangalore, and had obtained an ex parte order restraining the plaintiff from dispersing him illegally. He has been paying money. After receiving the sum of rupees 1 lakh, the plaintiff permitted the defendant to continue in occupation of the premises for his lifetime. Hence, the suit is not maintainable. The trial court, the small causes court, had dismissed allowed the has decreed the suit and directed the defendant to hand over the vacant portion of the property within 2 months from the date of the order, and is directed to pay arrears of rent at rupees 10,400 from April 2024 to June 2024. And further, the defendant is directed to pay damage of rupees 9,500 per month from the date of suit till its realization. While passing the order, while decreeing the suit, the court has observed that the defendant cannot deny the ownership of the property. Where when he himself says that there is a tenancy between the defendant and the plaintiff. And with regard to payment of 1 lakh, there is no material placed before the court. And further, on examination of P7, the lease was extended for a period of 2 years on the same terms and conditions. And in Exhibit P7, there is no recital indicating an amount of rupees 1 lakh paid by the defendant. And the plea of lifetime tenancy based on oral agreement appears to be an afterthought and is not supported by any acceptable evidence. And accordingly, the court held that the plaintiff has successfully proved that he is the owner of the sued property and the defendant was inducted as a tenant. It is the court has considered the notice that is issued and also the fact that no reply notice was issued by the defendant. And the defendant, the court observed that the defendant is in possession of the premises as a tenant. And the tenancy is a month tenancy and has validly terminated the tenancy by issuing Exhibit P2. Accordingly, the court held that the termination of the tenancy is legally valid. And the court has come to the conclusion that plaintiff is entitled to recover arrears of 10,400 and damages at the rate of 9,500 per month. But however, the prayer with regard to the interest is rejected by the court. The court has directed the petitioner to hand over the vacant position within 2 months from the date of the order. But when this matter came up on the last occasion, with regard to what are the arrears of, what are the dues payable as per the order passed by the court. Both the parties have filed their calculation memo. According to the plaintiff, an amount of rupees 10 lakh, 1,20,000.
Yes, ma'am. 1,20,400.
1,20,400
is the due.
400, and according to the calculation of the learned counsel for the tenant, it is 1,12,000. 12,000.
Yes.
12,000. It is a learned counsel appearing for the respondent. Submits that they will accept the amount as per the calculation made by the petitioner tenant. It is submitted that he has been squatting over the property from 1994. It is submitted that the court has rightly passed an order considering all these aspects and there are no grounds to interfere. And counsel appearing for the petitioner submits that. Shall I record that you are ready to vacate?
Yes.
Submits that the petitioner is ready to vacate the premises, provided a reasonable opportunity is granted to the reasonable time is granted to the petitioner. Learned counsel appearing for the respondent submits that if the petitioner is ready to vacate the premises within 3 months, they have no objection. Learned counsel for the petitioner seeks 6 months' time, considering the fact that the petitioner is in possession of the property right from the year 1994. And this judgment and decree is passed on 28th April 2026, and already the time that is granted by the court has elapsed, balancing the interest of both the parties. This court deems it appropriate to grant a 3 months' time from today. Accordingly, this court is passing the following order. This court do not find any infirmity with the order passed by the trial court, and accordingly, and hence the writ petition is dismissed. However, number 2, the CRP is dismissed. However, considering the request made by the petitioner, and as it is acceptable to the respondent, the 3 months' time is granted to vacate the premises, and that is what is today. Today is 14th. 14th. The petitioner shall vacate the premises by 13th of
End of October.
Huh?
End of the October.
Huh?
October end. This is becoming honor before.
He's making all his efforts. He's not leaving it.
There is no termination of legal notice. There is no termination of legal.
Don't go to the merits of the matter now. Then you will not get this also. He shall vacate the premises by 30th of October. Until such time, what is the amount?
That is a 9,500. 9,500 per month. It would somewhere around come to 1,40,000 would be the final amount.
Earlier it is 1,40,500.
1,40,500 is the final amount that he has to pay.
The petitioner for these 3 months, along with as per his calculation, 1,12,000 comes to 1,40,500. He shall pay the same by that date, by 30th.
It would be better if you pays earlier to that.
He shall pay the amounts by 14th of October. The, huh. If the petitioner fails to vacate the premises, it is the, on the face of it, as it is clear violation of the orders of this court and also the concession that is made before the court.
He has filed execution petition.
I'm not precipitating them, on the last occasion.
You know, this is, or now it is disposed of. I know he cannot, he has to file a separate petition in the light of this order.
I have to wait till 30th. I won't be doing anything. Great.
Till number 41, PM Sidmalappa for petitioner, Shankar Narayan Bhatt for respondent.
Yes.
This case, paper. Petitioner, please. The petitioner filed the application before the trial court order 7/11.
What is the suit for?
Suit for injunction and mandatory injunction.
Yes. What is, where is your application? Please come to that.
My application is in page number 34, please, Lordship.
Yes.
He has sought for relief, a permanent injunction and mandatory injunction. I request this honorable court first I go to the mandatory injunction prayer, please, Lordship. The in page number 19, plaint to grant mandatory injunction against the defendant, directing him to hand over the Schedule B property to the plaintiff by removing the illegal construction of the compound wall or any other structures erected illegally by the defendant in the Schedule B property. I request this honorable court, please, Lordship. The plaint pleading para 7, without seeking declaration and possession of the property.
We will look at your application. What is that you have raised? Just like that, you can't make any submission. In your application, you are referring to at paragraph number 3 about the earlier suit.
Yes,
Anyhow,
please,
that cannot be part of this because that is your case. Court will consider it at the time and during the trial. Then number 4. What is it, para 4 you said?
The para 4.
Say that there is a family partition taking place and recorded under a registered partition deed dated 2/4/2011. Whether this partition deed is placed by the plaintiff?
Please, Lordship.
Is this partition deed placed by the plaintiff?
Plaintiff vendor.
Along with the plaint.
Along with the plaintiff.
So, even that contentions at paragraph number 4 cannot be considered.
Please.
Then come to para number 5.
Para number 5 with regard to court fee and.
For court fee that can be paid.
And pay. But my humble submission, please, Lordship. The suit itself is not maintained.
Why did you say so? The purpose of filing the application is that.
That was not mentioned, but provision of like 7 Rule 11 mentioned suit is barred by law.
7 Rule 11 itself is filed to say that the suit is barred on these grounds that you have to state.
I'm sorry, Lordship. I can make a submission this way. I may be permitted to file a fresh application with regard to that contention. It is the prima facie.
What is your contention?
Please, Lordship. The suit, I request this honorable court kindly see the plaint pleadings, please, Lordship. Para 7. The para 7, they have taken a contention, please, Lordship. I may be permitted to read the para 7 in page number, running in page number 16. 16, please, Lordship. He purchased the property, I have no issue at all. He says that I am a portion of the property on the southern side. It is also admitted fact. I am not disputing that. He taken a contention in the para 7, please, Lordship. After the survey department has issued a notice to decide owners on 24/10/2024 has conducted a spot survey and prepared the spot master, and the survey department has submitted.
I'm not able to find where is this plaint.
Para 16, page number 16, please.
In page number 16.
16. Para 7 of the plaint.
Yes.
Conduct the spot survey and prepare the spot master. And the survey department has submitted and issued a survey sketch on 28/10/2024 with the observation and specific identification of the schedule A property, wherein as per the report submitted and sketch prepared, it is reported by the survey department stating that on the southern side of the land in survey number 132/2, an extent of 2.5 guntas, and in survey number 133/2, an extent of 3/4 guntas, which is the herein called as a B schedule property, has been encroached by the landowner old survey number 144, new survey number 144/2, wherein as per the previous 4D sketch, as per the boundaries described in the registered sale deed dated 8/2/2023, it is very much clear that defendant is the person who hold land on the southern side of the Schedule A property. As such, it is evident that the defendant herein has encroached the plaintiff's land in Schedule A property to an extent stated herein above. In the survey record has been produced for kind pressure. Next para, please, Your Honor. The adbust has been conducted and the official survey report has been obtained by the plaintiff from the survey department. The plaintiff has approached the defendant and request him to hand over and said extend to the custody of the plaintiff, but the defendant has not responded positively to the request of the plaintiff. Even he was refused to make his signature to the spots measure conducted by the survey department. In that regard, please, Lordship, the trial court totally erred in appreciating, giving a finding. I request this honorable court, please, Lordship, finding para number
All
9.
never part of your application.
That is, but he has given a finding on that regard in point number 1 in page number 70, para 9, please.
I'm not able to understand what is all this exercise and arguments. How are they part of Order 7, Rule 11? And how can the court decide it, and neither that court or this court? These are all, what you're referring to, are all questions of fact.
Please, Lord.
Please come to the order, we'll read the order itself.
In reasoning, please, Doctor. 70 in page number.
70. Yes.
It is the contention of the defendant that the plaintiff has admitted the position of the defendant in the respect of B schedule property. Hence, the plaintiff sought to have filed a suit for declaration and recovery of position. But on going through the plaint averment, the plaintiff has stated that defendant has put up a compound wall illegally in the B schedule property. He has stated that in the plaintiff has been disposed from the suit B schedule property. Hence, only erection of the compound wall does not amount to disposition of the plaintiff. This is the finding given by the trial court. In the entire plaint, para 7, 8, and 9, please, Lordship, the plaintiff himself has admitted that I am in the possession of the property.
No, his case says you have erected a compound wall in his property.
It is he stated that in para 9. Para 8 says, please, Your Honor, he has requested me to hand over the position of the property. Subsequently, para 9, he says that he refused to hand over the property. He has constructed the compound wall. That is the case of the plaintiff. Para 9.
Your Honor, all these lands are agricultural lands. Hitherto, the lands were being enjoyed by, they are the adjacent owners, and it was a vacant land, it was being enjoyed. Now, all of a sudden, when the defendant started erecting the compound wall, he filed a suit for permanent injunction and a mandatory injunction to clear the compound wall. That is a talk. In the interregnum, he filed an application for rejection of the plaint.
Already there is one more order passed by me. What is this?
That was, they filed the writ petition as against the order. It was directed to be converted into a revision petition.
Converted into CRP, please. I filed the writ petition.
Yes. Third resort.
Cell number 42. Name
Third resort.
Cell number 42. Ravindranathyam.
I can submit, please, with liberty to file a fresh application. I can make an application before the trial court, please.
How many times you will make the application?
That will come restricted. If permission of this honorable court, I can make an application. It is only, I am not mentioning the
if he says that if he reserves liberty, it is not permissible, since it will be hit by res judicata. It will be hit by principles of res judicata.
With permission, it cannot be res judicata. Without permission, once I can file again same application, I cannot As per the application, I have not mentioned that word, the suit is not maintainable, he has not sought declaratory relief.
Alla,
That
in his
word
affidavit, not even a single word regarding the
purpose I am
contention that
requesting.
7 Rule 11, how the provisions of 7 Rule 11 are applicable to the instant application on hand. Nowhere in his application such grounds are made out.
We'll set aside this order and permit him to come up with an application stating the reasons.
In that case, I may be permitted to amend the plaint. I may be permitted to amend the plaint, seek a relief of declaration.
If he sought the declaration, question of rejection of plaint does not arise.
Reserved.
Cell number 42, Ravindranath M for petitioner.
Last date of hearing will not directed me to serve on the council for respondents.
Await service of notice in respect of R1 and R2.
R1 and R2 are filing.
You appear? Yes. Land council submits that. Land council so and so. Submit that she has instructions to file wakalat. She already filed or you're going to file?
We are filing now. We
File in the
received
registry.
instructions. Yes.
Filed as instructions to file wakalat on behalf of respondents 1 and 2. Yes.
The matter may be heard now.
It can be heard.
It can be heard.
But in a suit for
No, we'll
partition,
share where you, today no urgency for this. Yes, the list is matter on 4th of August. Yes,
Cell number 43,
the first list.
first list.
Please.
Yes.
43. R. Hemant
If
Rai
the
for
CRP is
petitioner.
not maintainable, I have to file a the RFA. First appeal.
The court has raised an objection. What is the order?
Order
2197.
7 Rule 11.
Order 7. It is rejected.
Allowed, your lordship. Application is
That is
allowed.
allowed. The plaint rejected.
The first, I have to file a RA.
Yes.
First appeal.
The office has raised objection with regard to maintainability as the petition has come before the court against an order allowing rejection of the plaint. When counsel the petitioner submits that the petitioner may be permitted to withdraw with the liberty to file the appropriate, to file an appeal. Accordingly, the CRP is dismissed as withdrawn with the liberty to file an appropriate petition in accordance with law.
Delay may be.
The petitioner shall file the appropriate appeal within a period of 2 weeks from the date of receipt of the copy of the order. The registry is directed to return all the documents by keeping a copy of the same.
Delay may be continued in case.
Which delay?
Delay, your lordship. The earlier occasion also, your lordship, by mistake.
50 days delay.
50 days, earlier occasion also by mistake, your lordship, they have filed a RA before the district court. That is the correct procedure. By mistake, your lordship, the district court, the jurisdiction not comes under, you file a CRP. That is the reason, your lordship, they are withdrawn and filed a CRP.
Where is the delay?
Your lordship, kindly take page number 24, your lordship.
No, where is the delay?
Delay filed application, your lordship.
How much is the delay?
Delay is more than 60 days, your lordship.
IA number. But without notice to anyone, how can we condone the delay?
This is, your lordship, the only
But the
for.
court will consider now, in the light of now, till you have, from the
Anyway, your
date,
lordship, the
from the day.
relay is bona fide because of, your lordship,
No,
already
that's what
filed
please
appeal
understand.
before the.
You have, from the date you have come here, section 14 of the Limitation Act. Before that, whatever is the delay, you can tell the
No, that
court.
is not correct. Kindly take page number 24, Lordship. Page number 24, my appeal memo, kindly see. Earlier occasion also, Lordship, filed a appeal before the district court.
Then in that case, I'll order notice to them.
Ultimately,
But
CRP
we
is not
can't, but I
maintainable.
can't condone the delay like that.
Reason is this, kindly pay 1 second, Lordship.
You have to notice, I will condone delay, or
Page
else you
number
work out
24.
your remedies there.
That is not a used delay, Lordship. That is only for 60 days.
Whatever is delay that like cannot be condoned like that.
For a moment, kindly see my appeal memo for page number 24, Lordship. Page number 24, I have stated why the delay should be condoned. For a moment, kindly
Is
look.
it not an order condoning a delay that can be passed without the presence of other side?
That is all, Lordship, the technical.
What to do? What to do? Two things, either I will permit you to go or else you have to wait for them to come.
Anyway, Lordship, the CRP is not maintainable. That is the reason I am requesting. I have to
I
file a
will
first
not
appeal
condone the
before the
delay.
court.
I will say because you have a reason that you can tell before that court. wherever the.
What I am requesting is whatever the period before the Honorable Court, delay may be
That
continued.
you will entitled. That you are entitled from that section 14. No, that's why I said you have to file the whatever it is within 2 weeks from today, from the date of receipt of the copy of the order. I said so.
And also,
In between what has happened, you can tell that.
in addition also, because that is continuation of action.
But possible.
That is continuation of action.
Court is to the respondents. We'll see once a matter when the respondents.
Anyway, the liberty may be done.
Yes.
Within 2 weeks, should delay may be
Yes,
continued.
yes.
Rest of the other.
Yes, next.
Number 44, Arvindan.
This letter for extension.
That is 2000 ward suit, my lord, 2009 plaintiff case. This writ petition 4521 already disposed on 17th for 2025.
Oh, this suit is of the year 2020.
No, clubbed in original suit is 2009. Plaintiff filed by the partition. My lord, another suit, 2-3 suit is clubbed together in ward 2009 suit, 2022 and 21, my lords. My lord, in page number 26, old number, OS number 1230-2009, new number 3261-2022.
The court, learned judge is asking for a year's time. The court, a coordinate bench of this court has directed the trial court to dispose of by order dated 7th April 2025, has directed the court to dispose of the matter as expeditiously as possible, but not later than 1 year from the date of receipt of the copy of the order. A letter is addressed by the learned judge, stating the reasons why they require another 1 year time, considering the reasons stated.
My lord, 3 months may be, my lord, only.
Extension is as sought, because how come
The plaintiff
2009,
no, I am for DW 13. Plaintiff only. Every date he absent and stage is DW.
the time has sought for of the 1 year is granted. However, it is made clear that no further time will be extended. Yes.
Cell number 45. Cell number 45.
And someone.
And summons that advocate has refused, my lord.
Then
Respondent,
for that you can file a memo saying that he refused.
I have requested my counterpart's affidavit to that effect.
Yes,
I'll tell
this
you.
is matter after 2 weeks.
Cell number
This 46.
46.
My lord, for the petitioner in this case, my lord, I may be permitted to take notice on before the trial court counsels, my lord.
Yes, notice on the council of before the trial court.
A date may kindly be fixed, my lord.
This is a matter on 12th of August. Yes, 47.
Cell number
Please.
47.
Lots,
Shivakumaran.
please.
Maintainable.
Lots. This is the matter where on the stamp duty it has been challenged.
Maintainability of
Please.
the order.
Since my lords, trial court has already passed impugned the order and we have paid the deposit stamp duty. And again, after lapse of 7 years, defendants has filed applications
No, whatever
to
it
review.
is,
Only to review.
what do you say about the maintainability? Under 43 rule 1.
My lords, they have to prefer the appeal, not for the review. He has filed the application under 47 rule 1 to review that order. That is not correct. It's my submission. Hence, I have filed the petition.
No, against the order passed by the court, what is your remedy?
That order is not incorrect.
If it is not
Without
correct, you will tell
jurisdiction.
the court which
Please.
has jurisdiction that it is not correct. For that, you don't have to come to this court. Please come. The office has raised objection with regard to maintainability in view of order 43 rule 1.
Then I.
The learned counsel for the petitioner submits that the order passed by the court is without jurisdiction. Whether it is with jurisdiction or without jurisdiction, the remedy available to the petitioner is to file an appeal. The petitioner can raise all these grounds in the appeal accordingly.
I may permit to file, convert the
Petition
MF.
is dismissed as withdrawn with the liberty to file the appropriate petition with a period of 2 weeks from the date of receipt of the copy of the order.
Cell number 48.
All the same in this, all documents to be, and by keeping the Xerox. Yes.
That's the time spent in this writ petition make.
When the court grants you 2 weeks time,
Please.
it is,
But the trial court will not consider.
trial court has to understand.
Archana Murthy.
My lords, office objection is that, my lords, why plaintiff number 6 is not made party in this writ petition, my lords. But she has expired in the year 2013, my lords. So have written the same thing, my lords. Kindly overrule
What
the
happened to
officer.
the before the trial court?
My lords, suit for declaration and injunction, my
No,
lords.
no. Before the trial court, LRs are brought on record.
Please, my lords.
Then you have to get them also on record here.
No, my lords. Plaintiffs 1, 3, 4, 5, they are already on record, my lords.
Then what you should do, you should make her, as per the cause title, because she is there, so and so, dead, represented by LRs, they should be they should be shown as so and so, so and so. Office objections or sustained, petition shall comply with the office objections. Yes.
Serial number 49. Kushal K. Kaushik for petitioner.
No, appearing for respondent 12. Today morning I filed a work. So please stamp for my argument.
So and so submits that. You already filed.
Today morning.
So and so submits that, yes, filed wakalat on behalf of respondent.
One, my lord.
One. What about 5 and 6?
My lords, 5 and 6 have also been served, my lord. I filed a memo.
Memo is filed stating that they served notices on 5 and 6. Accordingly, the notice to R5 and R6 is held sufficient. Then what about one?
My
R1 is appearing. Then what about the other?
The remaining are all ex parte before the trial court, my lord.
Then we have given a memo.
Yes, my lords, I filed a memo to that effect. My lord.
Already order is passed.
Yes, my lords.
Already court has passed orders on the memo.
No, my lords, no, my
Give
lords.
the memo.
He has to file the memo.
Memo has been filed, my lord.
No, where is the memo?
Memo file ಮಾಡಿದ್ದೀನಿ along with proof of service.
Not proof of service. Dispensation
Dispensation
of
memo I
notice.
have not filed, my lords. I apologize.
Yes, file. Yes, this is matter on 6th of August. Yes, next 50.
Serial
My,
number 50.
my lords, if I may just, my lords, I apologize.
Panchamadi.
The matter is listed for the learned trial court tomorrow, my lords, and then there is the trial court has been insisting to amend the plaint, my lord. If an interim order of stay could be passed.
How will I pass an interim order? When I have issued notice means that this is not a case for interim order. Yes.
Obliged.
Serial number 50. Panchamadi for petitioner.
I request for pass over, my lord, sir. As there is
Pass over at
urgency.
355.
Not, sir, the
Respondent 2 is
I am-
KPTCL.
Huh?
KPTCL
Respondent
matter.
2 KPTCL, they have to answer.
Oh,
One and 2.
what is the now name of the councils? Where is that? KB councils.
In the connected matter, this court has ordered that not to proceed the matter. my lord.
Without hearing them, I will not pass.
Kindly
any
pass
order.
over, my lords.
Huh?
I'm
Have to
the,
serve papers on the council appearing for the KB. I'll take notice I'll take this matter tomorrow.
at 2:30 minutes,
It will come when it will come.
please.
See, Chennai Gowda is directed to take notice on behalf of the respondents, petitioner and counsel for the
Not
petitioner.
Chennai Gowda, my lords. H.V. Devraj. In a similar matter, he has taken notice, my lords.
Mr.
H.D. Devraj.
H.V. Devraj is directed to take notice on behalf of the respondent. Petitioner shall serve the copy of the writ petition, and the learned counsel for the respondent, Mr. Devraj, shall get specific instructions. List this matter tomorrow
Please.
in the first list. Yes.
51.
Please, Murad, I apologize for being on video conference. I'm not feeling well.
Yes.
Murad, this is a matter where the trial court, Murad, entertains an application seeking for ex parte interim order, despite there being a caveat on record, Murad. I filed a caveat, parties are the same. They deliberately, Murad, file it putting a different survey number. I have nothing to do with that survey number, but if my lords were to kindly see the plaint and the caveat is filed 1 day prior to, Murad, the suit being filed.
So
Parties
why
are-
you have come here?
Malad, now how that Malad goes with regard to jurisdiction to say, Malad, on what basis do you even entertain, Malad, an application when there's a caveat there? Caveat, Malad, is not even put up. It had to be put up, Malad, the court had to be.
And you have to bring it to the notice of the court, and you should ask the
Malad,
court.
what happens is now, Malad, by virtue of this, now this, I'll just be very, very brief with the facts of the case, Malad. The plaintiff, Malad, before the honorable trial court.
No, before going into the facts of the case,
Please.
an order is passed. There
Please.
is any irregularity in the procedure.
Please.
Caveator is not served. So
Please.
what is to be done?
Malad, there are two aspects which I would then go on to, Malad.
Now
One
you
is, Malad,
now
if it is-
you file caveat in the High Court. The court without issuing notice to you has passed orders. You will straight away go to Supreme Court.
Malad, if
You
that
will
is
not
the case, if there's a caveat, it doesn't mean that I have to file objections, Malad. It is only that I have to be heard.
You can boo the court saying that this is what it is. And why will this court interfere with all that?
Urgency
Because there is
mode is this, my
there
lord.
is an irregularity, then they will ask the
Yes.
court to rectify it. It is not,
Lord,
the
the
court is there.
rectification, no, my lord, I cannot undo what has already been done. But only what I can only seek for is, my lord, a stay as far as that particular order is concerned. Because if that
No, no, no.
continues to be here, as
Not
against me,
giving,
my lord,
I will ask the trial court itself to hear. When is the matter coming up?
my lord, I will just. (22/7), my lord, is the next date. 22/7.
Yes.
If my
It's
lords were to
coming up
kindly-
on exactly a week.
I understand, my lord. May I just make one last submission, my lord? If my lords were to kindly see the impugned order itself, my lord, that is to say, at least because as far as writ maintainability is concerned, if I can at least persuade my lords as to
No,
whether
no,
the
no,
order
not
is
on
decent.
maintainability, not on maintainability. First of all, we should stop this kind of, coming to the High Court for every case, wherever an injunction is granted, not granted for everything. Let the court decide. I will tell the court. I will also ask the court to look into the fact when the caveat is there, why did the court, without even noticing that fact, how the court has considered it.
Please, my lord,
And
but
expeditiously on the date
I understand, man, but the interim order would still continue to be against me only for the simple reason that, my lord, even 22/7, if it is taken up, I file my written statement also, it will take some time till the order. That is the only
No,
urgency.
I'll ask the court to decide it within 1 week.
But at least, my lord, can the interim order at least be interfered with, my lord, to one extent? Because if that is the case, I
If
lose
the
out on time.
interim order is interfered with, I issue notice to the respondents, call them here, then both of you for another 3 months, 4 months, let this go on before the court. Then again, we'll send you back to the trial court.
My lord,
That
I
process,
see what my
that
lords
process
is.
will cut short. That process will cut short. The court, what it has to do, it will do on 22nd. If not, if it is not happening on 22nd or immediately the next day, I'll ask the court to deal with this. Yes.
My lord,
Please come.
please, if my lords may also kindly clarify this one aspect, my lord, it may be touching a little on the merits. I don't want to trouble my lords any further. I have nothing to do with the social property, my lord. My lords may record that as well, because if this is not troubling me, I can at least go to the police station and say,
Where is the order? Please come to the order.
please, my lords may kindly come to page 38. There's absolutely no reasoning, my lord. 38, if my lords were to kindly see.
The petitioner is before this court questioning on order passed in I number 1 in OS number 3823 of 2026 dated 4/6/2026, whereby the court has granted an ex parte temporary injunction restraining the defendants or anybody acting on their behalf from interfering with the plaintiff's peaceful possession and enjoyment of the suit scheduled property till the next date of hearing or filing of objections, and issue notice. Notice on I number 1 and suit summons to the defendant. Matter is directed to be listed on 22/7/2026. Learned counsel for the petitioner's officer. The petitioner has filed a caveat, and without even issuing notice to the petitioner, the court has passed the order. It is submitted that the petitioner is, you are not, what is your submission?
Lord, I have nothing to do with the social property which they have shown in the plaint, my lord. I have nothing to do with it.
Then
This
how
is the-
are you bothered with the interim
Now, my
order?
lord, they go to the cops by virtue of this, my lord. Now, the cops are now troubling me as far as they go to the jurisdiction police station, say that I have an interim order, and now they're trying to identify. Theirs is, my lord, 49/3, 49/4, I'm sorry. I am, my lord,
That the
54/1.
petitioner is not claiming the suit scheduled property. Petitioner has unconnected with the suit scheduled properties. Now, under the guise of the interim order that is granted, the plaintiffs are going to the police, and police, under the guise of that said order, are trying to interfere with petitioner's position.
Please.
Position. It is submitted that the Land Council has also argued on the merits of the matter and submits that this is a case where the court has to interfere with the order impugned. Next para. Having heard the counsel for the petitioner, there is a material on record. The court has granted a temporary injunction. It is a contention that the petitioner has filed the caveat. Caveat in respect of which, why you would have filed a caveat
Lord,
in
no,
respect
it is not in
of
respect of their
property which
property.
you are unconnected with?
It is not in respect of their property, but the parties are the
Then why
same.
Then why will they not issue notice to you?
Because, my lord, it's on the parties, my lord. So the parties are the same. Address is the same, parties are the same. My property is different. Because he starts interfering with my possession, I know for a fact, my lord, he then tries to go to the police station. He then receives my caveat. Next day, my lord, very cleverly what he does, he files it, my lord, for his property. 2/6/2022.
Both are clever. You
My
are
lord,
also clever, he is also clever.
my lord, as far as I am concerned, I have defined that very specifically in my caveat.
What did you write? Petitioner has filed caveat and without notice to the petitioner, the order impugned is passed. As far as the submission with regard to the merits of the matter, this court is not inclined to hear. If this court interferes with, on whatever ground, if this court interferes with the order, the notice has to be issued to the respondent and unnecessarily it will protract the litigation. The matter is coming up before the trial court on 22/7/2026. Hence, this court deems it appropriate to direct the trial court to deal with the objections that are filed by the petitioner. And particularly, the court as well also consider and give a finding with regard to the caveat petition that is filed by the caveat filed by the petitioner and why the notice is not served on the petitioner or without notice to the petitioner, why the court has passed an order. In that view of the matter, this court is passing the following order. On 22, the petition is disposed of, directing the trial court to consider the objections filed by the petitioner on 22/7/2026. If by any chance the court is not able to conclude it on 22/7, by 23/7/2026, the court shall pass appropriate orders. No notice is issued to the respondent that as no adverse or orders are passed against them.
Please, grateful.
Prasad KP for petitioner.
Notice.
Sale number 53. This also notice.
For respondent, my lord.
Seeking an adjournment in this matter, my lords,
The copy of the petition.
will serve.
And counsel the petition saw the copy of the writ petition and the counsel for the respondent. This is matter on 6th of August. Yes, 54.
Number 54.
Notice.
Sale number 55. 55. Purnachandra M. Puranik.
Notice to R5 and R6.
R5 and R6, the other family members are represented by him only, my lords. I've
You
served
take
it.
notice for them. I take it. Then counsel for the counsel appearing for the respondents 1, 2, 3, 4, 7, and 9 submits that he has instructions to appear for 5 and 6, and he'll be filing his vakal. Yes.
Urgency is that, my lord, the matter is posted for judgment before the trial court. My application under
What are you
order,
doing for order 7 rule number till the judgment is, the matter is posted for judgment?
it's application under order 23 rule 1, seeking leave to withdraw the suit with liberty to file a fresh suit on the same cause of action. Reason being, my lord, my suit is defective for following reasons. There are some formal defects. One is, my lord, that suit is for mere declaration without seeking any consequential relief. So my suit is hit by section 37 of the specific relief act, my lord. And as
was the suit filed?
Suit is filed in the year 2015, my lord.
11 years ago.
But the provision doesn't bar me from filing this application at any stage. If your lordship may see the provision, withdrawal of suit or abandonment of part of claim.
Where is the order? Order.
Order, my lord, is at page number
17. Relevant portion is 18. Ink page 8.
Only on the delay, my application has been rejected.
No, you will pursue the matter. You will let the court engage in the dispute between the parties, let evidence, waste the judicial time, and after the entire trial is completed, then you will say that now I will withdraw the petition. Just because it doesn't say about the limitation or the thing that doesn't mean that any point of time you will do it. There should be any act should be reasonable. There should be some reasonableness. And why have you not taken this plea earlier?
Only at the stage of arguments I've got to know.
You understood that you are not going to succeed in the suit.
But
Yes.
the provision says, my lord, that any time after instituting of the suit.
So many provisions says anytime, but all can't be filed whenever you want. Let's see that. Please read para 2.
An application for leave under the provision to sub-rule 1 shall be accompanied by an affidavit of sub-rule 3, my lords, where the court is of satisfied that the suit must fail for the reason of some defect, or that there are sufficient grounds for allowing the plaintiff to institute a fresh suit for the subject
So
matter.
according to the defendants, they are in possession of the property. You have not sought for recovery of possession.
I'm not sought for delivery of possession. It's a mere suit for declaration. And as per the pleadings, I say that it's a joint family property, and I'm not sought for partition. So these are the formal defects in my plain matter. Therefore, I'm filing this application.
It borders on abuse of process of court.
Huh?
It borders on abuse of process of court. Your Lordship, kindly see. They say the formal defects, but the suit is of the year 2015. I filed written statement in the year 2016. The contention which I have taken in the year 2016 itself.
What is the limitation for recovery of possession?
You ought to have filed a suit for declaration. This is declaration to set aside the sale deeds which has been executed in the year 1986 and 1992. Suit itself is barred by limitation. His father has filed a suit that is dismissed. Now he had set up his wife and son to come up before the court and file another suit in the year 2000. I have taken all those contentions in my objections.
That doesn't, my lord, this formal defect still appear.
What is a formal defect?
Suit is hit by section 37 of the Specific Relief Act. If I may read section 37, my lords.
You should have amended the plaint from 2016 itself. When I took up that plea before the court. When the matter is posted for arguments, my lord, he filed an application to recall and reopen the case. That was allowed. Thereafterwards, he cross-examined my client. Thereafter, one more application he filed seeking indulgence of the court to appoint another counsel. Though one of the plaintiff is an advocate, another is an engineer. They filed an application to sue as a pharma pauperis. Lord, that is rejected. Thereafterwards, he filed an application for appointment of commissioner. That is also rejected. And thereafterwards, they have come up with this application to withdraw the suit with permission, with liberty to file a fresh suit. His father has already filed a suit that is dismissed. And now they set up his wife and son to come up before the court. Now they say relying upon 37, 36, it is open for them.
Yes.
Section 34, proviso, my lords.
Great.
Provided that no court shall make any such declaration where the plaintiff, being able to seek further relief than a mere declaration of title, omits to do so. So I could have sought for consequential relief, which I did not seek. So this is a formal defect which exists in my plaint. And also in my pleadings, I say that it's a joint family property of my family members, and there is no consequential relief of partition. So these are the two formal defects in my plaint. Therefore, I filed this application in order 23, my lord, seeking leave to withdraw on the same.
Earlier you sought for amendment of plaint.
Earlier, I have not sought, my lord.
No, you have sought, you are saying though.
No,
I did not seek for amendment of plaint.
Earlier.
No, my lord, it's not in this suit.
No, he ought to have, earlier suit was dismissed.
He's saying I should have sought for amendment of pleadings, which I did not seek for. Now I'm seeking order 23, rule 1, seeking to leave.
Yes, heard it, sir.
Lord, judgment may be deferred, my lord, till then.
Dismissed. Yes.
Cell number 56.
I appear for the respondent number 1.
Yes.
But my construction is stalled, and that is where, my lord, I have filed this application.
Here is Somashekaraya.
It's a mere suit for mandatory injunction. Notice is ordered by the trial court on me, my lord. And on that, my lord, a writ petition is filed before this honorable.
Suit summons are issued.
So suit summons
on
is
that
issued.
writ petition and interim order.
Interim order not to put up construction. Suit for bare mandatory injunction that the demolition must be ensured. My lord, on that basis, my lord, I have been started.
This is matter as a first case tomorrow.
Please, great.
No representation on behalf of the petitioner.
Right.
Cell number 57. Cell number 57.
Petition. I for bringing LR application and set aside and delay application of the petitioner.
Donation of delay 2026 for abatement.
Of petitioner.
What is the delay? How much is the delay?
2024 husband was died, my lord.
Why you are filing it here?
So miscellaneous.
You filed the petition in 2026.
Please.
Then why are you
Yeah.
filing a section 5 petition here?
Office objection is office is raised the
No.
office objection, my lord.
Even before this is filed, the so and so died.
No, my lord.
Uh,
After miscellaneous petition, non-prosecution was dismissed, my husband was died.
when
Then
was
I
the
have filed the
miscellaneous-
writ petition, my
When the
lord.
miscellaneous petition was dismissed?
29/11/2024, my lord.
Against that, you filed this writ petition in the year 2026.
2026. My husband was died 8/12/2024, my lord. Suffering from cancer, my lord. Only CMIS was dismissed for non-prosecution, my lord. Restoration of the MUC petition, my lord.
Then who is the petition before the
Petitioner
court?
is the husband of the petition.
Here.
My husband was filed the MUC petition.
Here before this court.
Wife and children, my lord. Firstly,
They were not-
my husband was filed a MUC petition seeking enhancement, compensation, my lord, accidental petition. The MUC petition was dismissed for non-prosecution. Then I have filed the miscellaneous petition for restoration of the.
Wife has filed the miscellaneous petition.
No, my lord. Petition, husband was filed, my lord. Then the husband was suffering from cancer. I have appearing for before the trial court, CMIS case. Then I have CMIS also, miscellaneous petition also dismissed for non-prosecution. Then I have filed the writ petition, my lord.
What I'm asking, you are not a party, none of these petitions are parties to the miscellaneous petition.
No, ma'am.
How can you straight away file this writ petition like this?
My husband,
Yourself like,
after dismissal of the miscellaneous petition, my husband was died. Then I have filed the.
I understood. You are not understanding my question. You can't file writ petition like this. You have to seek the leave of the court.
Please.
Isn't it? Straight away, you like whoever are all LRs, you only declared whoever are, you made them a parties and you filed the writ petition. And now to whom the notice has to be issued?
No, my lord.
Already the parties who are there on record,
Please.
for them, the court has to condone the delay. They were already
Accept.
there. You yourself have declared yourself as LRs of the
Petition.
deceased.
This is. Office
Can
is
you give
raised,
Mr.
office is
Counsel-
raised, the office of
The
petition.
office has correctly raised. First of all, this letter, the office shouldn't have numbered this like this. The petitioner shall seek the leave of the court for filing this writ petition, and the writ petition in this form cannot be entertained. Yes.
Please.
Cell number 58. Cell number 58. Satish
Petitioner.
Kumar KH.
Yes.
I beg to object.
Oh, which? 57, no, let him do the correction. Yes.
My lord, kindly see annexure L in page number 48.
Hmm.
Bescom has issued a notice.
48.
48, ma'am.
Hmm.
Annexure L.
Hmm.
Bescom has issued a notice for disconnection of electricity connection. This notice issued on 8/6/2026, but same was served through WhatsApp on 29/6. Immediately, we have filed objection. It's in annexure M on 2/7/2026. My objection was not considered by the Bescom.
So
Without
this notice is dated.
notice dated 8/6. Your Honor.
Where do you get the date? Where do you find the date?
It's in annexure L.
I'm looking at page 48.
48.
Disconnection notice.
Yeah, it's in headline. Left hand side.
8/6/2026.
8/6/2026 notice dated.
Oh.
Same was served through WhatsApp on 29/6.
Hmm.
I have given reply. I have filed the objection on 2/7/2026.
Hmm.
My objection was not considered.
Hmm.
Without that, they are trying to disconnect the electricity connection.
Yes.
Objections will be considered in court.
No, this I'm not able to understand. Yesterday also in another matter, I have asked the panel counsel. No, whenever there is violation of the building condition, on the letter by the whoever is a local authority, PESCOM will disconnect the power supply.
Supreme Court direction.
Huh?
Supreme Court direction is there. Therefore, they are issued. We'll consider the objections.
Yes, Mr. Senior Counsel, what is it? Yes, your matter is also the same.
Yes, please.
Uh,
Lord, there is a judgment of this honorable court,
uh,
coordinates bench decision, my lord, where this issue is already answered.
uh.
We just place it. It specifically says that as far as the illegal constructions are concerned, my lord, the BESCOM has absolutely no authority. It has to
That is
place.
what.
And even the Supreme Court
No,
judgment.
in fact, in Telangana also I have the detailed judgment on this. Even with regard to the revenue officials also, if the government says there are cases like it's a government land because it is government land because government claims that it is their land, municipality will, though you have a sale deed, municipality will not grant permission. So because they are all different departments, they have to independently work out their remedies. This is not the connection.
Yes, ma'am.
Where is the Supreme Court judgment?
My lord, Supreme Court judgment is also clarified in this. Kindly see. 25.7.
25 point?
25.7, my lord, page number 85. On the first aspect, notice dated so-and-so appears to have been issued primarily on basis of cancellation of Khata by the BBMP. ESCOM authorities are not authority competent to determine the legality or illegality of construction. Their act of proposing disconnection was triggered by and was a consequential to the BBMP cancellation order. Subsequently, my lord, the Supreme Court judgment is also clarified at 25.9. As regards the reliance placed by the respondent on the directions of the Honorable Supreme Court in the case of so-and-so, this court has already observed under point number so-and-so that said directions are primarily prospective in nature. Direction 4 thereof states that service connection shall be given to buildings only after production of completion of occupancy certificate. The key word here is shall be given, which indicates prospective application. It applies to new connections to
It
be
has to be
given.
set aside. This notice has to be set aside.
Consider the objection.
And tell your officers, stop doing this exercise. At least in the light of this judgment. The writ petition is filed. Questioning the notice, the writ petition is filed in the following prayer. When counsel to the petitioner submits that the respondents have issued a notice dated 8/6/2026, which was received by the petitioner on 29/6/2026, stating that they have been informed by the assistant executive engineer that the petitioner has violated the sanction plan in connection with construction of building. Hence, the petitioner is informed to obtain clearance from the assistant executive engineer and submit to the office within 7 days, or otherwise the installation will be disconnected. When counsel appearing to the petition submits that, in that in response to that, the petitioner has submitted his response on 2/7/2026. So far, they have not passed any orders, but they are interfering with the petitioners and with their threatening that they'll disconnect the power supply. It is submitted that the respondents have no such authority with the respondents without passing any, having issued a notice, and when the petitioner has submitted his reply, ought not to, cannot disconnect the power supply. Next paragraph, when counsel appearing for the respondents submits that they'll pass appropriate orders till such time they'll not take any coercive steps. Next paragraph, having got the counsels on either side, there is a material on record. When the notice was issued, to the notice dated 8/6/2026. It is a case that the petitioner has received it on 29/6/2026 and immediately has submitted his response to that, and admittedly so far no orders are passed. Without passing any orders, the respondents cannot interfere with cannot take any coercive steps. Considering the submission of the written counsel for the respondent, this court deems it appropriate to pass the following order. Next, accordingly, the writ petition is disposed of, directing the respondents not to take any coercive steps till the order is passed. Number 2, after passing the order, they shall give at least a week's time to the petitioner to avail the legal remedies.
Cell number 59,
Much
A and B for petitioner.
Yes.
For
Nine
petitioners.
WS.
Swami, in this subject,
yes,
my respectful submission to this honorable court, through the impugned notice, the petition was directed by the BESCOM to approach the concerned panchayat authority and give proper documents.
my question was, how are you connected with all that? The panchayat and they will deal with it. How the BESCOM is concerned with this?
No, because even in 2025, they have only communicated to the panchayat, wherein their communication itself discloses that property tax are due against the property. Apart from that, even the Khata information discloses does not disclose about how much floor that property is having.
That is a local authority's problem. They will take care.
Yes.
What is your business?
No.
I'm asking.
No, even the BESCOM, BBMP and Panchayat are interconnected with each other with regard to the administration of the.
Then BESCOM should grant.
No, that's why kindly your lordship.
No, I'm saying BESCOM should grant permission for construction. And
that's why we have not. In the impugned notice, we have not informed about disconnecting the power connection. We have not mentioned anything about disconnecting the power connection. We have only requested the petitioner to approach the panchayat authority. You furnish the.
Why are you requesting?
That's why I have stated all the departments are interconnected.
It is not like that. Every department has to do their work.
Because
if they do their work, that is better.
While taking the temporary connection also, they have furnished the document to the effect that we have the appropriate tax paid receipt, everything that they are the submitting to the BESCOM authorities, which is not forthcoming. Even the Annexure C itself, Annexure C, your lordship will appreciate, page number 20.
I cannot appreciate anything.
That is the document furnished by the
without jurisdiction. You are unnecessarily interfering in something which you are unconnected with. So BESCOM should mind their own business. They shouldn't get into all these things. The Gram Panchayat or the BBMP, they will take care of their problems. And if there is anything in violation of your regulations, then you have to take action.
If your lordship may pass the said order, I will communicate the same to the authorities.
Tell them if I keep on these kind of orders, if I come across, whoever we will take action against the concern.
I will bring the same to the concerned authorities.
The present writ petition is filed, seeking the following prayer. There's a case with the writ petitioner that petition is absolute owner and the khatedar of the property bearing khata number 422/246 measuring 120.19 square meter, situated at Devara Kagalahalli village, Cheluru Gram Panchayat, Haraholli, Hopli, Ramnagar district. Petitioner has constructed a building on the scheduled property for the purpose of securing an electricity connection to said building. The petition applied to the Cheluru Gram Panchayat, which has issued a no objection certificate dated 22/5/2024, stating that the Gram Panchayat has no objection whatsoever to BESCOM releasing an electricity connection to said building. Acting upon the said NOC and after due verification, respondent number 1 sanctioned and released the electricity connection to the scheduled property, which has been in the name and used with the petitioner. The petition is currently running a PG with over 50 female students being residents at the scheduled property. The petition was served with a notice dated 4/8/2025 by the Cheluru Gram Panchayat alleging unauthorized construction and asking her to furnish documents in answer to the said allegation. Pursuant to the same, the petitioner furnished all the necessary documents to the said Gram Panchayat by letter dated 12/8/2025. There has been no further communication on the said reply letter dated 12/8/2025 issued by the Gram Panchayat. While this being so, respondent number 2 issued the impugned notice dated 3/7/2026 calling upon the petitioner to submit documents clarification to Gram Panchayat within 7 days from the date of the notice and obtain NOC from the said Gram Panchayat and furnish the same to the respondent number 2. Failing which the electricity connection, the petitioner would be disconnected. Basing on a communication by the Gram Panchayat. It is stated that the petitioner has already issued a response dated 7/7/2026 to the BESCOM and furnished all the relevant documents to Gram Panchayat on 7/7/2026. And the Gram Panchayat is yet to give the NOC. Land Council appearing for the petitioner submits that this order passed for the the BESCOM is without jurisdiction. It is submitted that if the petitioner has committed any violation as per the regulation of the BESCOM can take action against the petitioner. With regard to the permission that is granted by the Panchayat and all, the Panchayat will take appropriate action in that the BESCOM authorities have nothing to do with the same. It is submitted that the notice that is issued is without jurisdiction and the same has to be set aside. It is further submitted that a coordinate bench of this court in WP number 26870 of 2023, clubbed with WP number 17679 of 2024, dated 26 February 2026, has passed an order wherein passed an order. This where is that you are referring to?
Page 85.
25?
Page 85, 25.7 and 25.9.
25.7. He relied on 25.7 and about the Supreme Court judgment?
25.9 minutes.
25.9 and 25.9. Relying on this, then council submits that the writ petition has to be allowed by setting aside the notice issued by the respondents. Next para. Then council appearing for the respondents on instructions submits that the basing on the communication received from the Panchayat, they've issued the notice. In the notice, they have not indicated about any coercive steps to be taken. Is it so?
No, they say that it will be disconnected. Page 18.
It is submitted. Page
18, last line.
They have not stated anything about the coercive steps to be taken. It is submitted that.
ತಪ್ಪಿದ್ದಲ್ಲಿ in case of they default to furnish any NOC from the Panchayat authority, thereafter we will. First they have to approach. That is the crux of that.
They submitted that. They only stated that they have to approach the Panchayat authorities. In case they fail to do so, they will take appropriate action. Land Council submits that. The petitioner, without approaching the Panchayat authorities, has come before this court, and the writ petition is liable to be dismissed. Having heard the counsel for the petitioner, the counsel on either side, there is a material on in his submissions, Honorable Apex Court has issued the direction that all necessary service connections, including electricity, water supply, and sewage, shall be given by the service provider only after the production or the completion of the occupancy certificate. In those circumstances, whenever there is any failure on the part of the parties in taking in a violation of the building condition, violation of the permission, and in other cases, the BESCOM is issuing the notice. Next, having got the councils on either side, produce the material on record. Whenever for issuance for giving a connection, for disconnection, or what is the procedure to be followed, the BESCOM is they are bound with the conditions of supply of electricity of distribution licenses, the state of Karnataka. as per the regulations, as specified by the regulations, the BESCOM will conduct their business. It is the responsibility of the local authority concerning the permissions for construction. And if there is any violation, that will be a notice, that there is a procedure contemplated under the respective acts. The submission of the land council for the petitioner that the council for the respondent that because the panchayat has issued a notice and the petitioner has not responded, hence they have given a reminder, such submission cannot be appreciated and such an action on the part of the respondents is without any jurisdiction. They absolutely have no business to deal with these kind of affairs, and that is exclusively pertain to the local authorities, and it will be taken care of by them. Land counsel for the petitioner has relied on a bench of a judgment of the coordinate bench in Nagabhushna. I think I didn't tell you the parties. Nagabhushna versus the chief executive engineer, and then in the same repetition numbers you have already noted. In case of Sri Nagabhushna refers Supra, wherein the coordinate bench has also considered the judgment of the apex court, and also at paragraph number 28, what is that? 26.8.
25.9.
At 25.9 has clearly observed that the shall be given as used in the said judgment is only a prospective application. It applies to new connections to be granted in future, not to the existing connections. In the light of the above, the respondents have no jurisdiction and authority to interfere in these kind of issues pertaining to the local authorities. In that view of the matter, this court is passing further. This court is coming across several matters wherein these kind of notices are issued by the BESCOM wherever concerning the disputes between the local authorities and the parties. It is made clear that in the light of the order in Sri Nagabhushna's case, even with regard to the Supreme Court judgment, as there is a reference, the BESCOM authorities are bound to follow the same. And hereafter, if this court comes across any cases where these kind of notices are issued and made the parties to rush to this court, the court would pass appropriate orders accordingly. The order dated so, the notice dated so and so is set aside and the writ petition is allowed. Anita, keep this with you, and this also. Yes.
Cell number 60, parted matter, Abhinav Ramanand A, petitioner,
Represent the state in the matter.
Harishchandra.
60.1. 60.1 I have not yet.
You appear.
For the petition 60.1, this is a new petition is going filed.
Writ petition. Yes, let's see the 60.1 first.
But now, a new authority, this is a development authority.
No, Mr. Senior Counsel, this writ petition is pending from 2023. Your advocate on record is getting so aggressive. He was getting so aggressive that the matter is not. I told him I'll release it from Parkhead, as if the court is doing, he's doing some favor to the court.
Informed by my learned friend. In fact, I should have joined him, but I did not. I was not aware of it. I think it should not happen. It will not happen.
No, because they have to, being a junior advocate, he has to understand the work pressure of the court. Yes. What is the prayer? Yes. What is the prayer?
It's for quashing Annexure G, which is the
Resolution passed with third respondent.
Third respondent without hearing me in my humble submission without jurisdiction.
Who is the third respondent?
Third respondent is an authority.
created in an act.
Let's see the,
Yes, my lordship sees the
please
act.
come to the cost title.
Yes, ma'am, page 4. The Ghati
Sri
Subramanya
Ghati
Temple Development
Subramanya
Board.
Temple Development Board.
This has been constituted under the Ghati Subramanya Kshetra Development Authority Act. It's a planning authority. But planning authority now gets involved and passes a resolution without hearing me. But saying I should not be distributing prasadam, which I've been doing for the last 40 years or more from my predecessor's time. And in fact, I have made a statement in the writ petition. Not the authority has been handed over the charge of the temple premises, and still not the authority chooses to pass resolutions. Despite in fact not the nominated members of the authority also not having passed a resolution saying yes, I should be allowed to continue because it's as per the customs. And not this question, not what arises for consideration, not is the rights under Article 25, 26. I am not the Paricharak of the temple, the Paricharak's family. But we have been offering prasadam to the deity every day, and then the prasadam is distributed to the public by way of sale within the temple. This has been going on for, and in fact the Agama Pandit has not given a report.
No, this temple will not have any register.
It will have a register, lords.
Then, if what is the purpose of maintaining a register is to enter everything, what are the religious, what are the procedures, who is entitled, what is that? Everything will be there in the register.
No, we have distribution of.
Has made a report already.
No, that is not Agama report.
Refer to the Pandit, not under the Act. Any question regarding any custom or not?
No, when you're saying that you're doing it from times immemorial, for that there should have been there will be a record, there will be a register maintained as per the.
According to us, my lords, there is no record. It is their own case that they were granted a license in the previous writs. Now to turn around, my lords, for a moment, I'll assume the worst case scenario. The lordship may set aside the resolution. That's all. He can go out. We can pass another resolution. He claims now hereditary trustees, hereditary right. That is what was being considered in the first matter. Let that be decided, my lords.
Yes.
After that, if the resolution goes also, we'll see. We can again pass a fresh resolution. All that I have to do. Why should that come in the
resolution has been passed now against affecting me? Not have approached the court.
It is.
If they say that the resolution is taken back, then
No. I'll pass orders because both are connected. I'll pass orders in
the first matter.
To some extent, not the questions will be overlapping. In both.
I don't think.
No, it won't overlap, lords.
No, the whole issue is only
It is entirely different.
you have the hereditary right as claimed by you, and why there were different pleadings from on these aspects, different points of time.
More as a acknowledgement of what you have been doing, more than anything else. I point out not if they have produced, we have produced what has been available. We are turning back to the ETs, Annexure A, which is their own. They cannot. This is part of the temple documents. Management. I'm sorry, you are holding up right at the end of the day.
Lords, I would request your lordships to first deal with the 23 matter. Because there is an interim order operating, people want to take that type of approach.
Yes. Well, you have that register.
No, I've asked my officers to check and tell me.
My petition not that you have to take notice and file any statement.
No.
Come to your petition, sir.
Lords,
Come to your petition.
we had completely made our submissions with regarding to the first petition. Lords, at that juncture, the counsel for the first petitioner made a submission to say that we have filed another petition in which certain other things are interlinked. If my lords recollect, the first petition is regarding to only selling of the prasada on the basis of hereditaryship, which they claimed by way of an amendment. I had pointed out to my lords to say that they had made an representation to say that they were unemployed, educated, and then they wanted it. At that juncture, my lords had directed them to file an affidavit. In that affidavit also, they had not mentioned as to whether they had made such an application or not, and what was the contents of that application. At that juncture, when my lords were hearing that, this submission was made to say that the second petition is interlinked and the contentions urged are interlinked. Now we see, my lords, it's an entirely separate petition.
Lords, hereditary rights.
On 18/5/2026, the resolution is passed for the first time. That's what we have challenged the resolution. I'm not sure why.
It doesn't matter.
For filing a writ petition now. Because there's an 18/5/2026 resolution.
So what we do is we'll deal with this 2023
petition, your lordship.
So as you say, no, If we say, if the court finds that is passed by an authority who has not even taken charge without any notice, no principles of natural justice, then in that case we can anyway set aside. But the core issue is in this.
In this, your lordship.
I'm not
Yes.
coming in the way of.
Oh, he'll
I
argue.
only found out why, my lord, I filed a writ petition and why.
No.
It's
Yes.
not
My
something.
lord, why, my lord, what is challenged, my lord, in the first writ petition? My lord, also, my lord, is a right in the second writ petition. Please see, my lord, page 54. I'm sorry, my lord, I should have, 54, 54.
Of the second writ petition.
First writ petition, my lord, 25.
23 writ petition.
23.
Listed as second case today.
Yes, my lord.
Page number?
My lord, 54 is what is challenged.
Hmm.
54.
Yes.
My lord, I'll just read the operative portion. My lord, I'm sorry, I owe an apology. I should have given the English translation. Lord, ದೊಡ್ಡಬಳ್ಳಾಪುರ ತಾಲೂಕು ಘಾಟಿ ಶ್ರೀ ಸುಬ್ರಹ್ಮಣ್ಯ ಸ್ವಾಮಿ ದೇವಸ್ಥಾನದಲ್ಲಿ ಪ್ರಸಾದ ರೂಪದಲ್ಲಿ ಭಕ್ತಾದಿಗಳು ಮಾರಾಟ ಮಾಡುತ್ತಿರುವ ಲಾಡು, ಕಲ್ಸಕ್ಕರೆ, ಪಂಚಕಜ್ಜಾಯ, ಖರ್ಜೂರ, ಸೋಣ್ಸೋ, I'll skip all those things. ಇತರೆ ವಸ್ತುಗಳು ಮಾರಾಟ ಸ್ಥಳವನ್ನು, please see my lord, it is relation to place where it is being stored. ಸ್ಥಳವನ್ನು ದೇವಾಲಯದಲ್ಲಿ ಹಾಲಿ ಮಾರಾಟ ಮಾಡುತ್ತಿರುವ ಸ್ಥಳವು ಜನಸಂದಾಣಿ ಕಾರಣವಾಗಿರುವುದರಿಂದ ಇದನ್ನು ತಕ್ಷಣದಿಂದಲೇ ಜಾರಿ ಬರುವಂತೆ ಈ ಮಾರಾಟ ಮಾಡುತ್ತಿರುವ ಶ್ರೀ ಸೋಣ್ಸೋ ದಟ್ ಈಸ್ ದಿ ಪೆಟಿಷನರ್ಸ್ ಇವರ ಮೇಲ್ಕಂಡ ಪ್ರಸಾದ ಹಾಗೂ ವಸ್ತುಗಳನ್ನು ಮಾರಾಟ ಮಾಡಲು ಬಾಡಿಗೆಗೆ ನೀಡಿರುವುದು ಗುತ್ತಿಗೆ ಅವಧಿಯನ್ನು ಮುಗಿದುದರಿಂದ so therefore they would say that the period has come to an end. ಸದರಿ ಅವರನ್ನು ಕೂಡಲೇ ಸ್ಥಳದಿಂದ ತೆರವುಗೊಳಿಸಿ ಹಾಗೂ ದೇವಾಲಯದ ಒಂದೇ ಪ್ರಾಕಾರದಲ್ಲಿ ಭಕ್ತಾದಿಗಳಿಗೆ ತೊಂದರೆ ಆಗದಂತೆ ಸೂಕ್ತ ಸ್ಥಳವನ್ನು ಗುರುತಿಸಿ ಎಲ್ಲ ಪ್ರಸಾದ ರೂಪದಲ್ಲಿ ಪದಾರ್ಥಗಳನ್ನು ದೇವಾಲಯದಿಂದ ವತಿಯಿಂದಲೇ ತಯಾರಿಸಿ ಮಾಡಬೇಕು ಅಂತ. So therefore, my lord, what this annexure H says is that the contract period has come to an end. They must not be permitted to give their prasada here. They must give it outside. And my lord, the temple must make appropriate arrangement. This has got nothing to do with my activity of stopping the prasada. Activity of stopping the sale of prasada is subsequently. If my lord, this order had the effect of stopping me from selling the prasada, my lord, they would not have passed the subsequent resolution. Now what this order says is, my lord, since the contract period is over, I should not sell at place A. I must be relocated to a place B.
No, when you're referring to hereditary,
yes,
you are having a hereditary right in respect of something.
Yes, my lord.
Before, prior to you, who were doing it?
My lord, my forefathers. Well, that is what, my lord, the resolutions would say. I have produced the resolutions.
Resolutions from when?
My lord, 1980 onwards, I have produced it, my lord. 1980 onwards, my lord will kindly see.
What is the age of this person?
My lord, age of this person, first petitioner, my lord, is 64. Second petitioner is 49.
So there is no another age. 80 means what is the age now?
My lord, 1980 onwards, my lord.
1980.
Yes,
so this person is the only one. There is no hereditary. Who is the other generation who is
My lord,
doing
earlier,
it?
my lord, earlier.
When is that?
My lord, grandfather, they were all, my lord.
No, but there should be something on that. If the grandfather
Yes, my
is
lord,
doing,
that is what, my lord. Please have a look at, my lord, along with the affidavit.
Huh.
My lord, I have produced these, my lord, resolutions.
years that I want to know.
Sorry, my lord.
Years. From which year?
My lord, 1980 is the first document, my lord.
No,
I am able, 1984, 6
Person is
months.
doing it from 1980. You cannot say
Not
that it
9
is
from 19,
hereditary.
1984 recognizes that I have been doing since time immemorial. That is the first document I have got. Lord, according to me, my lord, my forefathers were doing it right from 1950 onwards.
Then why did you give a representation?
Lord,
to
I'll
them?
tell you why, my lord. My lord, what used to happen, my lord, is in this temple, my lord, the prasada that we were offering, my lord, used to be closed as soon as the temple puja hours were over. There were a lot of, my lord, devotees who came after the, my lord, puja hours were over, and they were not getting
No,
prasada.
in these prasadams, there is nothing, none of these prasadam needs to be cooked.
My lord, some are cooked. Panchakajja, everything is cooked, my lord. There are other items, my lord, which are not cooked, but most of it is cooked, offered to God and then given. My lord, there are even, my lord, Panchamrita, my lord, is normally not cooked, my lord. 5 items are.
Prepared.
Yes, my lord. So therefore, my lord, what used to happen is, my lord, the devotee said when we are coming from far off places.
So when this temple is notified?
My lord, temple got notified under the new act, my lord. New act, my lord, came into force in 2001.
Earlier, there was a old act.
Old act. Yes.
Under the old act also, it must have been notified.
It was, my lords.
No, it was not
My
notified.
lords,
There's
the
nothing
new
like a
act of
notified
96,
institution under
in
the old act.
96, my lords, A new act came into force in Karnataka, consolidating, my lords, we had the Madras Act operating in certain places, the Bombay Act operating in, and the Mysore Act operating. So to consolidate 96, otherwise this temple has been there for generations. It is not some new temple. It is, my lords, we can't even go back to
Oh,
history.
it is categorized as which temple?
A class
A
temple.
category.
A category is on the income, my lords.
That's what, there will be A, B, C temple.
A category
That is
temple.
from
It's a A
2003
category.
onwards, my lord. Once the new act came, there was an earlier Mysore Act, my lord. 2003, my lord, the new.
It is the A temple, it will be under the
Commissioner.
control of the commissioner.
Yes, my lord, Commissioner.
Now an act has come into force, which validity nobody has questioned. The act, my lords, like how for Chamundi temple in Mysore, a new act came into force. They are bringing in acts like that for most of the major temples, my lords. Now this has come in. The Kukke Subramanya temple, it's in Anvil.
No, this is like a trust board.
Yes, my lords. It's like, it has everybody, commissioner, deputy commissioner.
That's what I'm
minister.
saying, a trust board.
Yes, my
No, it has an
lords. It will
authority.
take care of the management of the temple.
In other temples, it will not be there.
No,
Other temples have, my lords, under the scheme of the act, my lords, there is a managing committee which is appointed.
Forever.
Or no, it's a term, 3 years, 5 years, like that. Also including, there are reservations for SC, ST, like that. So these committees will perform as trustees. Wherever there are hereditary trustees, because of the validity being challenged, my lords, the state gave up the claim insofar as wherever temples had hereditary trustees, managing committees cannot be appointed. But executive officer will be there to take care of the accounts. So those are, my lords, majorly in hereditary trustees we find only in South Kannada district, which was governed under the the old Madras Act. In this part, they don't claim to be hereditary trustees. And my learned friend is representing two petitioners. If your lordships is Rangaraju and Hema. Hema is granddaughter of one Adi Narayanappa through his daughter. It's a maternal right. And strangely, Rangaraju is the brother of her husband. Now, from where hereditary rights come in? Adi Narayanappa itself was a paricharak and he was not even recognized as a hereditary paricharak. He never claimed.
So Adi Narayana's granddaughter is this Hema.
Hema, through her daughter. Adi Narayanappa's daughter.
Grandfather.
Yes. And Adi Narayanappa's two sons claimed hereditary rights. Thrice it was rejected as attained finality. By this court also. One of the matters came up to this one.
Where is that?
They have produced, the state has produced that.
The thing is, why don't you have both of you have your own compilation?
Lord, I'll also furnish the translation, my apologies.
So that it is here, from here and there.
My lords, what I will do is give
Tomorrow
a
I'll
short
take up this
synopsis with
matter
a
at
convenience compilation.
2:30.
Lord,
Please.
This matter at 2:30. Convenience compilation, I want.
Please, my lords.
One
We'll
more
do
day,
that.
my lord, day after tomorrow.
Day after
Yes.
tomorrow, 2:30, please come up with. So I will not be looking at any of these documents.
Please, my lords.
Only like your
Simple
convenience compilation from both the sides. And with all the, your matter can wait. I will take.
Normally they are being making.
No. What I do is, because whatever happens in this case, your case will follow. And even otherwise that if you want, we
If
can,
somebody
they
comes
have no
here.
objection to allow your writ petition also.
If this is decided, my lords, because an interim order is operating here.
Because some of these things overlap, that's all.
There is no overlapping.
On Monday, my lord,
Absolutely
I have a
different
Monday
issues.
Monday 2:30, my lord.
Completely two different issues.
Monday, well, because again, it should not be a piecemeal, my lord. Suppose there is some question. Monday
Monday
agam.
2:30.
Monday
And
agam.
I will not, all, any judgments you're relying on.
Yes, my lord, everything.
Any of the proceedings in advance, please serve the other side
Please,
also.
my
So that they'll get an opportunity.
Translated.
Both the parties shall make the convenient compilation, and basing on that, the court will pass orders. Court will hear the matter at 2:30 on Monday.
Yes, very great. Interim order may be extended.
Interim order in this WP 25004 is extended.
Great.
The next date of hearing.
That's one submission, my lords. Serial number 1.
No submissions, you will tell the court officer, I've instructed her what is to be done.
It's infractuous, my lord. That's the only submission.
My lord, in list number 2, serial number 39, my lord, the matter has come, but it was not teaching. Kindly be order for a list in the first list, madam, in the portions. List number 39, madam.
Who is writing in that writing without?
Fine.
In list
My
number
lords,
2, my lord, serial number
list to
39
serial
has
number
come for
30.
the 8 to 10 times, my lord. It was not reached.
ಅಷ್ಟೇ.
Sir, sir, settle ಆಗಿರೋದು ಏನ್ ಮಾಡೋದು? Settle ನಾನು ರೆಸ್ಪಾಂಡೆಂಟ್. ನಾನೇ ಮೆಮೊ ಆಗ್ತಾ ಇದ್ದೀನಿ.
ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಎಲ್ಲ ಡೇಟ್ಸ್
ಮೇಡಮ್ ಲಿಸ್ಟ್ ನಂಬರ್ 2 ಸೀರಿಯಲ್ ನಂಬರ್ 49 ನಾಳೆಗೆ ಹಾಕೋಣ. ಕೈಲಿ ಲಿಸ್ಟ್ ಟುಮಾರೋ. ಅಲ್ಲ ಬಹಳ ತೊಂದರೆ ಆಗ್ತಾ ಇದ್ರೊಳಗೆ.
Court officer serial number 4. ಹಲೋ ಸರ್. ಓ ಎಲ್ಲ ಆಗಸ್ಟ್ ಕೊಡ್ತಾ? ಬಿಡಿ ಸರ್, ಕೊಡ್ಲಿ, ಏನ್ ಮಾಡೋದು, ಯಮುನಾ ತಪ್ಪಿಸಿದ್ರೆ ಆಯ್ತು ಸರ್. ಓಕೆ.
ಹಲೋ,
ಯಾವ ಡೇಟ್ ತಗೊಂತೀರಾ?
ಗೊತ್ತಿಲ್ಲ ಸರ್, ನೀವು ಯಾವ್ದು ಹೇಳ್ತೀರಾ ಅದು.
ನೋಡಿ ನಮ್ರಲ್ಲಿ ಆಗಸ್ಟ್ ಅಲ್ಲಿ 12 ಆದ್ಮೇಲೆ ತಗೊಂತೀರಾ ಏನು ಅಂತ ನೋಡ್ರಿ ಅಷ್ಟೇ. ಓಕೆ ನಿಂತ್ಕೊಳ್ಳಿ ಅಲ್ಲೇ. ಯಾಕೆ ಇದು ನಮ್ದು ಆಫ್ ಮಾಡಿದ್ರೆ ನಾವು ಮೋಸ್ಟ್ಲಿ.
Court officer. Court officer.
ಹೇಳಿ ಸರ್. ಸರ್ ಹೇಳಿ.
Madam, list number 2, serial number 10.
ಒಂದು ನಿಮಿಷ. Cell number 10, 28, sir. 28. Date is assigned on 28.
28, madam.
28ಕ್ಕೆ.
28. 20.
28.
ಆಯ್ತು.